la commémoration de la dignité des victimes du crime de génocide et la prévention de ce crime. Mesdames, Messieurs, tout au long de cette journée, nous passerons au crible les diverses violations des droits fondamentaux dans la région MENA. Les systèmes internationaux et nationaux de protection, de prévention et de punition du crime de génocide, ainsi que les imperfections de ces systèmes. Mais ce que je souhaite vivement en cette journée de mémoire et d'hommage aux victimes des différents génocides perpétrés de par le monde, c'est d'enclencher une réflexion et une prise de conscience des dangers qui guettent notre planète en ce début du XXIe siècle. Mesdames, Messieurs, la gouvernance du monde de demain ne peut être la même que celle d'hier, dont nous avons tous vu et palpé les limites. Un ordre nouveau doit nécessairement régner au plus tôt. Un ordre nouveau basé sur une solidarité entre les nations et une véritable culture de paix, de tolérance, de dialogue et d'ouverture. Un ordre nouveau où l'entraide devra remplacer l'intérêt et où toutes les forces actives de par le monde devront avoir une seule et même devise, à savoir aimer et servir. C'est cette unique vision d'un monde meilleur qui devrait être le leitmotiv de l'Organisation des Nations Unies et des grandes puissances qui nous gouvernent. En fait, ils n'ont pas le choix. Ils ne peuvent se permettre d'échouer dans cette mission. Je vous remercie.
شكراً. المحور الأول أو الجلسة الأولى في هذا المؤتمر يتناول منطقة الشرق الأوسط وشمال أفريقيا وانتهاكات فظيعة لحقوق الإنسان. وقائع من الماضي، دراسات حالات، النجاحات والإخفاقات. إنها إضاءة شاملة تجمع الدكتور رالف هاسفيلد من بوتسدام ألمانيا الذي سيتحدث عن مرحلة ما قبل العام 1948. أما المرحلة بعد هذا التاريخ فيعرضها الدكتور أنطوان سفير الأستاذ في جامعة الأمريكية في بيروت، وسيتطرق إلى المجريات بموجب قانون حقوق الإنسان والقانون الجنائي الدولي والقانون الدولي. ويتحدث الدكتور نيدال جردي من مكتب المفوضية الأمم المتحدة لحقوق الإنسان وأستاذ الجامعة الأمريكية عن الواقع الراهن مقدما دراسات حالات من العراق وسوريا. I would like to invite you, Dr. Ralph Hosfeld, Dr. Jourdier. I think it's easier for you if you take it from there. We shall start the panel with you, Dr. Hosfeld.
May I begin?
Yes, please.
So, thank you very much, and thank you for inviting me. This is a great honor for me to be here. It's a very important conference, and I will begin with some historical memories. Mostly we deal with aspects of law and international law and present problems, but I will go back to what the American diplomat and historian George F. Kennan has once said was the seminal catastrophe of the 20th century, which was the First World War, and one can say within the First World War something of the most seminal catastrophes was the Armenian Genocide. For us in Europe and especially in Germany, this beginning of the commemoration of the First World War, which started in 2015, brought us back to a time which had been almost, in popular memory, more or less forgotten and overshadowed by the Second World War. But this had also the consequence that we have been looking in a world where our views are more global than they have been before to what we in former time has seen as the peripheries. And this is the Middle East region, and in especially the Armenian genocide, in what I'm talking about this morning. So looking back on the commemoration of the centennial of the Armenian genocide on 24th April 2015, the records show that the debate concerning the recognition to be rooted in a much more thorough standard of knowledge as compared with only 10 years ago when we had the 19th annual remembering. The issue in the public discussion in Europe and mainly also in the German public debate is no longer whether genocide occurred, but rather in what form it was committed and under whose authority and what was its causes. As you well know, the German Parliament, the Bundestag, has passed a resolution for the recognition of the Armenian genocide this year, followed by clear words of the President of the Republic last year already, and also the President of the German Parliament saying what happened in the Ottoman Empire was clearly a genocide. And maybe just adding this, that the information that the German Parliament will also pass a resolution concerning the genocide of the Hereros committed by German militaries in 1906 next year. Reconciliation needs truth. On the other side, as the US-based Turkish sociologist Fatma Müge Göçek from the University of Michigan in Ann Arbor has put it in one of her last books, denial of state violence can easily lead to a continuation of violence, and I believe that is something what we can see today in Turkey in a way. If we want to look into a more and peaceful democratic future, we must have a trusted picture of our past. And as to the Armenian genocide, we must learn to see it as part of the dark sides of a shared European and Middle East history and of the ongoing violent consequences of the dissolution of the Ottoman Empire. The Armenian genocide of 1915-16, which commenced in the spring of 1915 with the systematic expulsion measures, is extraordinarily well documented, and the records are very precise. The last 20 years saw extensive historical research conducted on the analysis of various Ottoman as well as Armenian sources, and beyond these, other important documents were supplied by American observers of the event, by missionaries and employees of international relief organizations, but especially by German and Austro-Hungarian observers whose countries were allies of the Ottoman Empire during the First World War. Only the latter sees in painting a picture that is not merely decisive, but also covers a broad spectrum and is astonishingly detailed. And it is really thousands of documents, which we only can find, for example, in the archives of the German Foreign Office, not counting the archives, military archives, and the archives of relief organizations and others. Events into a broader past perspective of the events that unfolded in the Ottoman Empire in 1915-16 amounted the beginning of an entire century of violence, atrocities, a century that was marked by genocide and forced ethnic displacements of proportions that had hitherto been unimaginable. Civilians had been targets of warfare from the outset of this war in 1914. In Europe, it had started in August with the so-called Belgian atrocities, when thousands of civilians fell victim to the German paranoia of an alleged ambushes of so-called franc-tireurs. And later plans were devised by German officials to permanently remove the Polish border population by force in order to implant a so-called racial military border against the Russians, even though those were never put into action and were something foreshadowing what happened in the Second World War. The Habsburg Empire practiced violence against its own civilians and Serbs from fall 1914 on, and in Russia, great numbers of civilians fell victim to a military policy of deportation, among them hundreds of thousands of Jews, German minorities, inhabitants of the Baltic territories, Roma, and Muslims from the Caucasus and Central Asia. They were universally deemed potential enemies within and unreliable as sections of the populace. The First World War, according to historian Wolfgang J. Mommsen, was on all fronts borderline in terms of violence against civilians, and as he said, a phenomenon of transition in that way. But roughly speaking, a strict distinction was still in place between deportations as military security measures and genocide, which is an extreme concept of radical domestic population policy. And that is what we have to keep in mind when we speak of genocide in the case of the Armenians and other Christian minorities in the Ottoman Empire. The German ambassador in Istanbul, Hans von Wangenheim, became aware of this difference only on 7th June 1915, when he wrote to the Imperial Chancellor Bethmann Hollweg in Berlin that it had now become evident by the vast amount of information from the Anatolian interior he had received until then, that literally the banishment of the Armenians is not entirely motivated by military considerations. Some days before this, Ottoman Minister of the Interior, Mehmet Talat, had openly expressed towards the German Consul General Mottmann his government's intention to use the World War for its own political gain. To quote him literally, without diplomatic interference from abroad, it would be easily to thoroughly clean house concerning enemies within domestic Christians of any confession. What Talat announced was very different from a deportation caused by a so-called military necessities of war. His was the announcement of a new and essentially Turkish post-war order, not achievable merely through deportations of domestic enemies temporarily, but only by dispersing them completely and thereby eliminating their influence once and for all. There had never been an announcement like this before in history. In contrast to the Russian and Habsburg deportation policies, which were ruthless and inhumane in their own right, Talat's vision encompassed an outright apocalyptic aspect. This contrast, however, is, in my mind, highly significant to understand the events. Henry Morgenthau, the American ambassador in Istanbul, harbored suspicions of the ultimate goal of the policy against the Armenians being literally race extermination. Based on precise information contained in reports he had received from all parts of the country, Ambassador Hans von Wangenheim cabled to Berlin on 7th July 1915 that it could be no doubt about literally the government's actual intention to eradicate the Armenian race from the Turkish Empire, and I underline the word intention. I mean, this is what has been said by a Turkish ally, and you can be sure that he didn't make it easy for himself to give a judgment like that. It was the intention of the government to eradicate the Armenian race from the Turkish Empire. He couldn't have made a more definite statement. Deportations and massacres of increasing intensity that could be observed in the Anatolian provinces since the spring served to the express purpose of systematically handing an ethnic group, the Ottoman Armenians and other Christians, over to destruction. So Wangenheim's words prove that the German government was aware of this at least by early July 1915. And as I always said in the public debate in the last years in Germany, this is government knowledge since 100 years in my country. And this is clearly, in today's words, one could label a genocide, even if the exact definition of genocide is not older than the Genocide Convention of the United Nations from the late 1940s. Documents from German archives, as I said, give multiple evidence to underline this judgment. To give an example, on 16th March 1915, the German consul Paul Schwarz had in Harput, Central Anatolia, a conversation with local governor Sabit Bey, in the course of which he was asked to take note to that, literally, quoting, the Armenians in Turkey needed to be destroyed and that they would be destroyed. Their wealth, as well as their numbers, had grown to a magnitude turning them into a threat against the ruling Turkish race, and the only effective way of handling this would be extermination. This is a literary quotation of Sabit Bey, the governor of Harput. What is remarkable about this encounter is its timing, before it precisely marks the beginning of a severe radicalization of policies towards the Ottoman Armenians that only recently had been put on the agenda in Istanbul, the empire's capital. This had been brought about by a paranoid way of dealing with a military defeat. The winter of 1914-15 saw, accompanied by enormous losses, the catastrophic failure of a campaign in the Russian Caucasus that had been motivated by ambitious dreams of territorial expansion. The defeat was thorough, in dramatic contrast to lofty expectations of liberating the Turkic peoples of Central Asia from the Russian yoke. They reinforced all the old stereotypes of Ottoman decline, so much that speaking of it in public was outlawed under threat of severe punishment. Even though there were over 200,000 Armenians enlisted and fighting in the Ottoman army, and despite Armenian soldiers being among those returning defeated in January, it was among them where the hunt for those responsible for the disaster began. Thus was conceived an Armenian backstabbing myth, as historian Ronald Grigor Suni put it, the pathological assumption that an entire ethnic group could collectively pose a threat to state authority. Within the following month, the Ottoman Empire's elites would develop this into a full-blown paranoid vision of a directly imminent all-Armenian insurrection in Anatolia. However, viewed through the Young Turks' ever-increasing nationalist eyes, the Armenians did not just pose an immediately military threat against the front in the Caucasus. Independently and quite generally, they were a fundamental menace to the dominance of ethnic Turks on account of their cultural capabilities, their capacity of organization, and their economic success. According to the worldview of radical Young Turks, the Armenians were, and now I quote Mehmet Rejid, the governor of Diyarbakir, literally a bunch of deleterious microbes which had infested the homeland's body. Over the course of modern history, such medical resentments, as the Polish Jewish sausages and Holocaust researcher Zygmunt Bauman has put it, always firmly anchored in the vision of a harmonious grand design of national health, and they always led to highly volatile and potential genocidal fantasies of conflict resolution. In the early days of the First World War, the leading elites of the Ottoman Empire were strongly motivated by ideological concepts of this kind. Moreover, since the Balkan Wars, their mental state had been one of a permanent emergency. Another factor was the following one. The first ideologically driven one-party Dictatorship in modern history was in fact established through a coup d'etat staged by the Young Turk Committee for Unity and Progress in 1913. And the direct consequences of this were a militarization and ideological Turkization of public life. Was this inevitable? As a historian, I would say in political conflicts, states, their leaders and institutions always have a choice. Two courses were open to the Young Turks, wrote the German Jewish historian Hans Kohn already in the 1920s. They could transform Turkey into a decentralized state of composite nationality, offering to its various peoples a free autonomy and the opportunity of fulfilling their national aspirations, or they could attempt to subdue the other people by force and so erect a predominantly Turkish empire. The Young Turks choose the second solution. And in the case of the Armenians, they aim more and more to what one might call a final solution of the so-called Oriental question. One can observe many parallels to the genocidal policies of the German Nazis 25 years later, which derived from a deep similarity of the two projects. One is the above-mentioned aim of a final solution regarding so-called interior enemies. Others are linked to the hybrid structures and the ideology of the institutions of the party and the state. The decisive bodies of the Young Turks' genocidal policies were the Interior Ministry, its departments for population planning, political planning, as well as its police forces, and essentially the hybrid institutions of the Young Turks' deep state. Through its party journals, the Committee for Union and Progress thus coordinated a process of what the Germans call Gleichschaltung, to be translated into something like enforced political conformity. A rather specific role was afforded by the so-called Teşkilat-i Mahsusa, a party-attached organization of paramilitary special forces operating qua politicized for security service in a gray area beyond the state authorities, yet receiving its orders from the interior minister. So these hybrid organizations you can find also in Nazi Germany, that you never know if is it the party, is the state, or is it both, mostly it's the party behind the state. They methodologically organized massacres, the methodologically organized massacres on a great scale and on specific killing fields from the upper Euphrates to the Syrian desert in the years from 1915 and to 1916. By the late winter month of early 1915, TM had reached a staff size of 30,000, led by 700 political conscripts from among the ruling Young Turk Committee. This is numbers we know, but in the summer 1915, there were probably much more. We have no exact numbers of that. These polities were part of what one might call a nationalist social revolution, which resulted in the enforced expropriation of more than 1 million Armenian citizens. In the Paris peace talks of 1919-20, the assets involved were estimated to have been worth 7.9 million francs by 1919 rates. As the young Turkish writer Halide put it in her memory, the strategic motive was to break the Armenians' economic balance with the aim of raising a national Turkish bourgeoisie to replace them. Besides contributing to financing the war effort, the expropriations amounted to something like a regional Turkish accumulation of capital in support of this goal. For the National Socialists, their racist worldview, this served as something like a role model, as historian Stefan Ihrig has found out by studying their press in the early 1920s. Literary, gentle measures, one could, for example, read in the Nazi magazine Heimatland, translated Homeland in 1921, will not do in such cases, like the bloodsuckers and parasites on the Turkish national body, the Armenians. And Adolf Hitler himself admired the Young Turks as an example to follow when he referred to Enver Pasha in his trial before the Munich People's Court in 1924. According to Hitler, Enver managed to build up a whole new nation, successfully detoxifying the multicultural Gomorrah that was Constantinople. He had some free interpretation of history always. But the key was that this unveiled a deep congruency of fundamental imaginations of racial purification. So one can say Hitler's awakening Germany, welcomed the radically nationalist Young Turks as a congenial example to follow. After the World War, the question was raised for the first time whether it be necessary to institute an international legislation, especially to handle gross violations of human rights at the hand of governments. On 15th March 1921, former Ottoman Grand Vizier Mehmet Talat, as you will all know, was shot dead by the young Armenian Soghomon Tehlirian in Berlin's Hardenbergstrasse. This assassination made history, and notably legal history. The June 21 court case of Tehlirian and its public reception had, albeit inadvertently, all the markings of an early genocide tribunal, especially the formal structure of a criminal trial necessitated a substantial assessment of the accused motives. The latter, by the way, was ultimately acquitted on grounds of temporary insanity. In a sense, the perpetrator's motives and ipso facto, the deeds of the victim, took precedence over the actual crime. In fact, the trial unearthed several new aspects. One of Tehlirian's three defenders, Attorney Wartauer, scrutinized the perversions of nationalist militarism. He thereby raised the question of boundaries of legitimate violence in war against the backdrop of an existing cause that had arisen from the Hague Conventions in 1899 and 1907. His colleague Niemeyer, on the other hand, went in some general words one step further, calling literally for jurisdiction in the sense of universal and enlightened insight into the nature of law as well as duties of humanity. Thus, a component of natural law theory was introduced into a criminal trial by augmenting along a moral political line there. This was unusual and amounted into an implicit demand for substantial legislative consequences in the future. Apparently, after this major crime, the Armenian genocide, during the First World War, time was meant to right for this major step concerning crimes against humanity. And by the way, as regards of the matter of verdict, the court had previously been informed that the murder victim, Mehmet Talat, had actually been sentenced to death in Istanbul. A ruling to this effect had been handed down in absentia by a Turkish court martial in Istanbul on 5th July 1919, in fact, on grounds of literary crimes against humanity. This is also important to keep in mind, that this was a Turkish tribunal which sentenced these people to death altogether, 17 sentences. Most of them were spoken out in absentia because they were in other countries. The Berlin trial brought about some unexpected far-reaching consequences, one was related to Rabbi Lemkin. And not to quote Lemkin himself, will not passion sway such a form of justice and make a travesty out of it? He asked in his autobiographical sketches, after having read about the case in 1921 newspapers. Quotation, I felt that a law against this type of racial or religious murder must be adopted by the world. Sovereignty, I argued, cannot be conceived as the right to kill millions of innocent people. The consequences of this train of thought was first to attempt a legally sound definition of the concept of genocide in 1944. He succeeded in introducing the United Nations Genocide Convention of 1948. And even after World War II, the genocide of the Jews, the Shoah, which 49 persons of his own family fell victim, he revisited his initial experience again and again, that memorable Berlin trial of 1921, the Armenian genocide, and the fundamental defects of international law which it had revealed. Thank you.
Thank you, Dr. Hosfeld. And now, just prior to transitioning to the era of 1948, I would like to introduce Dr. Carmen Wahassoun Abu Jawdi, political scientist, research editor of studies for the Arab modern world at University St. Joseph, former head of Lebanon office at the International Center for Transitional Justice, to moderate this panel. And I would like also to invite Dr. Antoine Sfer to join the panel. Thank you.
رح أحكي معكم بالعربي ورح أدير الجلسة باللغة العربية. أنا بعتذر أول شيء عن التأخير، بفتكر عجلة السير لازم نضمها لانتهاكات حقوق الإنسان بلبنان، بس استمعت لكل الكلمة اللي قالها المؤرخ. بحب أحط شوي الجلسة بإطارها العام أو سياقها كمان التاريخي. مثل ما بتشوفوا بالعنوان عم نحكي عن انتهاكات جسيمة لحقوق الإنسان وليس فقط الإبادات الجماعية. مهم كمان هيدا نشدد على هذا الموضوع، لأنه مثل ما بتعرفوا الإبادة الجماعية في عندها تحديد معين، ورح نسمع أكثر من الدكتور أنطوان صفير عن شو تحديد الإبادة الجماعية. بس هي كمان المحور بيتخطى ويعني بيزيد على فكرة الإبادة الجماعية، هي انتهاكات الجسيمة لحقوق الإنسان. هلا بحسب العنوان مثل ما بتشوفوا هي عن حقائق أو وقائع من الماضي، وعن دراسات لحالات معينة، عن حالات فيها فشل وفيها نجاح. أنا بحب يعني كمان نشوف إذا فينا نحكي بالعالم العربي عن نجاح بهيدا الموضوع مع كل المآسي اللي عم نشوفها. هلا انقسمنا مثل ما شفنا، حكينا يعني استمعنا للدكتور هولف عن موضوع الإبادة الجماعية في أرمينيا، وهي انحطت بحسب زمنيا قبل 48 1948. طبعا 1948 نعرف أنه كان إعلان شرعة أو إعلان العالمي لحقوق الإنسان يلي صار ب 10 ديسمبر. نحن كمان بالوجدان. نعم اتفاقية تبني الاتفاقية وكمان بالإضافة لهذا الشيء نحن بالنسبة لنا كمان 48 عندها كمان رمزية أخرى يلي هي مثل ما بتعرفوا النكبة الفلسطينية. بس طبعا هون ما كان القصد، بس بحس إنه مهم نشير لهذا الموضوع يلي كمان كان فيها انتهاكات جسيمة لحقوق الإنسان. طبعا لما بنحكي قبل 48 مثل ما نذكر بنحكي عن المحرقة اليهودية، بنحكي عن ملايين الضحايا لانتهاكات اللي صارت بأوروبا. وهالإعلان إجا بفكرة أنه الدول قررت أنه لا يسمح لهالانتهاكات تتكرر من بعد الفظايع اللي شفناها بالحرب العالمية الثانية، وطبعا الحرب الأولى بشكل أساسي الإبادة الأرمنية، بس مش هيدا كان بشكل أساسي الفكرة ولا الإعلان. فرح نستمع طبعا من اثنين خبيرين بالقانون الدولي. رح حكينا عن حالات، يعني أول شيء على مفهوم الإبادة الجماعية ويعطينا كم مثل. معي المحامي الدكتور أنطوان صفير يلي هو أستاذ محاضر في القانون الدولي في الجامعة الأمريكية ببيروت، نال الدكتوراه بالقانون الدولي من جامعة باريس ديكارت، أطروحته عن تطور مفاهيم الإرهاب. مستشار قانوني سابقا لدى رئاسة الجمهورية، كتب مقالات عديدة حول القانون الدولي والدستوري، ونشر عدد منها عام 2015 في كتاب حتى تعود الجمهورية. معروف، وجه كمان إعلامي معروف ومستشار بحبوه صحفية. تفضل، عندك 15 دقيقة.
شكرا. سعادة النائب، حضرة رئيس مجلس شورى الدولة، سعادة السفير، حضرة رئيس المؤسسة، مش منيح الصوت، حضرة ممثل مفوضية حقوق الإنسان، ممثل نقيب المحامين في بيروت، السيدات والسادة، حقيقة يوم نعتلي منبر الجامعة الأمريكية في بيروت لنتحدث عن قضايا، فهذه القضايا بحد ذاتها تصبح ذات منحى دولي ولها كل الجدية لكي تطرح في المنابر الدولية لكي ندافع عن المعتقدات التي نعتقد بها، خصوصا في العالم الحقوقي الذي يعاني اليوم ما يعانيه جراء السياسة التي نعيشها في العالم. نبدأ أولا بتحديد الإبادة الجماعية، وسأحاول أن أكون غير نظري لأن الموضوع يحتمل الكثير من النظريات. في الواقع إذا بدنا نعمل نوع من اختصار للموضوع، نقول أن الإبادة الجماعية هي فعل محدد، وبالتالي لا يجوز أن نجتهد فيها نشوف إذا هيدي إبادة أو مش إبادة. هي فعل محدد يبغي القتل وإلحاق الأذى الجسدي وغيره. طبعا عن نية هي لماذا أقوم بهذا العمل؟ أقوم بهذا العمل على أساس نية التدمير الكلي أو الجزئي لجماعة. هذه الجماعة إما جماعة دينية أو قومية أو إثنية. احنا بنزيد اليوم حتى إذا الاتفاقية منع الإبادة ومعاقبة مرتكبيها لم تتحدث عنها، الجماعة السياسية والفكرية والثقافية، لأنه كمان في إلحاق أذى بمن يعتقد بمعتقد معين في السياسة دون أن يكون له ارتباط قومي أو ديني أو إثني. أما مفهوم conception هي جريمة خطيرة. ليش خطيرة؟ لأنها تنال من جماعة قائمة مترسخة إما في أرضها أو في معتقدها، وبالتالي يوم يكون القانون الدولي مواجها لأي خطر يواجه الأمن والسلام العالميين حسب ميثاق الأمم المتحدة وما يقوم به مجلس الأمن في هذا الاتجاه، أعتقد أن الموضوع يصبح بدرجة من الخطورة يوم نرى شعبا قد ما يكون عدده بغض النظر عن العدد عم بينشال من أرضه بسبب أن هنالك نية جرمية باقتلاعه إما جزئيا وإما كليا. هي جريمة دولية طبعا، وإن حصلت على أرض معينة حتى بين أهل البلاد أنفسهم. ليه؟ لأنها تمس الأمن والسلام العالميين وتعرض التوازن الدولي للخطر. لأن ما يحصل اليوم في هذه الدولة أو ضد هذا المجتمع أو ضد هذه الجماعة سيحصل غدا في منطقة أخرى ضد دولة أخرى أو جماعة أخرى، ربما بظروف أقسى، لأنه للأسف عم نشوف مع تطور الأيام عم تتطور مفاهيم الإجرام بدل أن تعود إلى الوراء. هي جريمة عابرة للحدود، ترانسناشونال. ليش؟ لأنه القرار عم بيكون مطرح والتنفيذ مطرح آخر، لأنه ببعض الأحيان في مرتزقة يأتون من هنا ومن هناك ليقتلوا شعبا في دولة معينة مستفيدين من نزاع معين. هذا ما حصل في العراق، هذا ما يحصل في سوريا، هذا ما يحصل في ليبيا. يعني هيدي بالأمثلة اللي عم نعيشها بعالمنا المعاصر اليوم. عم نشوف إنه في ناس عم تقتل ناس ليس لسبب، إنما لنية جرمية باقتلاع هذه المجموعة أو تلك، تحقيقا لترانسفير معين أو لمخطط معين أو لمعتقدات خطرة يعتقد بها الإنسان. إنها جريمة لا مركزية القرار، لأنه الإرهاب، الخطر بالإرهاب بعد 11 أيلول 2001 هي أنه الإرهاب لم يعد إرهاب تمارسه دولة معينة أو تسيره دولة معينة، بل أضحى لا مركزيا في قراره وفي أنشطته، ولا مركزيا ولا مركزيا في أهدافه، لأنه هدف الإرهاب هنا يكمن في خط معين وهناك في خط آخر. أما شروط الإبادة الجماعية لكي لا ندخل في الكثير من الحيثيات حددتهم المادة الثانية من اتفاقية منع جريمة الإبادة الجماعية التي اعتمدت سنة 1948. أؤكد أنه تزامنا مع قيام الأمم المتحدة سنة 45 ومع إقرار الإعلان العالمي لحقوق الإنسان، لأنه لا يجوز أن ندخل في سياق الاعتراف بالحقوق الأساسية للإنسان إلا يوم نكرس شرائع شبيهة بتلك التي تتعلق بمنع جريمة الإبادة، طبعا مع أن الاتفاقية اليوم بحاجة إلى تطوير وإلى تحديث وإلى عصرنا مع كل الأمثلة التي نعيشها. ماذا تعني الإبادة الجماعية؟ تعني قتل، بس كيف القتل؟ الميكانيزم قتل أعضاء ناس، الحاق أذى جسدي أو روحي أو فكري خطير، إخضاع الجماعة عمدا لظروف معيشية بهدف تدميرها، بهدف تهجيرها، كما حصل في الحصار على العراق والحصار على غزة وسواها. ليه؟ لأنك بتعيش ناس بنوع من الترهيب الفكري على أساس أنه ما بقى يقدروا يقتاتوا، وبالتالي أنهم يعيشون إبادة. مش ضروري إبادة تكون إبادة القتل، وهي شبيهة بموضوع الإرهاب الذي نسميه إرهابا نفسيا. أو حتى دخلوا بالتفاصيل، فرض تدابير تستهدف الحقول دون إنجاب الأطفال، وهذه عملية خطيرة ضد كل الشرائع الدولية، لأن هذا الحق هو حق يتعلق بكرامة الإنسان. نقل الأطفال، هذا ما يحصل عنوة من مجتمع إلى آخر، يعني عم بتغير هوية الشخص اللي ممكن تكون راسخة بذهنه وإن كان بعمر صغير. إذا بدنا نحكي عن الركن المادي، يعني الشيء الماتيريال، عن شو عم نحكي؟ ليش في جريمة منسميها إبادة ما منسميها قتل عمدي أو قتل قصدي أو مجازر كما نسمع؟ لأنه مش كل مجزرة هي إبادة، بينما كل إبادة هي مجزرة. يعني هون تختلف التعريفات والتحديدات. أي فعل من الأفعال حطيناهم: القتل، فعل القتل، فعل إلحاق الضرر، فعل فرض تدابير تستهدف منع الإنجاب، فعل نقل الأطفال. أما الركن المعنوي فهو الرغبة، يعني النية الجرمية. السبب ما في إبادة فقط، مثل ما بنسمع ببعض الأحيان إنه هيدي ما حصلت إبادة، هيدا حصل قتل على هامش حرب معينة، على هامش نزاع معين، على هامش نزاع معين يقتل هذا وذاك ربما، بس مش على هامش حرب معينة أو نزاع مسلح يقتل شعب، أو بيصير فيه مجازر جماعية، أو بيصير فيه مقابر جماعية إثنية أو طائفية أو مذهبية أو سياسية. فهذا يعني أن هنالك ركن معنوي، أي النية الكامنة في ضرب بنية الجماعة القائمة، قومية كانت أم سياسية. طبعا ما في إبادة فقط بوجه الإنسان كشخص أو كجماعة إلا ما يكون في استهداف. الاستهداف هذا رأيناه جليا فيما حصل مؤخرا في العراق، بمعنى أنه يوم يكون هنالك جماعات إرهابية تقوم باستهداف جماعات قائمة ومترسخة تاريخيا في أرضها اليزيديين والمسيحيين، وربما أيضا بعض المسلمين من تركمان وغيرهم، هذا بيأكد أن الإرهاب لا دين له، أن الإرهاب لا دين له. وهذا بيأكد كمان عبر الأدلة والإثباتات، لأنه اليوم تعرفوا محكمة الجنائية الدولية اليوم لم تتحرك بعد بموضوع العراق بالشكل المنتظر. ليه؟ لأنه طبعا العدالة الدولية دائما عدالة متأخرة، عدالة متأخرة، على أساس أنه في معتقد، أنا دائما بقوله للطلاب بالجامعة، أنه العدالة الدولية هي مفهوم حتى الساعة أكثر منها نتيجة. لأنه نشوف مثلا بقصة يوغوسلافيا السابقة أصبح بكل حاكم يريد أن يقتل هذا وذاك بمؤخرة راسه أنه يمكن يوصل وقت يكون في عدالة دولية، بس العدالة الدولية عطيت دليفري لليوم بالشكل اللي يشفي الغليل؟ للأسف لا، لأنه الانترناشنال بوليتكس بعد أقوى بكتير من الانترناشنال لو. طبعا في شهادات، هذا الشيء الحسي، على أساس أنه في ناس نجيت من المجازر، نجيت من الإبادة وخبرت، وبالتالي هذه ستكون جزءا أساسيا من التحقيقات التي سترتكز عليها المحكمة الجنائية الدولية ولو بعد حين، لكي تؤكد على ثبوت هذه الأحداث والوقائع بالأدلة الثابتة. وأبرز دليل هي أنه في ناس عطيت شهادات في العراق، عطيت شهادات مش شهادات حكي، شهادات بأجسادها، يعني في علامات معينة التعذيب تؤكد على أن من قام بهذه الإبادة وكيف قام وما كانت نيته. هلأ نقدر نقول أنه اليوم بالعصر الحديث، أنه أنا البرزنتيشن هي بعد 48، خلينا نقول بالعصر الحديث ما يحصل في العراق هو من أكبر جرائم الإبادة التي تحصل في عصرنا الحديث، وربما في مناطق أخرى بس بعد ما بينت، بس عم نشوف من حيث الحجم والكم. أما القانون الدولي فهو ينظر إلى ما يجري ربما بترقب، لأنه الدوكيومنتس موجودين، بس من يطبق هذه الإعلانات والتشريعات والوثائق والنظم والقرارات الدولية؟ أنا بس بعطي مثل قديش تطور القانون الدولي. يوم اجتاحت إسرائيل جنوب لبنان صدر القرار 425 سنة 78. اليوم نحن صرنا بالقرارات بال2300 وشوي، وبالتالي القانون الدولي ب30 سنة صار ضرب 4 من ناحية كمية القرارات الصادرة في مواضيع معينة. يعني ما في قصور بالنصوص، في قصور بتطبيق هذه النصوص وكيفية تطبيقها والميكانيزم المعتمد والشفافية. طبعا في عنا الإعلان العالمي. ليش حطيته قبل ميثاق الأمم المتحدة؟ لأنه الإعلان العالمي موضوع الإبادة يأتي في سياق الإعلان العالمي. وقت اللي بتحكي عن كرامة الإنسان معناتها أنت عم بتشوف أنه موضوع الإبادة يمس هذه الكرامة فردية أو جماعية، بصير في نوع من تصنيف بهذا الموضوع. أما الميثاق فأهم ما فيه لناحية حقوق الإنسان أنه لا يقول نحن حكومات الأمم المتحدة، بل نحن شعوب الأمم المتحدة. وبالتالي يوم نصل إلى موضوع الإبادة، فالإبادة هي ضد شعب وليست ضد شخص. وليست ضد دولة، وليست ضد نظام، مجموعة قائمة بين الناس. أما الاتفاقية الدولية لمنع وتجريم ومعاقبة مرتكبي الإبادة فهي اتفاقية نحن بنسميها اتفاقية إطار، لأن وراها لازم يجي اتفاقيات أخرى، ولازم يكون في نظم قانونية وضعية في كل دولة تتحدث عن هذا الموضوع بإسهاب وتعاقب من يقوم بهذه الأعمال. أما القانون الدولي الإنساني، في الحقيقة لم ترد كلمة أو مصطلح الإبادة الجماعية في أي من اتفاقيات جنيف وفي البروتوكولين الإضافية، هذا ما ورد بالاسم. إنما يوم نصنف جريمة الإبادة فهذا بالطبيعي أنه يكون في انتهاك لاتفاقية جنيف دون ما تسميها، لأنه موضوع الإبادة يتعلق بالقانون الدولي الإنساني كمفهوم قبل أن يكون نص معتمد ومقر وموجود. وبالتالي نطلع أنه ما فينا نفصل موضوع جريمة الإبادة عن جرائم الحرب. الجريمة الإبادة في بعض الأحيان، مش كل الأحيان، في بعض الأحيان تكون على هامش جرائم الحرب أو في صلبها. هذا اللي عم نشوفه بمحيطنا، رغم أنه القانون الدولي الإنساني يقوم في زمن الحرب وفي أزمنة السلم، لأنه كمان في حق بهذا الموضوع يدافع عن القانون الدولي الإنساني. أما المحاكم المختصة هون في مشاكل. المبدأ يبقى حتى الساعة هو صلاحية المحاكم الوطنية في ملاحقة مرتكبي هذه الأفعال على الأراضي المعينة. المبدأ بعده لليوم، حتى لو في تقدم للقانون الدولي بموضوع المحاكمات ذات الطابع الدولي أو الدولية. وبالتالي يوم نذهب إلى المحاكم الدولية، لأنه في قصور بالمحاكم الوطنية، إما في صلاحيتها إما في الإمكانية العملانية لوضع يدها على الموضوع، عدم قدرتها إما اللوجستية إما الأمنية إما لظرف معين. إذن في قصور بهذا الموضوع، فتصبح المحاكم الدولية هنا صالحة. ليه؟ لأنه ليس المهم من يكون صاحب الصلاحية، المهم أن الأفعال التي ارتكبت هي تحت طائلة القانون الدولي وإن لاحقتها محاكم وطنية. مش المهم من بلاحقها، المهم أن نصل إلى نتيجة تؤكد أن هذه الأفعال الخطيرة معاقب عليها، وقد تمت معاقبة هؤلاء الأشخاص، كما مثل ما بنسميها باللغة العامية أن مودر الموضوع، مثل بعض الملفات اللي بنشوفها عندنا هون بلبنان بتقوم بالإعلام وبعدين تحال على المحاكم. بعتذر حضرة الرئيس وياخد هيك ياخد راحة شوي. يوغوسلافيا السابقة أصدر مجلس الأمن القرار رقم 808، كمان أنشأ محكمة دولية من أجل مقاضاة الأشخاص بموضوع القانون الدولي الإنساني، وطبعا من ضمنهم جريمة إبادة الأجناس، هذه كانت مصطلح جديد. أما برواندا كمان اقتبسوا من يوغوسلافيا. هلأ بلش في تسليم، المحاكم الوطنية بلشت عم بتسلم الدول، لأنه تعرفوا أنه المحكمة الجنائية الدولية اليوم أصبحت صاحبة صلاحية أساسية في القضاء الدولي، وبالتالي المحاكم الخاصة بدها تبلش يعني تنحسر بهذا الاتجاه، إما مع توسيع نظام محكمة روما إما مع اعتماد آليات جديدة. أما المسؤولين عن الإبادة فهي إما الإبادة الفعلية إما الاشتراك إما التحريض إما التخطيط، أو اليوم في شيء زيادة منه موجود بالاتفاقية هو تمويل. من هنا توسع القانون المالي الدولي يتحدث بشكل مسهب القانون الأمريكي والأوروبي والأمم المتحدة طبعا بالقرارات الدولية 2253 و54 عن تجفيف منابع الإرهاب وبالتالي تجفيف منابع من يقوم بأعمال الإبادة. يعني الممول يحاكم كأنه مشترك. أما النماذج لجرائم الإبادة الجماعية، تحدثنا عن العراق. بيوغوسلافيا مثلا صار الإبادة 1000 شخص بفترة معينة، فترة بسيطة كتير. بنطلع بذبح أئمة المساجد مثلا. بنطلع بسراييفو وصلنا إلى 40 ضحية يوميا، وصلنا بشهرين إلى 40,000. يعني بلشت انكريشندو، عم بستعجل لأنه ما عاد في وقت للأسف. القانون الجنائي الدولي بهذا الموضوع دخل ب3 عصور. العصر الأول هو عصر صياغة المصطلح واعتماده كقانون دولي عن الإبادة الجماعية، حتى 98 عصر التفعيل ومحاولة التطبيق، محاكم العسكرية وغيرها. اليوم أكاد أقول أننا ندخل أو دخلنا في عصر المحكمة الجنائية الدولية الذي لا بد وأن يتطور. كيف منحمي الناس والشعوب والجماعات من الإبادة؟ عبر ما نسميه المسؤولية في الحماية. يعني المسؤولية هي مسؤولية الدولة النظام القائم، ومسؤولية المجتمع الدولي في آن معا، إما عبر التدخل الإنساني وحتى عبر استعمال القوة لوقف هذه الإبادة.
نعطي مجال بعدين بالأسئلة وبالنقاشات فينا نفوت أكثر.
بس بعد في شغلة بسيطة كتير.
أخذت 20 دقيقة.
صورة عن إبادة الجماعة السياسية اللي حكيت عنها والاتفاقية ما حكيت عنها، كما حصل في الجزائر، في رواندا، في كوسوفو. ما في تقادم على الإبادة لأنه ما فينا نمرر مرور الزمن على جرائم من هيدا النوع. أشكركم.
مداخلة كانت أساسية تقنية، كان مهم جدا يعني نرجع خاصة بيناتنا ما عندهم يعني ثقافة قانونية نرجع نحطها بإطار القانوني. دكتور نضال الجردي تم التعريف عليه. أنا بحب كمان أرجع أعرف أنه أستاذ كمان محاضر متخصص في القانون الدولي، بدرس كمان بالجامعة الأمريكية منذ 2008، أكاديمي زائر بجامعة يونيفرسيتي أوف ماكجيل كندا. بلش تقريبا من 10 سنوات العمل مع الأمم المتحدة وبشكل خاص مع المفوضية السامية الأمم المتحدة لحقوق الإنسان. كمان باحث بيونيفرسيتي كوليدج كورك، وكاتب كمان لمواضيع بالقانون الدولي، منها كمان المحكمة الخاصة بلبنان إلى جانب أمال عالم الدين مغيرة وديفيد تولبرد. رح أعطي الكلمة، رح يحكينا أكثر عن نقرب أكثر من العالم العربي والانتهاكات، يعني حالات معينة، مع الأمل أنه نقدر شوي نطلع منها ونفوت بالنقاشات لموضوع يعني كيف عدم تكرارها، لأنه مثل ما بتشوفوا من العنوان هو يلي كان بيفكروا بهالإعلان حقوق الإنسان عدم التكرار وما يصير هو صار مثل أكيد حكينا عن يوغوسلافيا السابقة بأوروبا نفسها صار في بالتسعينات، بس كمان بالعالم العربي. وراح يحكينا دكتور الجردي أكثر عن يعني حالات معينة، وأكيد بدنا بنطرح سوريا بتصور. تفضل.
Good morning, thank you. I'll be the most schizophrenic situation during this panel and today because I have many hats or two hats. I'm talking on behalf of the UN, Office of High Commissioner for Human Rights, but I can always hide and go to the academia and say I'm talking personal capacity, so pick and choose when you see me squeezed. On the other issue, I can talk in English, I talk in Arabic. So usually I talk in Arabic in the MENA region, but it's the American University of Beirut and probably there are other internationals. So I can talk a bit in English, then if you ask me, then I can probably talk in Arabic when you ask me and I raise that, okay? Before moving on my topic, definitely I'll be talking about Never Again, about what Justice Jackson mentioned in Nuremberg, the famous word that what happened should not happen again, yet it still happens. What is the problem? We consider, or we at least claim that we have a full legal system. The system now is complete, or at least always developing and evolving, but the system is there. We don't have a lacuna in the law. We don't have a lacuna. So, but why? Why after decades still a genocide happens with a bit of culture of impunity? Let's put it in the right perspective. I don't want to jump on Judge and Professor K. Ambus' session about the legal elements, but just I need to remind a bit of things because really there are some misconceptions in the region about what's genocide, and probably in the whole world, except outside the academic legal circles. We are a party on our own, and also we are ultra-nationalists sometimes, ultra-legalists sometimes. As you know, and no need to repeat, it's any act committed with the intention to destroy, in part or in whole, a national, ethnic, religious, or racial group through one of the following acts, be it killing, serious bodily or mental harm, deliberately inflicting conditions to bring physical destruction of the group, prevent birth, I don't want to continue the whole definition most of you know, forcibly transferring children to a group. But what does that mean? That means that such type of international crime has certain specific characteristics that are different from other international crimes. Doesn't necessarily make it more important. All international crimes are serious. All international crimes affect and protect universal interest, what we call the civitas maxima. It is an interest, it's the greatest society, which we are all part of it. But what is relevant and more relevant about this crime, first of all, it's called the crime of all crimes again, not because it's more important than crime against humanity. Crime against humanity, thousands can die in crime against humanity and can be victims of crime against humanity. And the genocide can happen with a few hundreds or with thousands. So it doesn't make it more. But because it's a crime practically that affects and practically destroys the existence of the groups, it touches the existence of the human beings. If we have the right to life individually, then also into groups, be it ethnically, nationally, religious, or racial, we have the right to life as a group with different characteristics. Why only? So there's the element of special intention. It's a crime with a special intention. If it does not have the special intention, it is not a genocide. It is the dolice specialis, what we call it. So I need to have the intention to destroy the group in part or in total. Why only ethnic, religious, or racial or national group? And this is Dr. Sfair has mentioned, and it's a valid criticism. Among other debates is that those groups, relatively speaking, are considered well-defined groups. The other political groups, legally speaking, and we're sitting in front of very prominent judges, fluctuate, right? You can be leftist today and can be center left tomorrow, and you can join another parties. And in Lebanon, we do it a lot. Others. So how can we capture it legally? So this is a dilemma, or at least legal question to be asked. Anyway, so practically it's a crime that has peculiar characteristics, but it's a crime that is not very old in terms of positive school. So if you are a positivist, you say 1948 Genocide Convention and going after. You're a naturalist, and then you go, those crimes definitely existed. You cannot kill thousands of people and say this is something nullum crimis in legge. There is no crime without a law. Fine, but you cannot. This is what also in Nuremberg was mentioned: killing thousands of people, displacing thousands of people with the intention to destroy them. You don't have the article. But if you're a naturalist, you say, I cannot accept it by one or another. But as a positivist, there is a problem. Can we apply the law retroactively? This is another issue to discuss. Can we apply the convention retroactively? It's difficult. It's difficult. A genocide, so just to bring another few things on the table, is that genocide does not need a conflict. This is a misconception. Genocide can happen during time of war or time of peace. And this is why it falls under international humanitarian law at some point and under human rights law at another. But then you're going to tell me, come on, it's far-fetched. You want to kill hundreds or maybe thousands without a war? Difficult to imagine, but it can happen. If an organized group decided again, there's a beautiful minorities in this group, and I always pick on our beloved Armenian minority. Supposedly a freak who wants to get rid of the Armenians with the intention to destroy them from Burj Hamoud, and decided to poison the water, the widespread. There is no conflict, but at the same time, the intention is there. The element of killing is there, and the ethnic group is well defined. So this can happen without a conflict. Genocide, same as any international crime, it's a misconception. International crimes do not require an international element. They are called international crime because they protect and affect a universal interest, not because there's an international element in the crime. This is the difference between such crimes and transnational crimes. Transnational crimes can affect a number of countries, yet the interest protected could be 1, 2, 3, 4 countries, like drug trafficking, illicit trafficking between Lebanon, Syria, Iraq, or Iran. It does not affect the interest of the Mexicans. But destroying the human race affects our existence as human beings. So it can happen only between two of the same nationality, with local motivators, with local insight and plan, and at the same time, it's a national crime. This is what we learned, as simple as it gets, in Rwanda, right? The Hutu genocide, the Tutsi, they were Rwandese, against Rwandese, on Rwandan soil, with no international intervention. The ICTR came after. And the ICTR role is not, now we have a different one. The ICTR role is again to reiterate that it's an international crime, therefore, if the national system did not prevent and protect, then the international system should work. Now, when it works, sometimes it's political suitability. Is it the fault of ICL, International Criminal Law? Not that much. It's the fault of the world system we live in. And we blame a lot international criminal law. So these are quickly to move on my topic, but just I wanted to put things into perspective. Despite all the discussion and despite saying that such heinous crimes should not happen, they are still happening. They're still happening, and more importantly, they're happening in our region. Sometimes we use the term by mistake interchangeably with other crimes, but it is happening. If we go back together, let's start by self-criticism. Sabra and Shatila. Not only self, it's also the Israelis, definitely. What about the Lebanese civil war at some point? In some instances, I can highlight, and now in personal capacity, not the UN, so to make it, to jump where I want to jump, okay? What about Damour? What about Kfar Matta? What about Derdurit? What about some aspects when there was an ethnic cleansing with the intention to destroy in part the existence, be it of Christians in some place or Druze in another? Wasn't that a little bit to think about it outside the box? Now, unfortunately, this was not captured because we had a blanket amnesty law, but it was there. What about Hama? We don't know if Hama, it is a crime against humanity in 1980s, early 80s, or it was intention to destroy. I would say difficult to say Hama. Hama was atrocious crime, was heinous crime. But at the same time, Hama, it was a political movement. We cannot tell if it's, so maybe the Genocide Convention is not able to capture fully. It's a good debate. Coming to the early days, what about before, after that a bit, Halabja? What happened by using chemical weapon against the Kurdish minority in Iraq? It was the Iraqi government, the Kurdish minority, Iraqis, now accusing them of having relations with the Iranians or with whoever to do that. But in reality, if we go and study the elements, we see that the elements are local, yet it was an international crime. So again, back to what I was talking about. But at the same time, the bigger challenge is not only labeling them and characterizing them legally. The bigger challenge is, again, what is the obligation under the Genocide Convention? Two main important obligations. It is prevention and prosecution, accountability. Prevention on its own, So the Genocide Convention is a very, same to few other conventions, but definitely it subsumes two types of responsibility in international law. State responsibility and individual criminal responsibility. Because, so this part is under international criminal law, but after all, it's a treaty. And states have a duty to observe their obligation, right? Article 27 of Vienna Convention on Law of Treaties. Acta sunt servanda. Treaties are put to be observed in good faith. So states need to observe them. So there is a duty on every state to prevent genocide. This is a stated duty. If you fail, even if you don't do it, this is another part of the trick. So you don't do it, but you have sovereignty. Sovereignty includes duties and obligations. This is the privilege as a sovereign state, right? Historically, sovereign used to do whatever they want. Now we said there is responsible sovereignty. Sovereignty is not all absolute. You are the father and the mother of this society. You apply the law, you do that. But at the same time, if you fail, it's your responsibility. So you have two types of that. Sometimes state-orchestrated genocide, sometimes a genocide that can happen by non-state actors, definitely. But in both cases, on your territory, as long as you are a state and you are exercising your full jurisdiction on your state, you are responsible to prevent. You are responsible to prevent, and at the same time, responsible to protect. So I go back to the basic human rights obligation of the state: respect, protect, and fulfill. Respect is the minimum. You as a state refrain from doing it. Others refrain from doing the crime. Protect, which includes prevention. So you protect by preventing, and you protect by punishing the perpetrators so that it will not happen again. In all these cases, I have to say it, that the MENA states have ratified the Genocide Convention. Approximately all of them, not all, but most of them. Yet at the same time, nothing was done. No incorporating of the crime in the judicial system, no applying of the treaty by any man. I'll be talking more about internally in the second session, but I will talk now about cases and live cases to see what is going on. So again, all happened without accountability. Sabra and Shatila, responsibility of the occupier. Israel should be also to prevent and responsible. Israel ran away from it by the Kahan report. The Kahan report to try to put it in the perspective of civil responsibilities. This is not enough. The convention does not talk about civil. So state responsibility and criminal responsibility. What did you do on criminal responsibility? Nothing. What did the Lebanese themselves do on the criminal responsibility? I have to say it. And taking my origins are from Lebanon, so I can talk with a free hand a bit. Self-criticism, nothing. Now, same applies to many other places in the region. So going to Iraq, and this is also an interesting part of the debate, is the recent genocide case of the Yazidis, as easy as it gets. I chose this case because it is a flagrant, clear-cut case of, I'm not ruling on it, but I'm saying that the elements of genocide, obviously and apparently they were there, and this has been supported by a number of international bodies. I don't know, most of you know what happened to the Yazidis, I think. It's a lovely minority, same as this region. What I like about our region is this region is hybrid and rich in different groups, contrary to what people think. This cultural diversity is an element of enrichment for that. And Iraq is one of them. Iraq is a very diverse and rich country in terms of its groups. Saba, Yazidis, Assyrians, Chaldeans, Kurds, Arabs, Sunnis, Shias, Christians. So this is an element of enrichment. Definitely taking the religious beliefs of the Yazidis or various elements of their cultural aspects. The Yazidis were attacked by ISIS, Daesh. They practically, many of them, thousands were killed, thousands of them were raped and enslaved, and enforced disappearances and cases. So what happened exactly? And again, the Never Again 1945. This happened a few years ago. So we are after the 20th century, and We thought that this will never happen again, it's not anymore. What we gained as a human rights movement, as international law and international criminal law, we always thought that it is progressive. We always have this perception that what we will do more because the humanistic and the human rights movement is progressive. It turned out to be false. We are going back. We're going back. So I've been now harassed, and I should be harassed by the chair. So I have to abide by the time. So what happened with the Yazidis in terms of the elements of the crime of genocide? I'm highlighting here the Commission of Inquiry, the United Nations Human Rights Council established Commission of Inquiry for Syria. Cleverly and smartly, the Commission of Inquiry does not have a mandate over Iraq. But what they did cleverly is that they said that it's true legally. The Yazidis were killed, were sexually enslaved, and were sexually enslaved to Raqqa. They were sent to Syria. So they used the element that the crimes have the spill over the crime, the crime, to go and say this happened, it's under our mandate. And they covered practically to see if the genocide happened. Now, the burden of proof in Commission of Inquiry is not very high. For those who know quite criminologists, we have different levels of proof. When you convict beyond reasonable doubt, when you prosecute, there are reasonable grounds to believe. There are levels. The prosecution have a lower level than the conviction. But the Commission of Inquiries have even lower level. They use a lovely term, balance of probabilities. Balance of probabilities. That is, there is high risk that this happened, not to the level of prosecution. Can we criticize? Sometimes you can, but at the same time, maybe this is the first step for a judicial case. So it is a fact-finding in Commission of Inquiry. So it builds the ground. Later, probably an international court or an Iraqi court can do the job. So what did the Commission of Inquiry document? It documented the material elements of the crime, very interestingly. First of all, it defined, or at least it got into whether the Yazidis are a group under what is defined under the Genocide Convention. What are they? Political group, out. Social group, out. What are they? Gender group, out. They need to be one of the four restrictively. It's not a non-exhaustive list, it's an exhaustive list. They discovered the Yazidis are an ethno-religious group. They are religiously distinct, but ethnically distinct. So they fall quite okay under the convention. How were the Yazidis being, how was the genocide materially happening against them? Obviously, they killed men, many men, they took them and they killed them, and we have evidence on this. Very interestingly, it used serious bodily or mental harm. This is the ground where a number of international criminal tribunals used to widen the material perspective of the ordinary crimes within the international crime that constituted genocide. So when we entered rape as one element to commit genocide with Akayeso and others, it was practically under the severe bodily harm caused under this. Because the initial definition does not include sexual crimes. But that was good by jurisprudence. So that was good. So on that, we can find it documented enslavement, rape, and sexual violence, okay, and torture at the same time. On the other element, it also discovered the element, or one of the material elements of the crime, deliberately inflicting conditions to bring the destruction of a group. This was obvious when they were besieged or sieged in the month of Sinjar. They denied them food. They denied the women and the kids and the children and men, civilian, any food. So their aim was to kill them. So it was at the same time, it's a physical condition to make the group be destroyed. There's a debate when you, I got distracted with it. If you give me 2 minutes. 2 minutes. Okay. So if the group's ethnic racial character is affiliated to a number of religious rituals that has to do with the physical presence in the place. If I ethnically cleanse you from this area, don't I destroy the possibility of destroying your existence? وجود الشعائر الدينية، وجود المقابر الدينية، وجود rituals. So destroying your existence in some place and spreading you in parts of the world is an element to be considered and to be seen if it destroys, and it destroys your existence partly as a group. Cultural, there is a big debate, and this was raised in Australia too and other places about indigenous people and that. But it is a good debate too. I'll move quickly on the mens rea, very interesting, on the mental element of the crime. How did the Commission of Inquiry find that ISIS had the intention to throw in part on total. As we know, we try to know that as criminologists from the verbal theory, the verbal explicit intentions of the perpetrator. You say, I'm going to kill. But in genocide, these are crimes until GCE, joint enterprises. So many people and leaders are in. You will not find a single somebody will write and say, I order you to kill these people because I don't like them to live. You will not find this. They do it implicitly. So what the International Tribunal has elaborated is the circumstantial evidence, circumstantial material evidence. The material evidence in your behavior that help us and help any court to determine that there was an intention. The way you leave people without food, you besiege them and you know that they will die, and yet you say leave them. There are many elements that in fact, ISIS made life easy because they consider them infidel, they consider say, and they told them, you don't live unless you convert. And also forcing the boys to convert and moving the boys under 12 to be trained with ISIS to be Muslims is in itself another element of the crime. So in that regard, they were destroying the group and they were very about it. So in my opinion, it's a very easy case. It's much easier than even Karadzic or others, GCE, or even sometimes the court goes something called GCE 3, the extended GCEs. So it is about, you don't have the same intention everybody, but you can foresee the intention among the whole group. جمعية الأشرار رئيس عنا بالعربي مسميها جمعية أشرار بقانوننا بس هني موسعة بإطار أبسط من هيك فإذا we will stop here to say on that. I just want to say there is responsibility under the Genocide Convention for the international community and the UN to work. I'm not defending the American
عن تشريح عملية الإبادة، ولكن ما بنضطر لموضوع الثقافة الجماعية، ويمكن الثقافة الجماعية هي الأساس للعمليات الإبادة. لما بيكون في بالثقافة الجماعية تحقير أو فصل مجموعة معينة بالثقافة الجماعية، أكيد الإبادة تحصل بوقت معين، ولكن لو ما في الخلفية الثقافة الجماعية اللي بتوصل لهالشيء ما بتحصل الإبادة. مثل المثل اللي عم تقول عن اليزيديين، لو ما كان في بالعراق ثقافة تمييز أو تحقير هالجماعة ما كان حصل هالإبادة. وأنا بدي أعطي مثل، بدي أوصل للبنان. نحن بلبنان بالسبعينات والستينات ما كان في تمييز، ما كان في تحقير للغير. اليوم نحن متجهين لثقافة تمييز وتحقير الغير بالمجموعات الفئوية، ومشجعة هالشيء مفعل هالشيء من القيمين على المجموعات الفئويه تقدروا يتسلطوا على المجموعات، وهيدي يمكن يؤدي بالمستقبل يوما ما وقت قريب ما بنعرف لما بتصير في الظروف المؤاتيه يمكن تؤدي لنفس النوع من الاعمال. شكرا.
شكرا لك. رح ناخذ 3 أسئلة عفوا قبل ما بعرف إذا ما انتبهت بفتكر حضرتك you want to answer you have a بعدين ساري بعدين المدام.
Thank you very much. My name is Utkat and I'm representing the Embassy of Turkey here. So I would just like to make a few remarks regarding Mr. Holzfeld's presentation, where he was accusing Turkey with genocide. So first, I would like to say Turkey does not. Turkey does not accept the genocide claim. And as you all know, as is discussed in this meeting, in the seminar, genocide is a very legal term. It's not a political term. It has a very narrow legal narrative, and it's very clearly defined in 1948 Genocide Convention. And according to this convention, for a genocide to happen, there should be a decision of a competent court. In the case of what happened in 1915, there is no such court decision, so we cannot label it genocide. Firstly, there is this legal point I want to make. Secondly, Turkey and the Turkish people, we share the sorrow of the Armenian people and their sufferings during the First World War. We demonstrated that we want to commemorate with the Armenians the sufferings of what happened in 1915. And we have very clear political messages, including the Turkish president. Their messages were very clear and very humane in this respect. So I just want to point out this. Secondly, I wanted to share our disappointment in the sense that in a seminar where there are presentations, there are remarks accusing Turkey with genocide, United Nations is a collaborator in the seminar, so we are very much extremely disappointed with this, since I believe and we believe it's against the impartiality of the United Nations. Thank you very much.
Thank you. تفضل ساري.
Well, spoken English. I am glad that Fair and Nidal talk about extrapolating toward political groups, and I would say really we are governed by authoritarian regimes in all these regions, and for half of century, and it's time to move to at least to supplement our post-colonial thinking, where really it's a colonial, the other as an ethnic group, the other as Western power, to what our own people belong to the same group, nationally, ethnically, etc., is capable of committing genocidal acts. And I am specifically thinking about Syria now. And we cannot really not comment on almost, we know around 450,000 people killed by different groups, but mainly by a protracted genocidal regime. Hammam massacres, etc. We have a record of this 11,000 people killed in the prison. They are extremely well documented. So I hope that a question of recognition, and what I will talk this later on, that we should not dwell so much in only legal level of recognition. I mean, we need political debate, we need a moral debate to engage, and not only a legal debate. So
got the message. Then we'll give the floor to answers. Then we'll have a second set, and please be short.
ملاحظة صغيرة للدكتور نضال. أنا وسن مبارك من السفارة العراقية. هو سهل نينوى وليس ماونتين.
بس اكيد، بس جبل سنجار كانوا هن بالاخر شيء حوصروا بجبل سنجار.
هن حوصروا في سهل لانه سهل الوصول اليه، محصور بين الجبال في هضبه.
انت ادرى.
I want to comment about الشخص الاول اللي اعطى تعليق. قال انه لابد ان يكون مدعوم مجتمعيا، وهذا ابدا شيء غير موجود بالعراق منذ لن اقول مئات وإنما آلاف. فيني أقول هاي وحدة. في اختلاف كبير بين اللي يصير الجينوسايد من حكومات أو منظمات تختلف عن اللي صار من آيسيس، من داعش بالعراق. داعش هو كيان غريب عن كل مجتمعات العراق، خلينا نقول إذا مو هو مجتمع واحد، ومجتمعات العراق هالقد منصهرة مع بعضها ومختلطة، في عوائل وعشائر، نص مسيحي نص مسلم، نص شيعي نص سني، نفس العشيرة نفس الأب نفس الجد.
عبيدة.
فأنا بس يعني بدي عم موجه كلامي للأستاذ الأول كومنت إنه ما في شيء مدعوم أو مشجع مجتمعيا في العراق ضد الأيزيديين بالأخص، لأنه يمكن ثاني أصغر ماينورتي بالعراق.
رح أعطي المجال للأسئلة، بس بفتكر الأستاذ ما كان بس عم بيحكي عن العراق، عم بيحكي عن يمكن غير لازم. بتحب تبلش دكتور؟
ايه انا ثانك يو. انا عندي جمله ملاحظات. اول شيء بدي اتشكر الاستاذ على مداخلته. هذا بيتطرق لموضوع مهم، واللي هي بالاباده الجماعيه في جريمه ثانيه مكتمله العناصر بالاتفاقيه، مكتمله العناصر، هي جريمه الحض على الاباده. لو ما حدثت الاباده، الحض incitement to genocide is a separate complete crime. بالعاده نحن بمفهوم اللاتيني اي حد اذا ما رافق اعمال ماديه ما بيكون جريمه، يعني ما بيكون بدا شروع بالجريمه لنبلش نحاسب عليها. الحض على الاباده لحالها، خطاب الحض على الاباده الجماعيه هو نفسه يجب، هو مجرم بالقانون الدولي. هذا بيتقاطع تفضلت فيه مع موضوع كتير اساسي اللي هو الحض على الكراهيه، ثقافه الحض على الكراهيه. ووين ضوابط؟ نحن كمان رافضين نحط قيود على حريه التعبير، لكن حريه التعبير لها ضابط، شرط ما تستغلوا الحكومات، ما تستغلوا الحكومات لاهداف اخرى. هو الحض على الكراهيه، وحيحكي عنها الدكتور عبد السلام بعد الظهر، اللي هي اعلان الرباط، يلي هو متعلق الحض على الكراهيه كبدايه. عناصر الحض على الكراهيه مش نفس عناصر الحض على الاباده، بس هي اول عناصرها، هي ارضيتها. ففي عندنا أزمة ثقافية، في عندنا أزمة ثقافية بعدم قبول الآخر ورفض الآخر وإلغاء الآخر. الآخر بيغنيني، الآخر بيغنيني، الآخر بيغنيني، أنا بتكامل فيه، أنا هاي حكيها على مستوى شخصي. هلا هذا الثاني اللي بعده، بس حقول شغلة واحدة. ثقافة قبول الآخر هي كمان سلوك اجتماعي، الدولة مسؤولة عنه، المجتمع مسؤول، البرامج الأكاديمية مسؤولة عنه، وحتى العلاقات المجتمعية ورجال الدين مسؤولين عنه، وحتى القائمين على الواجب بالدولة بشكل كامل، بدءا من العراق، سوريا، لبنان، اليمن، كل الدول، السعودية، البحرين، كل الدول، ولا أي محل يستثنى من ذلك. بسرعة أنا بدي أتفضل to talk about thank you for our colleagues from the Turkish delegation, and I think we were in touch. Our stand is clear on this. First of all, the stand of Professor Rolf Professor Rolf represents his own opinion. It does not represent anybody's opinion. He's a respected academician and also everybody. So what is lovely about this setting is that everybody has the right to express your opinion, including your opinion that is well respected. The UN has its opinion, and it's obvious and clear to everybody, including to that. So there is no need to on this, in the sense we collaborate, sometimes we support activities, but we support opinions that are sometimes criticizing the UN. It does not mean necessarily it's our stand on this. The Secretary General stand is clear. The Secretary stand indicated and talked about atrocious crimes that happen. Atrocious crimes that happen. Now, legally speaking, I may disappoint some people. Legally speaking, yes, the 1948 does not apply. It's controversial, but for some schools in law, does not apply retroactively, same as any treaty or some treaties. So using the treaty itself to apply on incidents that happened in 1914 or 1915 or after is in my opinion, is legally not possible. Not possible for that. But the SG's opinion is that the atrocious crimes happened against the Armenian minority or people. In that regard. Yes, but just I have one thing, and I go quickly. It's just for Sari. The only problem, seriously, is that there is a perception that genocide, as if we put a hierarchy of crimes. This is a problem, and I think the lawyers are responsible, the judges are responsible, and the world community is responsible. As if, genocide did not happen, but crime against humanity is as serious as genocide, and it can kill thousands and millions. So it is very serious. But just because it's not genocide, so we're fine, everything is good. No, genocide has a specific element, but again, crime against it can be more grave. I gave example. You may kill thousands. In Halabja, you killed hundreds or thousands, few thousand? 1,000? Okay. In Syria, you killed hundreds of thousands. In terms of gravity, the crimes in Syria are more grave in quantity. So this hierarchy is a fallacy. It's not there. Political parties are captured by crime against humanity, so there's no problem. Do not go.
Yes. So, well, first of all, I must say, I do appreciate if you say that you share the troubles of the Armenian victims. I'm glad to hear that. But I was not accusing. I mean, I'm an historian, and there's a difference between a, let me say, bottomless accusation and giving evidence. So what I try to refer is what the historical records say, and especially what the records of the German archives say, which I do know best of all of the archive records I know, but I know also others. And I referred what was the judgment of the German imperial government in that time, when I say that the imperial government in July 1915 literally said it is the intention of the state to eradicate the Armenian race in the Turkish Empire. This is really a very, very clear statement by an ally. And so there is one cannot debate about this. I mean, you can say they are wrong, but if you really want to prove that they're wrong, you must go into the details and present all the evidences that have led to that conclusion. And another thing is that, I mean, accusing Turkey makes things a bit too short. This was the Ottoman Empire, and as I said, the Ottoman Empire was in those days more or less ruled, or you can also say occupied, by a one-party regime of the Committee of Union and Progress. And this does not mean the Turkish people. This is really must make a difference between these political, and I would say perpetrators, and what you say the Turkish people as a whole. This is really a difference. This is the same thing when you speak about the Holocaust and the Germans, and it's, this is You must of course make that difference, and also make the difference between the generations. I mean, I belong to a country, I was born in a country that has committed a major crime, and it was crime than the Armenian genocide. But I feel responsible for this, but I do not really feel guilty. I mean, I was not born in that time. This is also a major difference.
Thank you for your... Dr. Sfair, you want to add something?
بليز ردا على او تعقيبا اللي قلته حضرتك بدراسه اي موضوع ذات طابع قانوني ما في شيء اسمه اتهام سياسي. بس ندخل بالاتهام السياسي يعني نحن عم نضعف الملف القانوني، الاثباتات والشهادات، واي دوكيومنتس بيكون موجود بتكون موجوده بدها تروح امام المحاكم المختصه وطنيه كانت او دوليه. وبالتالي وقت اللي بنحكي عن الانظمه الموجوده والتي تمارس ما تمارس، هذا موضوع ما بنقدر ندخل فيه من زاويه الكلام السياسي فقط، انما من زاويه الملف القانوني اللي بيكون عنده مستندات ويكون عنده كل الافيدنس اللازمه تيتقدم امام المحاكم، خصوصا اذا هالمحاكم دوليه او ذات طابع دولي. ساعتها الموضوع بيكون اكثر جديه، يمكن بياخذ وقت اكثر، ولكن بيكون له وقع اكبر. لسبب دائما حتى باي حديث سياسي بنكون فيه على الاعلام في فصل تام بين القانون والسياسي، والا بنصير مثل اللي عم بيصير بلبنان، كل واحد بيقرا الدستور من الزاويه اللي بيريدها. وبالتالي نعم، بدل ما يصير النص هو الحكم، اصبح النص هو مسار المشكله. بقى الملفات هون بتصير مسار مشكله، لان بيصير ملف سياسي ما عنده المستند اللازم، اما الملف القانوني فهو يحتاج الى مستند لكي يكون ثابت.
يعني بس معلش بحب أعقب، يعني أنا عم بدير جلسة وعندي كمان يعني موافقة مع ساري، يعني بالآخر نحن عنا دليل على الجرائم اللي عم ترتكب ضد الإنسانية وجرائم حرب في سوريا. هيدا مش وجهة نظر سياسي،
صرنا ملف قانوني.
نعم. بركي ما نسأل دكتور جردي وين إذا عنده فكرة عن الملفات القضائية اللي كانت عم تتحضر بموضوع الجرائم في سوريا. هل عندك أي معلومات بهذا الموضوع؟
يعني سوريا موضوع توثيق الجرائم بعتقد الشغل جيد. سوريا في عدة جهات عم بتوثق الجرائم. المجتمع المدني السوري، وأنا بعرف عدد من الجمعيات عم تشتغل بشكل مميز. للأسف المأساة بتعلم. الكوميشن اوف انكوايري عم تشتغل رغم أنه الحكومة السورية لا تتعاون أو لا تعترف بالاختصاص تبع لجنة تقصي الحقائق، وبالتالي لا تستطيع الدخول للأراضي السورية. مكتب المفوض السامي لحقوق الإنسان لديه فريق يعمل على جمع ومتابعة ودعم عمل بشكل مستقل، على اعتبار أنه لجنة تقصي الحقائق هي لمجلس الأمن، فبالتالي ممكن ينهي اختصاصها. بينما مكتب المفوض السامي هو المكتب المولج بالعمل حول الإنسان بشكل مستمر في الأمم المتحدة، فهو بمكتبنا والعمل. هلأ هذا على مستوى جمع المعلومات. على مستوى المساءلة للأسف الوضع هذا. ليش؟ لأنه اختصاص المحكمة الجنائية الدولية لا ينعقد إلا بالانضمام أو بتوسيع الاختصاص تحت المادة 12.3 أو بإحالة الوضع من قبل مجلس الأمن. مجلس الأمن الوضع السياسي كلنا بنعرفه هو لا يسمح، وال12.3 بدها قرار من الدولة السورية، ولا أعتقد هذا متوافر. الاختصاص العالمي بتشكرك جيد كتير. الاختصاص العالمي عم يتمارس، بس صار عم يتمارس بضوابط أكثر. بالماضي كان في حالات ممارسة اختصاص بشكل واسع، هلا عم بيصير في انه على القليل بعد حضور المتهم او وجود المتهم على الاراضي معتمدين على دولة معينة. بس هلا عم تبلش تظهر دعاوى ضد بعض اللاجئين يلي لجأوا إلى البلاد وتبين أنه هن مرتكبي جرائم حرب ومنخرطين بجرائم ضد الإنسانية أو غيرها. هلا هذا شيء جيد. النقطة الإيجابية الوحيدة بخضم هذا التشاؤم بالوضع، أنا بقولها بالناحية الشعبية، بالجرائم الدولية يمهل ولا يهمل، بس لأنه فيها عدم مرور الزمن ومبدأ التقادم، عدم سريان مبدأ التقادم بالإطار هذا. فهم نحكي فيها بالجلسة الثانية. هيدا عامل بيسمح أنه لما الظروف السياسية تتغير بتضل الجريمة لحقتك. وأكبر إثبات على كلامي أنه بول بوت وجماعة، أو مش بول بوت، الخمير الحمر بكمبوديا هلأ عم يتحاكموا بعد 79، يعني حوالي 40، قربنا 35 سنة.
بس رح أعطي مجال لسؤالين ومنختم لأنه طلب الكلام. يو وانا تفضل.
Thank you. First, I would like to thank all three panelists for their very insightful and detailed and interesting presentations. But my first question or comment will go to Mr. Nidal Jourdi. I'm afraid that your approach of broadening the attribution of the crime of genocide, going down to individuals even, or to non-state actors, is kind of wrong, because the crime of genocide is clearly a crime which is planned, premeditated, and organized in a methodical way by state authorities, which is clearly directed against a distinct ethnic, religious, cultural, or even civilizational group. And then in that term, the Armenian genocide clearly falls into the definition of the 1948 Convention of Genocide. And by the way of broadening that notion of the attribution of the crime to different levels, I'm afraid that it will be creating serious problems in terms of the justice to be pursued for the perpetrators of the crime of genocide. And then you were mentioning that the crime of genocide should not be distinct from the crimes against humanity or war crimes. Recently, they have been grouped in a generic term, the crimes of atrocity, and the crimes of genocide, crimes against humanity, and war crimes are put in that general group. But again, you also mentioned that the crime of genocide is a distinct crime because it aims to clearly exterminate a distinct ethnic or religious group. The other crimes could be directed to larger or mixed groups. Of course, they are extremely refutable, and they should be also at the same level punished. So this is, and for Mr. Antoine Sver, as you rightly pointed, the international justice is somewhat delayed, and unfortunately, that brings to the forefront the issue of the justice in relation to the prevention of crimes, because the administration of a proper justice is one of the major preconditions to prevent further crimes. And if the international justice is delayed, then the role of the international justice to prevent the crime of genocide is significantly diminishing. And how would you comment on the recent trend of withdrawal of states from the Rome Statute, from the International Criminal Court?
Yes. Dr. Jean, please be short. I'm not sure we're having the break afterward. Yeah.
So I'm being suppressed. The question took 2 minutes. My answer would be in 1. It's okay. You're right. Definitely, it'll take time. Thank you, Ambassador, for your question. Maybe I did not make myself clear. Maybe I did not explain it well. It's my fault. What I said is that it's not. It can happen. Individuals. This is what even was said in Nuremberg. Is that when they started, the German Nazis, to say these crimes were done in the name of the state, right? Saying that this is a state. We applied the laws. These were there. Then the answer was that these were done by concrete men. A crime happens by people. It does not happen by a fictitious entity. But what does that mean? That means the state can be engaged. Yes, and I'll give you the example. And but the state, be it a leader, be it a commander, be it a president, be it all these, all of those who are involved in such a crime should be criminally liable, and there is no immunities, criminally liable. But at the same time, the state is responsible under international law, under the obligation of the treaty. And this is what we witnessed, very clear case, if you noticed, this is of interest to your attention. The ICTY was doing its work, the International Criminal Tribunal for the former Yugoslavia, was prosecuting all the accused, and it arrested all of them, Mladic, Karadzic, and others. And at the same time, there was cases before the ICJ, the International Court of Justice, a court between states regarding state responsibility, regarding respect and the proper implementation of the ICJ, Bosnia-Herzegovina versus Serbia, and Croatia versus Serbia. So what does that mean? That means that yes, a state can be involved, and in many places initially it was the state orchestrated crimes. It was most of the time in cases, and some cases were non-state actors. So, but the state is responsible under the convention. Under the convention, the state is responsible, and the individuals are still also responsible as a perpetrator in a crime. Because it is a crime, and it is a convention, and the state is not observing its duty to prevent, punish, and not to say be engaged, which is the opposite of both, which is a violation of that. So this is what I meant. Okay. It's both. Yes, it's both. It's both. Absolutely.
Dr. Sfair, then we have last questions, Miss. You, because he addressed the question to you. Okay, so you rather go ahead.
I'm the Dean of Arts and Sciences at Haigazian University. I'm also the grandchild of a genocide survivor, and whose memoirs have been published, and they'll soon be in Turkish, and I'll gladly send you a copy as well. My question is, this seminar is about lessons learned for prevention and protection. And I think by the end of this day, we'll come to some resolutions. But there is one underlying principle that is the cause of all of this, and you mentioned it. It's impunity. If I can do and get away with it, who's going to stop me from repeating it tomorrow? And in 5 years' time, we'll sit still around these tables and we'll have more seminars. We have identified the problem, we have the proofs, we have the laws. Who is going to enforce them? Who is going to apply, especially when impunity is at the topmost level of every country? It's not the small policeman, but the one who covers the small policeman. So what are we going to do about that? Thank you.
Yeah, can you?
Excellency, the most important thing is that the international justice does exist for prevention, for punishment, for legal process first. Then about the withdrawal of some state or the big state from Rome Convention, it's related, it's an evidence that there is a deep fighting and competition between the international justice and the international politics. And still, and maybe we'll have some evolution in that. But we have the resolution of the United Nations, of the Security Council, of the General Assembly, even all declarations and documents, and we have to promote these products and ideas just to implement the general international justice to the whole world.
You want to say a last word just to respond, or we're gone?
Just to say, the Dean is my teacher, okay. So 30 years ago, and absolutely, the problem is the political will to end impunity worldwide, and not to put the law under the mercy of realism and realpolitik. They say a word about national criminal law, I don't like it, but it's a ship of law that's floating in a sea of politics. This is unfortunate. It's unfortunate. The politics does not enter the ship. The procedures are great, are good, or could be that, but at the same time, it's states who enforce the law. So when the ICC has been engaged in a number of places, Darfur and other, doing nothing because Security Council is saying, I took note, and doing nothing.
Thank you.
I know that we've been having a very interesting discussions. ورح أشكر كل البانelists, Dr. Jerdi, Dr. Sfair, and Professor Fosfeld, and of course to our moderator, Dr. Carmen Boujaudi. But I know coffee is calling, and I see it on all of our faces. But just before doing that, I would take this opportunity that we all reflect on a basic right that usually we have, the freedom and the right of expression. Sometimes we tend to take that for granted, and we're thankful for our dear country that we can still enjoy that. Thank you. And let's break to the coffee. On the left side, we're going to have a brief 10 minutes, and we shall continue. Thank you.
على المجلس كثير قضاء الحريات لنا قضاء الحريات
بس شجعوا هالقضاء يرجع
لا بس والله عم يطلعوا قرارات حلوه انا متابع not do that. We don't express the screen. We always Albany. There is a special rapporteur on that now. In following, there is a special rapporteur in Albany. In Lebanon? No, in Geneva. Yes, I know, but in Lebanon, nothing. We don't have much. I'm sorry for this. Yes, you're right.
نرحب بكم مجددا. الآن نتطرق في الجلسة الثانية من هذا المؤتمر إلى نظام الحماية الدولية، مساهماته وقصوره في مسألة منع العقاب عن مرتكبي جرائم الإبادة والجماعية. يطرح القاضي البروفيسور كاي أمبس من جامعة غوتنغن ألمانيا مسألة نظام القانون الدولي والواقع السياسي، كما يسلط الدكتور نضال الجردي الضوء على نقاط القوة والضعف في أنظمة الحماية المحلية. ويبحث الدكتور ساري حنفي من الجامعة الأمريكية بيروت في دور الإعلام والمجتمع المدني والرأي العام. يدير هذه الجلسة الأستاذ وائل خير، مدير عام مؤسسة حقوق الإنسان والحق الإنساني.
I decided to steer the the panel in a somehow different direction. So far, and I think for the coming sessions, we are going to focus on international law and perhaps certain measures for the future. But what I feel will be lacking is a background. And that's what I'm going to present in a very brief form. I'll start with an historic incident, very significant one. And after that, I'll pinpoint number of helpful points for our deliberation and perhaps for our planning. Now the historic thing. The islanders of Melos, terrified by the approaching mighty Athenian fleet, sent emissaries to reason terms with the masters of the sea. The Athenians' admiral's arrogant answer echoed down the centuries. You know as well as we do that right, as the word goes, is only in question between equals in power, while the strong do what they can and the weak suffer what they must. Did anything change between the incident noted by Thucydides in his Peloponnesian Wars of 416 BC and the picture of our days? Nothing would be the answer of the pessimists. They would go on to say, the rules of the game are pretty much the same. The strong dictate, the weak submit. The only difference is that those who dictate their will on the weak lack the honest frankness of the Athenian admiral. Instead, they wrap their arrogance in all kinds of ideal statements. For me, this hypocrisy is progress. A human rights effort in all their forms, including prevention of genocide, is not wasted. At least it forced violators to imply there were higher standards which they failed to observe. Now, these are some of the points for deliberation. International law, like all law, rests upon moral and practical foundations. It doesn't help to have only one of the two foundations. We need them both, the moral and the practical. If it's only practical, this will be tyranny. If it's only moral, that would be idealism. So you need a balance between the two. So international law requires the presence of responsible and orderly society that is firmly dedicated to the sharing of minimal common values. International law operates within the context of power in constantly changing environment within the boundaries of internationally accepted norms and values. This is something I suggest we bear in mind. These two pillars of international law, the practical and the moral. My following point, it shall be helpful in our examination of how international law developed to note the law of humankind. We think it is something recent. In fact, it isn't. There are references to it in the antiquities. Now, this law of humankind, which all nations regarded applicable to human beings as human beings, apart from race and religion. This attitude is not of our modern age, but has roots in antiquity. Now, recognition of this law is to be seen in the rebuke. This is the historic incident, very interesting one. There is a rebuke administered by Xerxes to those who suggested that the Persian king should retaliate upon the Athenians and Spartans for the murder of his envoys. His reply, as reported in Herodotus's Persian Wars, was that they violated the law of all humankind. His terms were mankind, but now we don't use it anymore. Of all humankind, and he would not do those very things that he blamed in them. So we have a reference here to the law of mankind. Now, a further introductory remark is that the international community displayed growing sensitivity to the plight of some minority groups. The big powers, as they were called in the 19th century, not always for purely philanthropic motives, moved toward endorsing humanitarian intervention in the affairs of sovereign states. When atrocities and wholesale massacres were committed in the Balkan by the Ottomans, the reference here is to the massacres against the Bulgarians. State sovereignty, the sacred cow of the concept of modern state, started to erode on the fringes of the international community. It's fortunate that this concept of sovereignty is eroding. Otherwise, all our existence will be senseless. There will be no human rights. Human rights is a violation of sovereignty. Okay, finally, I deem helpful to underline the role of intellectuals in introducing humanitarian concepts that serve as building block in the impressive edifice of international law. international law is marked by two characteristics that set it apart from the rest of the compilation of laws. There are two characteristics. The first is that international law is a very recent development in this body of laws, in the corpus of laws. Some of the laws will date back as old as 4,700 years, whereas international law, not as a sparkling incident here like Xerxes, but as a body, is not older than 400 years. Nevertheless, this international law is developing at a very fast pace in comparison to other laws. The second point is that the contribution of intellectuals at large in international law is by far superior to the contribution of intellectuals in the normal bodies of law. This is an invitation for all of us to contribute to the development of international law. My elaboration on this last part, which I find it important as a guiding principle for us, is that if you take number of non-jurists who played very important role in the development of international law, I'll just cite some names. Dunant, for instance, who is behind the agreement of Red Cross agreement. Take Martens in the development of the Geneva Convention and the humanitarian law. Take, for instance, René Cassin, who is a jurist, and they did a marvelous legal formulation of the Universal Declaration of Human Rights. I'm always stunned by how airtight his formulation is. Take, for instance, Malik, who contributed a very developed interpretation and definition of what is human rights and human beings. And my favorite is none of those. My favorite is Peter Benenson, an English lawyer who had absolutely no position, but nevertheless, he really changed history. He turned human rights into a very effective, practical force by mobilizing the ordinary person. He said, ordinary person can do extraordinary work by name and shame. And that was the message of Amnesty International. Now with this, I pass the floor to our illustrious speakers. I'm glad that the speakers are already introduced. So the floor is yours, Professor.
Okay, first of all, thank you very much for the invitation. My role is a role of a lawyer, so I will perhaps bore you with some technicalities, but I think it is important to take into account the legal concepts if we speak about these topics. In the afternoon, we have another panel on prevention, and on this panel, I shall talk on the International Criminal Court, which certainly has an important role to play in terms of prevention in these issues. And I will now limit myself to explain the concept of genocide from a legal perspective. So first of all, I think it's very important to, I should maybe say, because I was expected to be presented, so since this was not done, I just want to say I'm an academic, I'm a professor of law, I'm not linked to any political movement, nor to any political party. I'm also a judge, and I work in international criminal practice before the International Criminal Court. I wrote something on this area, quite a lot, and if you are interested, more interested than what I can say now, because the time is very limited, I want to draw your attention to a recent treatise of international criminal law, which I published with Oxford University Press. So you will find outside leaflets. So this is really for the people interested in this area, more than just on a very superficial level, because in the 15 minutes I have, I cannot be very much detailed. And the topic is quite complex. So the first thing we should, I think, take into account is, what are we actually talking about if we say something is genocide? Are we talking about genocide as a historical concept, as a sociological concept, as a policy expression, or are we talking about the legal concept of genocide? Now, I'm a lawyer, and I think all these concepts are very, very important, all these other concepts, but my task here is to explain to you the legal concept. So I'm only talking about the legal concept. There is one very important issue which we should take into account, and that is that, which by the way also affects the German history, that the Genocide Convention, as we have already heard, was only adopted in 1948. That is after the German genocide. I mean, I have no doubt that Germans committed a genocide against the 6 million Jews. There was a plan to destroy this group. We had the famous Wannsee conference, so there is no doubt. But we did not have this offense in Nuremberg. So don't forget this. Many people don't know this. Nuremberg did not judge genocide. There was no such offense. And in the statute of the International Military Tribunal, we only had war crimes and we had crimes against humanity. And crimes against humanity, as such, have not been defined before, though there was another issue. Can you actually take this concept of crimes against humanity, and especially the crime of persecution, which was applied against the major war criminals, the Nazis, in the Nuremberg Tribunal as regards the Holocaust? So what was applied was persecution for discriminatory reasons, okay? On the grounds of discrimination. You discriminate a group because of their religious beliefs, or for other reasons, including political beliefs. That would be the so-called persecution crime against humanity, which later has been defined in the Rome Statute in Article 7, okay? So this is an accepted definition of a crime which is applied all over the case law since Nuremberg. And this also is a very important distinction, because many times if people speak of genocide, including in the region, in this region, they are not speaking about genocide stricto sensu. They are speaking about crimes against humanity as persecution. I will come back to this point at the end of my talk, giving you very concrete examples. So when we talk about the concept of genocide, what is our authority to say this is genocide, this is not genocide? Of course, the definition of genocide in the Genocide Convention, and this is a definition which since 1948 we have always copied, until the ICC in 1998. It's the same definition. When we negotiated in Rome, I was part of the German delegation. The state said, well, we have a recognized definition, the 48 definition, and we take this definition. So 1-to-1, the same definition, we put it in the Rome Statute. Although some states and some NGOs said, but we have no political groups. We had this discussion in the previous panel. Why don't we have political groups? That was a decision by the 48 convention states, including Russia. Stalin did not want to have political groups in the genocide definition because he was afraid that if political groups would be included in the definition, the policy he pursued in Russia, in Soviet Union, would come under genocide. Read Robinson, 1950. We have a lot of books by people in the 50s who studied the travaux préparatoires of the Genocide Convention. And the most recent book is Bill Schaber's book of 96, published by Oxford University Press, The Genocide Convention, 600 pages. He recounts this history based on the previous studies, and we know that certain states, including the Soviet Union, did not want to have political groups, so they wanted to have a restrictive definition of genocide. That was a policy decision of the states. And states make international law. Not academics, not NGOs, but states. This has been criticized, but imagine we have never changed this definition. If I say we, that is the states. The states are the makers of international law. And the states have never changed this definition. We have to take this into account. There is no protected political group in the Genocide Convention. Political groups are not protected under the Genocide Convention. It's very important. Some states on the national level, however, have implemented a definition of genocide which is broader. For example, Colombia, where I work a lot, or Mexico. They've included political groups. Of course, a state can say, I have a genocide offense in my law, which I think should be broader than the international genocide offense. Germany did not do that, for example. Germany took the very definition of the Genocide Convention, the conservative definition, you can call it. Now, how, from a criminal law perspective, do we analyze a legal offense? Nidal, in his very excellent presentation, already made some important points, which I totally agree with. I just want to explain more, but he made the relevant points. First of all, criminal lawyers are conservative people, okay? We are conservative. We, especially the Germans, the Spanish, and all these people in the French culture who like the positive law. So what we say is, look at the definition, what we call the Tatbestand in German, or the élément légal in the French language, or the actus reus, how the common lawyers call it. So what is our Tatbestand? That is Article 2 of the Genocide Convention. Now, if we look at Article 2 of the Genocide Convention, we see that we could say we have two levels of definition. We have the objective level, what are the objective requirements of genocide? And then we have a subjective level. You call it actus reus in English, in plain English, a common language, or mens rea. As to the objective level, we have one issue which we already talked about, and that is the definition of a group. National, ethnic, racial, or religious group, not political group, not political group. You may criticize this, many people criticize it, also academics, but it's not in the actus reus, it's not part of the offense. So you can criticize it and you can try to reform it, but it's not in the international law offense of genocide. No political group. And Nidal made this point, why actually, I mean, there is a reason to it, apart from politics. Of course, there was this political reason by Stalin and others, but there is also a reason in terms of definition. Of course, you say political groups is too flexible a concept to be included in the criminal law offense where we want to have certainty. Criminal law is also a guarantee, and that especially we see in dictatorial regimes. Criminal law can be used against people you don't like, against the enemies of the state. And that's why we say we need to have strict criminal law. The Nazis used the criminal law to kill legally, after process, Roland Freisler in our Volksgericht people. So they use criminal law as a political instrument. And that's why we say we have to be strict in criminal law. And that means that we need concepts which can be defined by our judges. I mean, the judges are the people who say this is genocide. Not we as academics, not the NGOs, and not our diplomats, but the judges. If it comes to court, we will have authority, we will have a voice of a court which has defined it. Just as a kind of brackets, under the ICTY, the International Criminal Tribunal for the Yugoslavia, with all this case law since 93, I mean, we had many, many cases, many judgments. We have only one genocide judgment, that is Srebrenica. And in the recent judgment against Karadzic of this year, the chamber did not convict Karadzic for all counts on genocide. It took a dualist approach. If you are interested, I can explain this in detail. I wrote about this in the blog of the European Journal of International Law. You can access it easily in the internet, EGL Talk, European Journal of International Law. I made an analysis with other colleagues. And what does this show is that courts have a big problem to convict for genocide. Why is this so? Because we have a strict definition, and that's the substantive side, and we have high procedural requirements. What do you need to convict a person to be genocidaire is you must be convinced beyond reasonable doubt that this person had the intent to destroy the respective group, and that is the subjective mens rea element. Intend to destroy the group. Now, in Karadzic, for example, the chamber said Karadzic was part of a joint criminal enterprise of a kind of, well, let's say, kind of movement who said, we want to remove all non-Serb population from Bosnia-Herzegovina. But this, as such, is not sufficient to consider him a genocide perpetrator, because we would have to prove, according to the chamber, that he had the intention to destroy this group, i.e., that means the transport of a group from a certain area to another area. Yes, you can say even crossing a state border or within a state is not necessarily genocide. So what we normally call ethnic cleansing, which is a so-called atrocity crime under the United Nations scheme of the 4 atrocity crimes, but which is not necessarily genocide. It could be genocide. You could, of course, have an ethnic cleansing where you say, I want to clean, in inverted commas, a certain area of these elements, and I want to destroy this group. Yes, I want to kill these people. I want to perpetrate the acts of the convention, imposing measures intended to prevent birth. That's the German genocide, the other German genocide, which we will now deal with in Germany, finally. But you have to have this intention to destroy. If you only I say it in inverted commas, it's enough anyway. It's a crime. We are not talking about impunity. We are normatively, it's all a crime. It's a question if it's a genocide or another crime. So if you say, I want to remove, like Karadzic, from certain villages, I want to have no Muslim in this village. I only want to have Serbs in this village, but they can live in another place, no problem for me. I have nothing against the group, but I don't want this group in my village, okay? So I put them into another place. That is not genocide, because you are not intending to destroy the group. The raison d'être, the ratio of genocide is you attack the existence of a group. You attack a person not as a person, but as member of the group. You are not attacking this person because you don't like his face. You attack the person because you don't like the group he belongs to. You want to destroy the whole group. And so ethnic cleansing is not always, it could be, but it's not always genocide. Now, thank you very much. 5 more minutes. We have also extensions. So, you have this objective level. You have certain acts as defined under the Genocide Convention against the defined groups, a limited number of groups, with the intent to destroy. By the way, criminal lawyers, we have a big discussion what this means. I just wanted to tell you, I don't want to bother you with this, but if you talk about law, please take it seriously, or don't talk about it. I mean, it's easier. You can say, I'm not a lawyer, I'm not interested. That's okay. I totally accept. I think lawyers are not good people necessarily. They are very bad people sometimes. But we just talk about our subject. I mean, the specific intent, that is the dolus specialis, the überschießende Intendenz in German doctrine, is a big discussion in criminal law doctrine, criminal law theory. I mean, we discussed it in legal seminars all the time. What does it mean and how can you prove it? And you need circumstantial evidence. How can you prove intent of a person? You cannot look into the brain of the perpetrator. Even if a person tells you, I wanted to destroy these people, maybe he is a mentally deranged person. He tells you, but he does not know what he wants. So even then, you cannot be sure. So you always work with indicia, you work with circumstantial evidence. So it's a big evidentiary problem on the second level. And that's the reason why courts very rarely convict persons for genocide, because the highest threshold is genocide, the specific intent. Now then we have these extensions of genocide. What we also had in the previous panel, this incitement. What does this incitement mean? We had it in Rwanda, we used it very much in the ICTR. We call it inchoate crime, it's an independent crime. We consider that if someone incites, it's more than instigating. If I say now in this meeting, please go out and kill all the black people in Lebanon, okay? That would be an incitement. That would be clearly an incitement. And I cannot control, if there were thousands of persons in this room, not just by 50, and I cannot control these masses of people. I do it via radio, internet, Facebook, okay? So I have this public impact, and I cannot control who will react to my call to kill all black people, and the danger lies in the call. In the call as such. If I incite, if I tell people do this crime, commit this crime, in this case genocide, destroy this group, I do not control the effect of my call, and therefore is punishable independent of the commission of the crime, okay? So what is punishable here is I'm punishable for the fact that I tell you, and maybe the outside world, if we have an internet outside access, that please kill all the black people in Lebanon. And that would be incitement. And nobody reacts because they say, Kai Amos is crazy. I mean, nobody follows my call, but it's not important. The fact that I call upon you without individually saying, Mr. Hosfeld, go out, that would be an instigation. But I say incitement to everybody. Everybody who listens to me, please go out and kill all these people. This defined group would be incitement. And that is punishable as such. That's an inchoate crime. And why does it only exist, you have to ask you, in genocide, not in crimes against humanity, not in war crimes. You look in the ICC, there's the same situation. Incitement as a specific inchoate offense for genocide. Why? And here's a point where I disagree with my friend Nidal, maybe. Yes, there is an implicit hierarchy. We always have said, and that is one proof that genocide is more important than other crimes, because we do not have incitement for other crimes. And there are more arguments for this, we can discuss it. There is a hierarchy. We said crime of the crimes. When Raphael Lemkin in 48, before 48, 44, he started. By the way, Raphael Lemkin, as was said before, was a victim of the Nazi Holocaust, and he was a guy who drafted this definition, and he drafted it on the basis of the German Holocaust. So, I mean, this guy said this was the kind of blueprint. The Germans committed the genocide, de facto genocide, which was not legally defined, and Raphael Lemkin said, well, this has to be put into an offense, and I do this work. I will create this offense on the basis of the German experience. And so this extension of incitement to genocide, which does not exist, I repeat, in crimes against humanity, war crimes, is another sign of many that genocide is a more important crime. And that's why people like myself and others, I think most criminal lawyers would be very conservative and restrictive, because we think that genocide is such a special crime that we would devaluate the genocide charge if we use it for everything. Everything, I mean, every serious human rights violations. Nobody can deny that human rights are violated in Syria. Nobody denies. In my country, in Germany, we violate human rights. For example, fair trial rights. In Germany, we violate human rights. We are violating human rights of immigrants. We are violating human rights of refugees, etc. So, but that does not amount necessarily to an international crime, and less to genocide. So if you have, for example, a situation where a state fights against an insurgent movement and kills indiscriminately civilian population because it says, well, in this area X, there are rebels or terrorists, and there are also civilians, but it doesn't matter to me because I think I have to kill everybody, and so I will erase the whole village. This is certainly a war crime. This may be a crime against humanity if it's based on a systematic policy of persecution of this population, of killings, rapes, etc. But it would only amount to genocide if these people are attacked as members of a group. And in a situation where you attack your own people, in Argentina, I don't take examples of this area, I do not want to enter into this debate, but take Argentina, that was an important case. If a military dictatorship kills the left-wing people, they don't kill them because they're Argentinians. That's absurd, this argument. Because you are Argentinian, you kill Argentinians, not because you are Argentinian, you kill them because you are communist. You consider that is a communist, or this is a guy who has political beliefs you don't support. So you kill them for political reasons. So that's a persecution crime. It's not genocide. So my plea is, let's be careful with this use. If we talk about law, we can say, I'm not interested in law. Okay, I accept it. We talk about historical concepts. But let's just clarify what we are talking about. That's my only plea. Thank you very much.
Thank you, Professor Ambos. I was lenient in applying the time clause because Dr. Jordi transferred from his account 5 minutes to you.
Thank you.
A famous human rights activist, international lawyers, academic, and also has a prominent post within the framework of the UN. Already introduced, but don't listen to him again.
Famous is a big word. I just enjoy this academic discussion, same as others. Thank you, Professor. Really, it's very difficult to talk after Professor K. Ambos. Again, for those who don't know, Professor K. Ambos, a very prominent name in international criminal law, have been cited many times. His writings, his numerous writings, were cited in numerous cases at the international courts. So again, it will be difficult for me to pick it from there. And just one thing, he talked about his comment on Karadzic case. It happened that I have it with me, so maybe I'll share it with Anita so that we can print it for the audience. That's a good, I mean, for those who are interested in the commentary on the comment on the Karadzic case this year. It's a recent decision. Okay. I'm going to talk about, let me remember what I'm talking about. Okay, that's good. I'm going to talk about domestic protection system strengths and weaknesses. And this is a very contentious issue that brings in the MENA region, the domestic implementation of the convention, the relation a bit. I will not go a lot about international courts, the direct enforcement mechanisms, because Professor Kay will be talking about it. After all, where are we? What is the situation in the MENA region? As I talked in the morning, and as you know, I mean, most of the Arab countries, not all, most of them ratified the Genocide Convention. Again, the international community drafted a convention for a reason. The reason is to improve protection. So the logical issue is that ratification itself, joining a treaty, logically saying, is a mean, not a goal. Huh? It's a mean to improve protection. And although international criminal law started in reverse, so if you talk about international criminal law, even the terms we use, when we say direct enforcement mechanism, the direct enforcement mechanism of ICL, we also say international crime, courts. When we talk about domestic systems, we say indirect enforcement mechanism. This is a bit blurred and this is a bit confusing because usually what we know as lawyers that is usually the natural judge is the first logical judge, right? أفضل قضاء هو القضاء الطبيعي المحلي اللي أمامنا. The reason is historical and the reason are well known because, as you know, that international criminal law in its current form was at some point a reaction to legal lacunae, legal loopholes in the international system of protection. The principle of sovereignty, you don't interfere in domestic affairs, we talked about it, which is catastrophic. What did this lead to? Led to a state who under different justification can kill its own citizens, can commit different type of international crimes, yet claim and invoke the principle of non-interference in political affairs, in domestic affairs, and therefore stuff like I'm out of this. International criminal law came to say, no, these are international crimes. The interest they protect is beyond your sovereignty. The interest is protected is beyond the state. It is above this and above that. So the starting point for this was a tense relation between international criminal law and public international law. Because public international law historically had a number of traits that preserved state sovereignty. No interference, domestic affair, immunity for head of states, and equal sovereignty. If all are equal, then we don't interfere in our business. But if the state again itself, or on its territory, human beings are being killed massively, then how we protect them? So ICL, to be able to deal with this, it was under public international law, but at the same time to reverse certain concepts of public international law. So the starting point was very logical to be international courts, not domestic courts. And then we started to say, no, it's not enough. International courts cannot do the job, cannot do the work of every community and every society. And the logical aspect is back to domestic courts. So again, through this compromise, states are still the duty bearers, but states have obligations. Obligations they took voluntary. Nobody imposed anything on states. So if you go to all the sources that are the basis of the international crimes, they're either treaty-based or customary-based. But in both scenarios, it's voluntarism. And whoever says something else is saying something wrong. It is voluntarism. It's the states that accepted those obligations. Now, unfortunately, states now, or some of them try to retreat or try to say, but this is what the states did. Geneva Conventions are conventions. Genocide Convention is a convention. Crime against humanity is not a convention, but it was in Nuremberg, in the IMT statute. It was accepted by the General Assembly in a resolution reflecting states' will. On its own, does not create custom, but nobody objected, continued to this, and then adopted it in ICTY, ICDR statute, and then in the ICC Article 7. There is now a discussion about drafting just a convention on the crime against humanity to codify that, but this is redundant in terms of criminalization. It is redundant. Why I'm bringing all that to say that despite that, international criminal law tried to organize the relation under the ambit of international law by saying it's also the duty of the states. It's the duty of the state to prevent. It's the duty of the state to proscribe and punish. Okay? And if you look at all the conventions, and this is the characteristic of international crimes, you see the principle of universal jurisdiction did not come from a vacuum. It came from legal obligations that were subsumed in the early conventions of international criminal law. For instance, if you look at the Geneva Convention, it includes what? A very important principle. It is the audidere aut audicare, the Latin principle of either extradite or prosecute. You either prosecute. Now there is a debate whether which one is before the other, depending on the treaty. But in general, the logic of the law is that as a state, you have to criminalize the conduct and hold those accountable. If you can't do it, extradite to another state to do it. This is what we have in the Geneva Convention. In fact, it did not come from Geneva Convention. It came from the oldest crime, oldest economic international crime, but there is a debate if it's international, is piracy. Piracy. This is Hugo de Groot. It was first put by Hugo Grotius, the famous father of of the law of the sea. So from there onward, just to make the story short, we look at other conventions and we see them, they are being repeated in a number of conventions. Even in Convention on International Terrorism, see that repeated? We see them in the Genocide Convention, but not in the same language and not complete od didere, od edicare. We say it is the domestic court that should prosecute or else surrender to an international tribunal when it has jurisdiction. Because at that time, in the mind of the drafter, the ICC was to come. And in fact, the negotiation of the ICC was apparently, or at least closely at the same time, 1950s, 53. It was the Cold War that stopped the ICC from materializing. And it kept freezed until 1988. And 1988 is not a coincidence. 1988 is the time when the Cold War was over. And it was the idea of establishing a court for transnational crime that created, again, the momentum for the ICC to regain the ground. And another historical. The bottom line of all that is that international criminal law in its treaties also had the ground, state responsibility, state duty to prosecute and to play the role. Now, that is okay, but then you're going to tell me, okay, that's fine, that's good, but where are we from there? Unfortunately, we are not in a very satisfactory situation. If you look at the Genocide Convention, it is, first, before I talk about Genocide Convention, I want to talk about, quickly, most of the Middle Eastern countries, MENA region countries, are of the monist system. For those who don't know a lot about international law subsumes or incorporates treaties through two main schools, one called monism and one called dualism. Dualism is like the Anglo-Saxon system where it's two different bodies of law and they are parallel. It's an obligation, but you need to include it through a law in the system. Monist system is a bit easier, at least on paper. It considers international law part of the domestic law. So any obligation you take internationally, it directly becomes part of the obligation domestically. So that could make our life easy, right? For the systems that apply the monist system. But it's not very much easy for two important reasons. Genocide Convention in some of the articles is not a self-executing treaty. If you read Article 5, it says states will adopt legislation to prosecute blah, blah, blah. So if you look at it, I'm not reading it verbatim, but it says you need to take legislative measures to practically prosecute, meaning that you have to do something. Plus, don't forget, I mean, these are the ABCs of criminal law. No law, no crime without a law. So already we need it in the penal code, otherwise we can't prosecute it. So this is a problem. Now you may tell me, okay, but there are other crimes that can prosecute them ordinarily, as ordinary crime, right? War crime, you can prosecute as killing, as a homicide when you kill a prisoner of war, or you use torture even if it is a war crime, etc., etc. In fact, if you look at the material element and even the mental element of the crime, it is difficult to capture it through an ordinary crime. Very difficult. How can you capture it? You will take it just as ordinary crime of killing people. But this does not catch the severity of the crime. Does not give it what it is. Plus another problem is these international crimes do enjoy certain characteristics. And the Genocide Convention does enjoy similar characteristics. They are there in the treaty. One of them is no immunities. It's clear. No immunities. But we know that on domestic speaking, and those are crimes that, as mentioned by some colleagues, that many times happen through a state-orchestrated plan or through commanders. Time is over because I give that. So quickly, I'll take just half a minute. So no immunity is another problem. Extraditable, not ordinary or decare, so needs to be more careful about it fully on this. But at least it's extraditable. But the world has exercised universal jurisdiction over the crime. Historically speaking, we did not apply a lot, although that. We applied the first case, if you recall, probably it's Eichmann. It's the case where Israel abducted Eichmann from Argentina to prosecute him for a crime, but at the same time, this was very contentious. Israel is not successor of the Jewish minority in Germany. And Israel existed after the crime. And at the same time, the legal definition itself did not exist there. So this was issues that were raised. The world in general domestically remained dormant on the crime, truly, and that's disappointing. Remained dormant until 1998, suppose at some point, where the ICTR, starting with the Akayeso case, and also the ICTY with the Christish, which also prosecute them, and then back to back, the ICC debate, and then states start to pick it from there and back to domestic courts trying to do that. We noticed that in a number of cases, the Rwandese themselves started to prosecute through the Gacaca courts. Canada, or the Mayonnaise case, Guatemala case, although now it's not going very well, before Guatemalan courts, and also Spanish courts to try to do universal jurisdiction on that. When it comes, again, and lots of others, Switzerland, Germany, Georgia, Finland, others. What about the MENA region? In the MENA region, not much. The Iraqi High Tribunal, the Special High Tribunal, that was for Saddam and others, tackled some cases, and it was included in the law just for crimes that happened during that period. But it was never extended to be a regular crime in the criminal penal code of the Iraqi system. Again, still the challenges are there in the region because immunities are there. It is not within the domestic law, and at the same time, there is a culture of impunity, I have to say. I gave you the example of the blanket amnesty law of Lebanon. That is a law in violation of international law. I hope this will end. I hope this will end soon, although the situation is not encouraging. Thank you very much. We need to keep the fight. Thank you.
Okay, we touched on the international system. Professor Ambers covered that. And now the domestic protection system already covered by Dr. Nidal. Now we zero in on specific things. It is the media, civil society, and public opinion. Our speaker is Professor Sari Hanafi, who is a professor of sociology at the AUB. He also, to his credit, he introduced a minor degree in transitional justice, and he's active on a number of regional societies. He acts as vice president to 2 societies region.
Thank you, Wael. Okay, so I tended to talk in Arabic, but I notice if I talk in English, only one will put the cast, so I will stick into English. Let me quickly go to what I called pillars of justice, and I agree so much with Kai and Nidal about the complexity of these issues. This is why we need really to keep a cold blood, because it's extremely complex, and we should not understand the justice as only with its pillar, the legal, okay, the lawyer. I am surrounded by lawyers, so I should be careful what I would say, but also the political and the moral. And I think if we understand the justice only by one pillar, we will skew this justice and maybe make it injustice. And I would take each pillar, and I can show you by itself can be negative or positive. For instance, let me say Israel has been created through international law. So even the majesty of international law may do injustice for other people. Recently, just a few days ago, Polish historian Jean Gross did an interview in a German newspapers claiming that the atrocity of the Polish government toward Jews were, according to him, is worse than the German one. And this is to protest against Polish policy toward the refugees. I mean, Syrian refugees and other refugees, because Poland refused to take refugees. So quickly, the parliament, Polish parliament, issue a law of imprisonment for those who tarnish the image of Poland. Okay, something like that. Okay, so you see, I mean, with law you can create absolutely justice, but injustice. The political, of course, I would say in the last 10 years, the political was extremely instrumental for recognizing the Armenian genocide. I mean, and of course, it's happened by specific countries, those who wanted to tease Turkey. So in fact, just to show you that the political is not necessarily neutral. Political is political. We see how politically also many countries refuse to I mean, made a veto about so obvious war crime committed by Syrian regimes and ISIS and some Syrian oppositions. I mean, namely Russia and China. So we see the political. If I take the political in a local level, I can mention a lot of positive examples. For instance, in Latin America, when all victims are eligible for compensation after protracted atrocities, we saw that no, the political work a differentiated compensation to take into account the need of poor people compared to middle class. So you have a much advantageous package for poor people than for the others. Okay, so again, so the political is extremely important for justice. Okay, and I will come to something to last pillar, which is extremely important. This is for me is the moral, because believe me, in the end of the day, the moral for me who overarching the enterprise of justice. I mean, why at certain point the politics and the legal will work? Because we feel morally something wrong. And just to give you an example from France, Frédéric Mitterrand, a very famous French presenter, he became Minister of Culture in early 2000, and he and suddenly National Front they show they publish something that in his memoir he wrote, when I go to Thailand, I like to flirt with boys. Just he used a word flirting. Okay, so for so National Front asked for his demission, for his resignation, and a court. So they sue him, and so it become like a famous affair in France, because he is a minister. In the end of the day, so and then the judges. So okay, absolutely, there is no legal evidence of any pedophilia, but the moral pressure was so strong that after the decision of court, he resigned. Okay, so you see, I mean, and this is where really, I mean, every time I am not Lebanese, so I have relationship to all Lebanese group, so I benefit of this externality. So, but when I talk with people of Hezbollah, say, I mean, would you one day think in al-Manar or in al-Akhbar newspaper make a moral judgment about what is going on Syria? I mean, again, I may ask other party to do the same thing. Okay, so I think this is extremely important that that we don't dwell so much in politics of recognition. I do understand Armenian people, and I fully support them to keep pushing in a legal level. Okay, don't misunderstand me, but I mean work other levels. And this is here where it come the title of my talk, role of civil society, because it's not only it's something should be resolved in a tribunal, but how you generate debate in a public level. Why I saw while Armenians of Lebanon commemorating the genocide, why I saw in the Lepsius Street the flags of Turkey, and even some WhatsApp I received saying, for instance, but the Armenian were a traitor. I mean, why? I mean, have you ever seen, and correct me, a debate in 1,000 of mass media, Lebanese mass media, where you bring these people? I mean, they make a Cold War through their street. I mean, just to bring them and make the debate in a public sphere, and not everyone using its thugs and the streets. So here where the role of civil society to generate debate, to show the complexity of this, and the role of civil society is the unicity of justice. So this is really, we know unicity of God. Okay, this is very known but unicity of justice. I mean, I am Palestinian, I cannot defend a Palestinian cause and see 4,000 Syrian killed next to me, and some of these parties use Palestine to justify this mass atrocity. I mean, unicity of justice. I mean, so I ask really, I mean, I ask Armenians, I mean, I see here this major occasion of Armenian genocide and reflection that we talk about. I mean, we should always keep thinking, do we have solidarity with the other? This is extremely important. So I will give two examples to finish, two examples and one comment about the role of academia and university. The two examples I will brought from, one from Palestine, one from Lebanon. From Palestine, it was for a long time Palestinians conflate the word massacre with genocide. And of course, they made the big mistakes of Jenin camp when Israel destroyed the third of Jenin camp in the second Intifada in 2001, that they called, Saib Ariqat used the word, this is a genocide. And then we discovered that, in fact, you have as much as Israeli killed, because the Palestinian resistance was very smart. They killed among Israeli as the Palestinian civilians. So it was actually as a destruction. And in that time, I wrote an article which published in 7 languages. It's called Israeli Colonial Project 2. Spacocide. So to highlight, is not genocide, is not killing people. Their project is much smarter. It's not about people, it's about land. They want more land, less people, wherever they go. So it's in Arabic التطهير المكاني. It's a place where so in fact why the role of civil society? And I was part of civil society. I was a head of a research and advocacy center. To say, because I noticed that the Palestinian National Authority, they have never stopped negotiation when Israel do a new settlement. They only do it when there is 1 or 2 Palestinians killed. So the whole imaginary of the conflict is about, they didn't notice that, in fact, the issue at stake is not killing 1 or 2, but the massive confiscation of land, etc. So I think really we should, and I like the debate today, I mean, about genocide. I mean, keep genocide as illegal, but work other atrocities, and maybe at a certain time I agree with Nidal that the hierarchy maybe it's much more important. So I would say we need really to go beyond this catchy terms and see how atrocity can take different shape, including politicide, when you kill the leader of a political parties or a group, or urbanocide, what happened in Bosnia, for instance, that the Serb wanted against any mixity, so they want to end up any cities where a symbol of mixity and just produce a village with mono-religious color. So I think this is here where I see our role. I mean, look what happened in Lebanon. So in 2011-2012, I did content analysis of 232 long news or op-eds, editorial, about special tribunal for Lebanon. Okay, so and this is from Al-Nahar, Al-Akhbar, Al-Safir, Daily Star, L'Orient du Jour, etc. So so basically in the beginning I found it very interesting that 55% of the article are neutral, while if you like 25 in favor of special tribunal of Lebanon and 13 against the legal court per se, and 4% against the international criminal justice system. But in fact, when I look closely to the neutral, I found it's more informational news. So in fact, it's very difficult to load it with normativity, whether in favor or against. But what was very interesting is that it's extremely clear color. I mean, maybe only Daily Star and Orient du Jour, there is some opposing op-eds, but I mean, Al-Akhbar, you know their position. I mean, absolutely no op-ed whatsoever to say any good thing about the STL. And the other, of course, the opposite you will see in the Nahar, etc. So you see a media of a democratic, the only democracy in the Arab world where the media is so misleading people, creating from this democracy illiberal enterprise, very sectarian one. So you see the role of is if the media in the world is one of the pillar of civil society, I would say really in Lebanon that this the media definitely 5 minutes. No. Okay. I will finish. Okay. So you see, it's this is what I think. Yes, again, it's like the example I brought about the Armenian genocide. I would say, there is no debate. We only monocolor debate we find. Just to finish that, this is where I found a pity about the role of the intellectuals and specifically the academic in the Arab world. and my work is on knowledge production in the Arab world in the last 5 years. If you take France or South Africa, you see that the production done in a professional, what we call the professional, is within the university. Research is always has a public moment. I mean, it's through op-eds, media, interviews, etc. But policy, talk with the policy maker. This is a case of France and South Africa. If you take the situation in the Arab East, you find the research is actually it's policy rather than professional, so done often for international organization and not for the state. But what is very interesting is not the size of each activity of production, but that there is no connection between research produced at EUB and at universities and the outlet outside. This is why in STL, and I finish here, you don't find only, I found Shibli Mallat, who is also, it's not 100% academic, it's not like Nidal, I would say. I mean, main job is elsewhere, but he is the only one try to rationalize the debate of STL. I mean, where is the lawyer of Lebanon in writing about STL in the newspaper and transforming it to a legal debate and not only a potade, what we call in French, just anecdotal things between politicians. Ahmed Fatfat said Hassan Nasrallah, X, Y, Z. I mean, it become like really no content of this debate. Thank you.
Thank you. Thank you, Dr. Hanafi. How many minutes we have for questions? 10 to 15. Yeah. While I was listening to the interesting presentations, I remembered a few things from my early days in the human rights movement. A friend of mine, in fact, he was my tutor. He once said something that it was evoked to me in the course of the discussion of this morning. He told me the only thing universal in the Declaration of Human Rights is its violations. So the violation is across the board. And I could give you a concrete illustration. If you consult, let's say, Amnesty International yearbook on violations of human rights, do you think you will find a blank page or top by the name of any country? Never, not even Scandinavia. Everywhere you have a violation. So the only thing universal with human rights is its violation. Another point, Dr. Hanafi mentioned that it evoked some memories. The original sin of the human rights movement is the following. The human rights movement attracted some prominence in the 60s and on, after Peter Benenson started the Amnesty International. And for the first time in history, ordinary people started to have a role in changing matters. So those who jumped on the wagon of human rights in the Arab world were the opposition parties, the Ba'athists, the Nasseris, the communists, etc. None of them is deeply rooted in human rights, but they were in opposition, and the only outlet for them to practice, to topple regimes, it was under the slogan of human rights. So from the outset, the human rights movement was politicized, and this led for it to lose credibility. You would defend a just cause, but you will turn a blind eye to a far more atrocities committed by your allies. That tarnished the human rights movement. Now your questions. Let's start with the gentleman there.
It's my background is in international public law, even though I found it more lucrative to go to the private law in my career, but I still keep that interest. We have a situation, I'm sure many of the individuals present here, most probably they are a little bit confused for the second session, because the topic itself is confusing. It has to do a little bit also with the human nature, I guess. Like communism, when they started, the concept of Marx and others was to create an ideal society, but they forgot that all human beings have their weaknesses and their sins. And maybe we are trying also to find an ideal society with regard to human rights issues. Now, you mentioned that there is at least unity in God, but there is such a diversification in its implementation. It's the same thing about the International Tribunal or International Court. There are so many interests which come into play, and it will be very difficult to control individuals. And I think in the coming 5 years, I'm afraid that we're going to find even more violations, because it's not anymore a MENA question. Today, if we see in the Western countries, in the so-called civilized world, whether in the United States, in UK with Brexit, in the United States with the election of Trump, in France with Le Pen, in Austria, almost there. There is a clear division of the world. All elections, if you notice, are won either by 50.01% or lost by 49.55%. And I'm afraid, obviously you follow the news on CNN, in the US already there is this tendency that more and more hatred, more and more strife, and I feel it. During the elections, nobody was able to express his views to his neighbor. In my law firm, lawyers used to avoid asking each other who we are going to vote for. And this is going to lead to new tensions. If we look in Europe, this wave, whether in Germany now with the immigrants, I was recently in Germany. In the early stage, everybody was very open about welcoming the immigrants, the refugees. Now there is a sort of a resentment. What I'm saying is that to preempt or prevent, I don't see yet unless we find the tool of being able to enforce. And the enforcer should agree on the enforcement. We don't have the tool. The only thing that especially the US and the Western world tried to do the last 5 to 10 years are the sanctions. Sanctions on Sudan, sanctions on Syria, sanctions on Iran. But unfortunately, these sanctions are politically motivated. Even there, even though it's a good tool. The United Nations started having its own list of people to put on their list. But the issue is, at the end of this day, what will be, virtually at least, the way that maybe we can have an order that we can enforce? Or I will put the question, would it ever be? That's another question. I know that dialogue, George Mitchell is my partner in my law firm. And he told me, he gave me 2 examples. When he was involved in the Irish negotiations, he said, I listened for 763 days. I said, you have patience, you were a judge. I don't have that patience to listen for 763 days. At the end he said, I ask you, do you want to continue killing each other and your children and your grandchildren? You have 1 week to get back to me. They got back, and in his mind, there were 2 ladies in one delegation and 3 ladies in the other, and it made a big difference according to his psychology. They said, no, we don't want to kill each other anymore. Then he said, I took 1 week. I said, this is a solution, otherwise I'm leaving. And we had peace. And then he said, the President of the United States asked me to go to Israel and try to see there to solve the problem. He said, after so many days, I came back to the President, I told him, I'm resigning. And he asked him why. He said, unfortunately, I discovered that Israel does not want peace, and the Palestinians don't know what they want. He said, unless there is this willingness, unless you convince the parties to want peace, I think that we are almost at the deadlock. So what I would like you to start is virtually imagine how this problem can be resolved.
Thank you. The gentleman over there, please. Could you say the name, please?
Iran Harman Dayan. I would like to comment on Nafi's assertion that there is dialogue. Definitely, I agree with you that there should be dialogue with the population. Armenians are living, but actually there is dialogue, mainly with the Turkish society, and specifically with the academic and education society. And there is a site there is a website, Reconciliation, where you have articles by Armenian and Turkish scholars debating this subject. However, there is no dialogue with the local populations where Armenians live in the Middle East, and this is correct. And what you are saying is very correct. But you should recognize that these societies are opaque to dialogue in all orientations. And this is the reason of the problems of the area, the opaqueness to dialogue. This is the reason of all the problems between Israel and Palestine, between the Lebanese people of different groups in Iraq or in Syria. It's the opaqueness to dialogue. And this is the difficulty. This does not exonerate the Armenians from their obligation to dialogue with the local. I will not. My other comment is to the assertion of Mr. Ambos that Lemkin's endeavor to introduce the concept of genocide was based on the Holocaust. His endeavor on this subject was long before the Holocaust. He based his activities his attitudes on the Armenian genocide, and there is a letter that he sent to the United States government in 1939 when he is warning the American government that if you don't act now in Germany, the fate of the Jews in Germany will be similar of the Armenians. So his activities were based on the Armenian genocide. Actually, the word genocide did not exist at that time, and it was accepted in '48 much later. And his activities were mainly directed towards retribution and accountability. This is what he wanted to create. And actually, this is the problem with Turkey. Turkey does not recognize the genocide because he is still, until today, following the same policies of forced Turkification of the population of the Asia Minor. And this was the main reason of the genocide. In 1938, they bombarded the Alawites, and there were tens of thousands of killed people. No one talked about them. So the feeling that they will not be accounted for, this is what is encouraging Turkey to continue with the same policy that is continuing until today. And this is their real problem with the Kurds and the Alawites, is the forced Turkification. The moment they will recognize the Armenian genocide, then they have to change their policy of forced Turkification of the population of the Asia Minor. Thank you.
I'm sorry, there's no more time for questions in case. Yeah, okay. Just one, please.
Good day, gentlemen. My name is Bassam Haj, and just want to concur with Dr. Hanafi regarding the multiple approaches that needs to be taken in order to promote international, I may say, international peace and fight the genocide and crime against humanity. You mentioned the different approach, including, in addition to the legal, the moral, and the political. And if I might say, add also the economical. I have a great respect to the Armenian community because they're also trying to lobby economically for this, in addition to the Palestinian community through BDS. And which brings me to my question to Dr. Jirdi. Now there are some states that are fighting the movement of the BDS, driven by their political interest toward Israel. Say Canada, for example, you're not allowed to promote anything which stands against the interest of Israel. Is there anything that can be done from different movements to at least vocalize their right to protest economically against a certain crime which is happening internationally? Thank you.
No.
Okay, so just I wanted also maybe not to reify the dialogue. I would, in case of Palestinian case, I mean, I wrote an article called Dancing Tango During the Peace Process, analysis of people-to-people programs between Israelis and Palestinians. So in that time I was living in Palestine, so I know, so I was very critical of all this so-called dialogue between Israelis and Palestinians through this project. I think in the case of Palestine-Israel, there is a major problem caused by the dialogue, because the dialogue evacuates the structural problem that there is a ongoing colonial project, and all the dialogue wanted to start it from scratch, to say, look, I mean, we are all a human being and we should talk with each other, etc. But every time the Palestinians, they opened their mouths, they told them, no, etc. So I would say it's very important that dialogue should have a real issue at stake and not a post-liha process. It's not just a love enterprise. It's really a real intellectual enterprise. And when I say real intellectual enterprise, this is what missing. I saw in LBC once a debate in the time of the Armenian genocide, and it was not between historians, it was between politicians. And this is we need really, I mean, I am convinced by what Rolf said today, and not at all convinced by the French Parliament voted unanimously to consider the Armenian massacre as a genocide. I am more.
Think of the German Parliament. The German Parliament
also that, yeah. So you see, I mean, this is. I mean, we should really. This is what I call rationalize the debate. Rationalization. It's really. It's a tough process. Is to tell the truth and to tell something counterintuitive, and so this is. I would like a debate one day in a Lebanese mass media where you bring the figure of Hezbollah to talk about their absolutely heroism project of resistance against Israeli colonial and their atrocity in Syria at the same time. I mean, we should have the courage to say, great what you did here and bad what you did here, and not to make mono. I mean, the devil here and the good here. No, we human beings, we can be devil and the angels in the same time. Here where the role of civil society is not, and really, I mean, when I say dialogue, and I'm so glad to hear that there is in Turkey such things, but I hope this really to be part of public debate and spheres all over the area where the Armenian exists. I stop here.
Myself?
Do you want to?
Yes, I have a few things. One of them, I did not want to talk about it, thinking that the audience is with all due respect, is a generic audience. So I don't want to shake your faith in international justice. So I wanted to keep the rhetoric that this, there, and that. But I want to send a few criticisms and to deflesh certain shortages, not to disbelieve in this system, but to look at it again to rationalize the debate, even including that. ICL, International Criminal Law and International Justice, suffers on 4 main levels. It suffers at the political level, it suffers at the legal level, it suffers at the academic and the societal, at least for the MENA region precisely. At the political level, you mentioned that, and a number of issues. Yes, again, ICL is a tiny backseater. I hate to say that. This is what we discovered now. We are the people who love ICL, and we've been following in it, and we've been specializing in it. We thought that the world turns around international justice and international courts. We saw that in Yugoslavia after, so we felt ICTY is the giant, and everybody's talking about this. Same as ICTR, although I don't know if we damaged the cause. In what sense? We dehumanize the process to become simply a legal process in The Hague, where you talk about Srebrenica in the chambers inside as if they're just numbers and you talk. This is a debate from a number of aspects. But at the same time, now it's clearly ICC, ICL, international justice, is losing the momentum. Look at Africa, people are giving up, not giving up on justice, but thinking that the system is not working. It is not the system on its own, the international justice not working. There is a retreat, unfortunately, there is a retreat on the idealism in international relations, international law. What we gained after 1945, by reaction, by never again, by, oh my God, what we did to humanity, this was a momentum. This is a momentum, even during Cold War, it stopped then, and after even the Cold War, and now there is a retreat. There is the rise of the extreme right. There is the values of human rights. The universality of human rights is now being debated. I'm not telling you that to give up and go pessimistic. I'm just telling you that there is a battle and the challenge, and what again I implicitly discussed in the morning, that what we won, we thought we're going to accumulate over. Not true. We're losing. We're clearly losing. Where is the Arab Spring? Where is the idea of freedom in the region? On the legal aspect, the problem also is even among jurists. I mean, many are not, but there is a living in a cocoon of discussion about legal debate. ICL is different than anybody of law. International justice, in my opinion, is different than any typical civil law or that, because it plays a role that is political, but also it plays a role of stability of societies at some point, and rule of law, an attempt to, again, humanity move forward without committing such kind of, that affects the existence of such societies. So it's not only lawyers and judges, but at the same time, it's steered by lawyers and judges. So judges in The Hague and the ICC, they work every day with domestic courts, complementarity. But I trust you, they are very good judges, but they don't know situations. They don't know Uganda. They talk about Uganda in a rhetoric. They talk about Libya in a rhetoric, but they don't know the places. How can you don't know the place and you talk about dynamic of justice? Is it their fault? It's more complex. It's not that they have the bad intention to get you there, but it's about lack of knowledge. Good lawyers, good judges, specialized, they don't know anything. Trust me, I lived in Hague, I lived a bit in Geneva. After a bit of time, the trams drive every day, everything is so calm. You are de-associated from the world. I come to Egypt, I used to Egypt or Lebanon. It's a different thing, completely. And at the same time, you want to interfere in Libya. Good, this is good work. But there is a problem. Academically speaking, quickly, we talk to the converted. We're talking with our own audience. We don't penetrate outside academic circles. In fact, we have interest. I publish a publication in English, because I want academic recognition. But at the level of talking to the masses, there's not much of interest. Maybe also, and also this is where the media is filling the gap. The media is important, but media alone with such misconceptions, that is catastrophic. This is what Sari was talking about. Societal, I want to question something in the personal capacity, not the UN. We keep repeating rule of law and respect to rule of law. In this part of the world, do we truly are believing in rule of law that far? If it is so, then what is the problem with the Arab Spring? Do we need to readjust and reassess what's going on? Are these values imposed on us, but at the same time we have a sense of justice? We have a sense of believing in justice, but what type of justice? This needs a discussion, a deep, deep discussion. Thank you.
Thank you.
I'm trying to be conscious of time, so I would like... Yes, of course, Professor.
My just 3 points as to Lemkin. Lemkin in 43 drafted a law for the Polish government, the exile government, and in this law he used for the first time the word genocide in Polish, and in 44 he used the English term. And in his most famous book, Axis Rule in Occupied Europe, which was published in 44, he of course referred to Armenia. This was a kind of historic reference as for many people, but I still think that the actual blueprint for the definition was Germany. So I do not deny, we can discuss this maybe. I do not deny that there was this historic reference, but I have read the book, Rolf. I'm not sure if you have read this book, the 1944 book, Axis Rule. That's a major book of Lemkin, and that's actually the work one should read if one wants to understand Lemkin's actual motive. But this is anyway not important. I just answer your question because you doubted, let's say, I didn't talk about Armenia because I do not want to get involved in this discussion. I have written about this, and maybe some of you have read my position on the legal issues, but that is not for me here to discuss this issue. Just reacting to this thing. But there is another point, as to Sari's concept of justice. I mean, of course, we have a discussion in law about normative basis of justice and law. I mean, this is a philosophical discussion, and if you take a very positivist view, it's a very French. I mean, if you have a lot of French influence in Lebanon, very different from the common law. Influence. Of course, we would say as international lawyers that human rights is our building block. That's our framework. And the Constitution of Germany, for example, is the constitutional framework of a constitutional liberal state. And therefore we have, of course, values like the dignity of a human being. That's, of course, our major value in our understanding of law. And therefore I would strongly reject any argument that what you a little bit, the suggestion that law is unjust as such, I mean, or justice is not guaranteed. We have to look at each case individually. The Mitterrand case is a good case where you can see that law would have guaranteed Mitterrand's fate, because the lawyer said, the judge said, that is not, has no offense character what he did. I mean, actually the French law in this Mitterrand case protected Mitterrand, but he was politically so much under pressure, he was fired anyway, you know. So that's political pressure. That's our media who are actually forcing upon us certain kind of populist moods where lawyers then, or judges, if they apply the law. Okay. You know, I mean, that's a philosophical discussion. I mean, for example, Hart and Radbruch had a big discussion if moral is part of law, but we cannot have a seminar now on legal philosophy. That's a philosophical discussion. That's not so easy. I mean, what is your concept of justice? You have Amartya Sen writing of justice as giving people equal opportunities. Amartya Sen, he's a Nobel Prize winner from India. So what is your concept of justice? I cannot just have a pillar and say these are the three things without explaining what's the concept behind it. So these are really tricky questions. I mean, we should not be so like the populists we criticize outside, Mr. Trump and Ms. Penn and all these people, and we are populists in the same way. I mean, that's not, in my view, it's not a serious academic approach. Anyway, speaking as an academic, you can not my, it's my position as an academic. And the third point is, I'm not so pessimistic as some here in this room. I mean, we have to be more concrete, or what are we talking about? I mean, there are injustices all over the world each day, but of course we cannot solve all these issues. Not a court, not the United Nations. That's too much. I mean, you can have over, as Damashka from Yale in the great paper said it, we have this kind of overabundant expectancies, over ambitions. We say, well, there is this court or this United Nations Human Rights Council, and they solve all the issues. That's impossible. I mean, we have to be realistic, but the first thing, and that's for the afternoon, we have to define concretely what we want to target. What are our aims? So what are actually the problems we identify? And I think for everybody, it is important to talk about their own society. That's why I always refer about my country. I can give you many examples where I think we have to change things in Germany. But it's up to the Lebanese, of course, to say what they change in Lebanon, and nobody talks about Lebanon. I mean, you know, who is interested in Trump here? We are in Lebanon. So what are the issues you want to resolve? For example, I give you one thing to think about. Why is Lebanon not party of the ICC statute? That's for the human rights people to make advocacy. I mean, that is in contradiction. Why do we talk the whole day about this, and Lebanon is not even party of the ICC statute? So you can say, I'm against the ICC, okay, that's a position, I haven't heard this. Or you say, we are not in because certain forces in this country are against it. But then let's talk about this. That would be, for me, an important function of your organization, to make advocacy with the NGO coalition of 5,000 NGOs, including Amnesty, Human Rights Watch, you are quoting all the time, national NGOs, and to work on the ratification of Lebanon of the ICC statute. That would be a contribution, an important contribution.
We were discussing, I think, yesterday about that with Dr. Boujadi. Thank you very much for this very interesting second panel. Thank you, Professor Ambas, Dr. Hanafi, Dr. Jardi, and of course our moderator, Mr. Wa'al Khair. I'm conscious of time, but yet, despite of that, we're 15 minutes above the time. So we're going to have 1 hour of lunch break, and we'll join for another interesting panel. And I would say, Professor Ambas, we're going to touch upon a lot of Lebanese issues, and probably we're going to go cut deep inside this topic. Sometimes probably we're going to go to some uncomfortable discussions, but I think this is the main point of today. So let's go on enjoying the lunch. Thank you.
طبعا
هونيك يا ماما. خلاص. شكرا أنيتا. يعني عرفتي عن عن المحاضرين. بعتقد رح نعمل مثل أول جلستين الصبح يلي هو إنه في المداخلات وبعدين نفتح الحوار. بدي أعرف بس أول شخص تعرفتوا عليه اليوم الصبح يلي هو بروفيسور أمبوس من ألمانيا من جامعة غوتينغن. Can you want to start?
Thank you very much. I think I can follow up on the discussion we had before and on the conversations during the lunch break. We are now talking about prevention, so actually we should now focus a little bit on possible measures, countermeasures against, I would use this word, atrocity crimes, used by the High Commissioner in this, in one of the papers, one of the documents after the responsibility to protect was decided in the famous Kofi Annan plan with the 4 targets. Atrocity crimes would include, just that we have the focus clear, what we are talking about, genocide crimes against humanity, war crimes and ethnic cleansing. I'm not sure that I'm convinced by this inclusion of ethnic cleansing in this list, but that's a United Nations decision. I have no, I mean, that's what they did. But it shows clearly what we said before, that ethnic cleansing as a separate phenomenon, rather. It's not really a crime as such, it's a kind of phenomenon. It happens, and it may constitute genocide if it's committed with intent to destroy, or it may be a crime against humanity if you have systematic and widespread commission and you have the individual acts of the crimes against humanity. And of course it could also constitute a war crime. So it's actually, that would be my criticism, under this atrocity crimes phenomenon. They have put together crimes, 3 crimes, which are clearly defined nowadays in the Rome Statute, but another thing which is rather a phenomenon. And there's also this discussion in social sciences, and of course some American colleagues, Mark Trumbull, who has a book, Atrocity, Punishment and Revenge or something. So this word of atrocity is also kind of a little bit, is it an advocacy word? So we are perhaps again in this kind of question of not very precise term, less precise than the crimes, because we have definitions of the crimes, and this helps us at least to get a certain orientation what we are talking about. Now, if we talk about countering these kind of crimes, if this is our aim, so if we want to diminish the international crimes, we had a discussion before in that one of the questions is, do we actually have progress in humankind? I mean, this question of if international law helps to make the world a better place. I mean, in this sense, that's a point maybe to discuss. And I said that I'm not so pessimistic as some other people. I think that international law, especially since the Universal Declaration after the Second World War, since Nuremberg, the international criminal law, international humanitarian law, human rights law, these 3 areas have developed very fast, and we have different mechanisms where we have different levels with different controls. We have a kind of rather political mechanisms like the Human Rights Council, we have the General Assembly, we have more legal mechanisms, the Human Rights Committee of the Pact of Civil and Political Rights. You have highly regarded academics, for example, Anya Seibat-4 or Yuval Shani from Hebrew University as members. And they are quite effective in calling states in the country reports, and you have an individual complaint mechanisms. And then we have this whole area of tribunals, yeah, where we, of course, have the ICJ, International Court of Justice, here very important, the Wall decision in this area. And we have the International Criminal Tribunals now with the Universal International Criminal Court. And so this shows the complexity already. I mean, we have these different levels, we have different normativity, we have really a very complex area of normativity, and many people confuse. They talk about human rights instead of talking about international criminal law. They say that humanitarian law is like international criminal law, which is not the case because it's just a primary norm. You cannot kill civilians in an armed conflict. That's a prohibition, but if to convert it into war crime, you would have to have an international criminal law provision, like Article 8 of the ICC statute. So these things are complex, and this is important to make these distinctions. And then the reaction mechanisms and the whole question of enforcement. Yeah, of course, the frustration comes from the lack of enforcement. If we say, someone said in the morning, why happens nothing in Syria? Well, it's very clear why not, because Russia vetoes any referral to the Security Council. I'm not from the United Nations, so I can say this. I mean, you know how this works. That's a treaty regime. The International Criminal Court is a treaty. You have to ratify it. This state has not ratified, by the way. As we said, Lebanon is not part of it. So there is no jurisdiction of the ICC in Lebanon, and not in Israel, and not in the United States, and not in Russia, and not in Syria. So the only way in such a situation to give the ICC a case would be a Security Council Chapter 7 resolution, which also is a question why the Security Council has this power, but that's another question. I can give you explanations if you are interested. The Security Council can refer a situation to the ICC. It has done so in the case of Sudan and Libya, yes? It has not done so in the case of Syria. You know that we have every week, every month, we have intentions by Britain, by the US, to have resolutions approved, and each time and again Russia vetoes. Or they don't even put them to vote because Russia says we will veto it anyway. And also referral resolutions. France has tabled a resolution. Every Western state has done it. It's in this case Russia. So in other cases, United States is a problem. So I don't want to put the blame on Russia only, but we have to be honest in these situations. It's not the responsibility of the International Criminal Court. The International Criminal Court has not even this case. It's not even in the jurisdiction. There is not such a case as Syria in the ICC. So this is an enforcement problem, which is a clearly Security Council deficit of enforcement. So the responsibility lies in Security Council. And we have to say this. We have to say clearly, is the responsibility in this case of Russia and China, which would, by the way, as a second guess, also veto. In other situations, take the case of al-Bashir, Sudan. We have a mechanism. We have a jurisdiction of the ICC. It was referred a long time ago by the Security Council. We have restaurants. We have many situations where al-Bashir traveled even to state parties, Malawi, South Africa recently, but he was not arrested. Al-Bashir does not travel to Europe because he knows in Germany he would be arrested right away because we are very compliant with the ICC statute. We have a law, a cooperation law, which even allows ICC investigators to interrogate persons on German territory without German police. We would have German police if there is intervention in individual rights. In France, he would be arrested. In UK, he would be arrested, as Pinochet was arrested when he made the error to travel for treatment to London. So he is traveling to certain states, and these states are states in Africa in this case, in the southern part of sub-Saharan Africa, and they do not comply with the obligation to arrest him. There is, of course, a legal issue if there is not immunity, and this is a tricky legal issue. We can discuss it. In South Africa has one of the reasons why South Africa said we are withdrawing from the ICC is this immunity issue. But at any rate, again, this is not ICC responsibility. Look, what can a court do? The court is working. The court is putting out in the restaurant. There is a process. The prosecutor applies for an arrest warrant. There is a 3-judges chamber, pre-trial chamber. They take it and say, yes, there is sufficient ground and there is a suspicion regarding crimes, and we put out an arrest warrant. This arrest warrant, everybody knows in this world. Every state has this arrest warrant. And this works with an Interpol system. Every state is informed that Mr. al-Bashir is on an arrest warrant of the ICC. So it's not a question of not knowing. I mean, every state knows. So it's a conscious decision of a state to invite Mr. al-Bashir. Take al-Bashir as an example, not that later Sudanese people tell me I'm against Sudan. That's not the point. I'm in favor of Sudanese people. You know, I'm against Mr. al-Bashir perhaps, but it's a case just as an example. I mean, no state has an excuse not to execute this restaurant, except the state says, I don't want to do it. Okay, then please be so honest and tell us that you like Mr. al-Bashir and you want to buy the petrol in Sudan, like China. We have a big photo. I was in China a few weeks ago, and I always talk with the Chinese about this. Look, you have this big photo of the chairman of the Communist Party receiving al-Bashir and giving handshakes. And, well, China needs oil, and al-Bashir has oil, and China builds trains in Africa. So you have a kind of win-win situation, according to Chinese media. And China receives al-Bashir, and China, of course, is not a state party and says, we are not obliged to arrest him. That's, of course, a different situation than with South Africa, or Germany, or France, or Jordan, which is a state party in this region, yes? So we, as state parties, would have to arrest him. Well, the fact that al-Bashir is not arrested, again, is not an issue of the ICC. It's not responsibility of the ICC. The ICC, from The Hague, in the nice building, are producing decisions, and they're sending them out, and then they depend on states to execute these decisions, or on the Security Council. Each year, the chief prosecutor, Moreno Campo, now Fatou Bensouda, goes to New York, tells the Security Council, you have referred Sudan to us, but you don't help us to execute the restaurant. So again, the Security Council is not following up. So the Security Council says, we send you a case. ICC, please take care of this. There's a situation of criminality. And then ICC says, okay, we are the little ICC, you know, small ICC. We have no police. We have no military. We need you, Security Council. If a state does not comply, like Malawi, South Africa, please impose sanctions. Mr. Bensouda goes, Ms. Bensouda goes. No, not any decision of Security Council, not any enforcement decision. We have so many violations of ICC obligations by state parties, not any decision of Security Council, and not even in the case when they refer. So Sudan, Libya. Libya, we have another problem, by the way, with the son of Gaddafi, who, you know, we have a big complementarity dispute in the ICC, and again, there is no support by the Security Council. In the end, the ICC is alone. The only states which would support the ICC would be the state parties. But even the state parties, we have this assembly of state parties which meets every year, 2 weeks ago in The Hague. They can also impose sanctions in non-Security Council cases, but they have not taken any decision to impose sanctions. So you see, the whole enforcement system of the ICC, which depends on states, is failing. That is not the ICC responsibility. It's the states who are, of course, as we said before, the makers of international law and the breakers of international law all the time. And they should enforce international law, but they don't even enforce their own rules. And the ICC then is made responsible, and we should be fair to the ICC. So that would be my plea for the ICC. I'm not working for the ICC, but I highly appreciate and estimate the colleagues who work for the ICC. People work very hard at the ICC, and I think we should be fair with the ICC. Now, this is part of a system. We are talking about the international criminal justice system, and here come the states in. In the Genocide Convention, it's a state who has a primary responsibility to prevent and repress genocide. Under the Geneva law, grave breaches, the states are responsible. We have the principle aut dedere aut judicare. Either you extradite or you adjudicate. So states are the primary responsible for the prevention and repression of international crimes. The ICC has been created by some states to have a complementary mechanism, to have a kind of complement, because, of course, states are not doing it, and so we say we need the ICC, but the ICC is complementary. It's not has no primary jurisdiction like ICTY and so on. And this international criminal justice system, which we are discussing internationally, is a system which consists then of the states. What Nida thought about is decentralized prosecution, which maybe is for you confusing, but that means that, first of all, the territorial state must prosecute. So, very concretely, Lebanon is responsible for the crimes committed in Lebanon. It's not the ICC, it's Lebanon.
Lebanon. State, you mean?
State of Lebanon. I mean, as a legal subject. As a legal subject, yes, that's a good question, but then we discuss it. You discuss between you as Lebanese about this, but that's a good point. But, I mean, legally speaking, it's the state of Lebanon. So, the responsibility rests with Lebanon. And that's why I said before, don't talk about Trump. I mean, nobody likes Trump, at least myself, but well, it's not our problem now. We have here a problem, we are in Lebanon, let's talk about Lebanon. I mean, you have to prosecute these crimes, and you have to decide if you want to ratify the ICC statute. Now, state can do it extraterritorially, like Spain or Germany, universal jurisdiction. We say we prosecute cases in, let's say, Argentina, because we think that the crimes are so heinous that we have to prosecute them, we have jurisdiction. But this is a big problem. We have done 2 cases recently in Germany, Rwandan case and Congo case, and this is very costly, this is difficult. A German prosecutor traveling to Congo not knowing anything, I mean, he doesn't speak the language, you have to get the witnesses to Germany. The same problem that ICC has, of course, to The Hague. There are so many problems involved in this kind of extraterritorial jurisdiction that it's not the best solution. It's really always a plan B. It's only a plan B. The best solution is do your own work at home. Do your homework. Because I think that's very important. I work a lot also in Latin America. It's about the whole system. If we criticize international law because it's a system which is not enforced, is the law enforced in Lebanon? I wonder. Is the law enforced in Colombia? Is the law enforced in Congo? I mean, the Germans have this problem. My German colleagues speak always of the lack of enforcement in international law. I tell them we have 190 states. In how many states we have enforcement of law in the world? Not talking about Eurocentric France, UK, and Canada. I mean, these kind of more or less operational systems, you know, where you have separation of powers, you have independent judges, you have judges, you know, independent judges. But let's talk about reality. And so enforcement is not just a problem of international law. The problem starts at home. So how can we ask international law to be better than ourselves? I mean, we ask these international judges, these poor guys working at the ICC, our friends, you know, please do something. We have a problem at home. But I mean, that's absurd. We should solve our problems at home first. And we must work at home. Everybody must work at home. That's why I said, as in the morning, we criticize Germany. We have to work in Germany. As German, I don't go here and say, what do we have to do in Lebanon? I'm not competent. But I can tell you what I think we have to do in Germany. So the point here is we have to be very honest in this discussion. What I don't like in these kind of meetings, I'm honest. I mean, as I said, I'm academic independent. We have to talk about our problems. It doesn't make sense to talk about the problems of the world. We have problems in our jurisdictions. And if we want to change things, we have to start here. From here, we have to start. And of course, civil society is a very important actor in such a situation. Then perhaps if we have a problem, then we can recite to the ICC or to international institutions, but we have to try first at home. But in the end, these institutions, take the Lebanon Tribunal, they will never get these persons, never. I mean, so what then in the end to create a tribunal which is not legitimate? People think that's a joke. You know, you have a tribunal which is working there. And I was in a meeting 1 week ago in Germany with lawyers, and they asked me, you know, there is this tribunal called Lebanon Tribunal. You know, is it still existing? You know, because one hears nothing, but they are still existing, receiving money, you know, and doing what? Because so in the end, you delegitimize international justice because you create a tribunal which cannot, by definition, it cannot work. It cannot
have protection in Lebanon after you leave the conference?
No, I leave it here. Enough provocation. Thank you very much.
Thank you, Professor Ambus. I'm sure there's lots of questions that are going to come up and points for discussion after your very interesting discussion and provocative discussion. We can now move to Dr. Abdulsalam Said Ahmed, who's the Regional Director for OHCHR. The full name of Office of the High Commissioner for Human Rights at the regional office in Beirut.
Thank you, and good afternoon, everyone. I had to leave not just for lack of interest, but for other urgent engagements during the day. Also, being it Human Rights Day, I would like to say that our motto or slogan for the Human Rights Day this year is about get up and stand up for somebody's right. قم ودافع عن حق إنسان هو شعار هذا العام، ويعني كل عام وأنتم بخير. أنا I will speak in Arabic. مرة ثانية هذه الجلسة عندي كم دقيقة؟
20.
أوكي. شكرا. يمكن. حتحدث بالعربية كما قلت. حقدم خطة عمل الرباط وأعرف بها، لأنه في اعتقادي يمكن يكون المعرفة بخطة عمل الرباط ليست بالقدر الذي المطلوب. يعني خطة عمل الرباط اسمها بشأن الحظر الدعوة إلى الكراهية القومية أو العنصرية أو الدينية التي تشكل تحريضا على التمييز أو العداوة أو العنف. هذه سميت خطة عمل الرباط لأنها تم إطلاقها في الرباط عاصمة المغرب في تشرين أول أكتوبر عام 2012. سبقتها 4 حلقات عمل دراسية انعقدت في مختلف أركان الدنيا، في أوروبا في فيينا، وكلها يعني في عام 2011. في شباط في 2011 كانت حلقة العمل الأولى في أوروبا، ثم تلتها حلقتي عمل في نيروبي لأفريقيا وفي سانتياغو شيلي للأمريكتين، وأخيرا في بانكوك بالنسبة لآسيا، وأخيرا في سانتياغو شيلي بالنسبة للأمريكتين كانت في تشرين أول أكتوبر 2011. ثم توج هذا المجهود في الرباط كما قلت عام 2012 الذي اعتمد برنامج أو خطة عمل الرباط بشأن حظر الدعوة إلى الكراهية القومية والعنصرية. الهدف من هذه الحلقات أولا كان إجراء تقييم شامل لكافة التشريعات والسوابق القضائية والسياسات العامة فيما يتعلق بالخطاب الكراهية، وكان يعني المؤدية إلى التحريض إلى العنصرية إلى غير ذلك. كان الغرض يعني إنه يعني دراسة للتشريعات وللقوانين وللسوابق القضائية على المستويات الوطنية والإقليمية والدولية. ومن ناحية كان يعني الغرض إنه بين إحنا يعني ما هو الوضع على الأرض فيما يتعلق بالحظر على الكراهية من ناحية، ومن ناحية ثانية كيفية عدم تعارض الحظر الكراهية مع الحق في التعبير. هذه طبعا معادلة صعبة. كان القصد ما يكون الحظر الكراهية على حساب حرية التعبير كما تلجأ العديد من الحكومات أحيانا من ناحية تشريعية أو من ناحية قانونية أو من ناحية التطبيق العملي. أنا بس أعيدكم يعني أعيد الانتباه إلى العهد الدولي للحقوق المدنية والسياسية. طبعا نص في المادة 10 الشهيرة اللي خاصة بحرية التعبير على التالي: لكل إنسان الحق في اعتناق آراء دون مضايقة. لكل إنسان الحق في حرية التعبير، من هذا الحق يدي في إماس مختلف ضروب المعلومات والأفكار وتلقيها ونقلها إلى الآخرين دون ما اعتبار الحدود، سواء على شكل مكتوب أو مطبوع أو قالب أو بأي وسيلة أخرى يختار. تستتبع ممارسة الحقوق المنصوص عليها في الفقرة 2 من هذه المادة واجبات ومسؤوليات خاصة، وعلى ذلك يجوز إخضاعها لقيود، ولكن شريطة أن تكون محددة بنص القانون وأن تكون ضرورية، وهذا أن لا يكون هنالك مساس بالحقوق الآخرين وسمعتهم. وحماية الأمن القومي طبعا هذه فيها ثغرة، حماية الأمن القومي أو النظام العام أو الصحة العامة أو الأدب العام، هذه فيها ثغرة طبعا. والقانون يمكن من سنة 66 لحد الآن تطور ما على كافة الأرض، لكن يعني هذه المادة 19 ولا زالت تتيح يعني حق التعبير بشكل واسع. المادة 20 من نفس العهد بتتكلم عن تحظر بالقانون أي دعاية للحرب. 2 تحظر بالقانون أي دعوة إلى الكراهية القومية أو العنصرية أو الدينية التي تشكل تحريضا على التمييز أو العداوة أو العنف. هذا مربط الفرس، يعني المادة 20 فيها نص على حظر التحريض على الكراهية، لكن الخبراء لاحظوا أنه يعني بقدر ما أنه القانون في كثير من الضوابط التي تنظم وتتيح المجال لحرية التعبير، وأحيانا أيضا يعني أحيانا تنظم هذا الحق، وأحيانا يعني حظر هذا الحق بوسائل قمعية إلى غير ذلك. لكن هنالك غموض فيما يتعلق بالمادة 20 باعتبار أنه يعني كيفية يعني ما فيش كثير إجراءات وتدابير قانونية تتعلق بموضوع التحريض على الكراهية، ما فيش عقوبات كثيرة يعني تطال من يقوم بالتحريض على الكراهية. هذه هي الإشكالية التي نحن بصددها. طبعا أنا يعني فاتني يعني أذكر أنه نحن نتناول هذا الموضوع في إطار هذا السيمينار باعتبار أنه التحريض على الكراهية تحت أي ذريعة كانت هو يشكل مقدمة لجرائم وعنف وجرائم ممكن تصل حد جريمة الإبادة الجماعية، خاصة إذا كانت التحريض على الكراهية يصل مرحلة التنميط السلبي أو استهداف مجموعة بعينها أو مجموعات بعينها، سواء كانت مجموعات دينية أو عرقية أو غير ذلك. طيب اللي توصلت إليه خطة عمل الرباط هو أن يعني يلجأ المجتمع الدولي وكافة الدول على الأصعدة الوطنية والإقليمية لتدابير بعينها ممكن تصب في حظر على حظر الخطاب التحريض على الكراهية. هذه التدابير تتعلق أولا بمجال التشريعات، يعني انتهاج أو اعتماد تشريعات جديدة إذا كانت مش موجودة في القانون أو الدستور تحظر التحريض على الكراهية، طبعا دون مساس، دائما دون مساس بحرية التعبير. ثانيا على صعيد القضاء، وثالثا على صعيد السياسات العامة. على صعيد التشريعات طبعا يعني ما حتكلم كثير، بس هي المسألة في موضوع التشريعات باعتبار انه المسألة واضحة. إذا كان في ثغرات تشريعية في أي بلد معين، سواء كان في القانون العام بتاع هذه البلد أو قوانين العقوبات أو نقص في الإجراءات الجزائية التي يعني ما فيش تجريم كافي مثلا لموضوع التحريض على الكراهية، لا بد من تلافي هذا الخلل واعتماد تشريعات تسمح بحظر التحريض على الكراهية بصورة ناجزة، بصورة قانونية، بحيث أنها تشكل ردع بالنسبة لهذا الموضوع. وبالتالي هذه طبعا مسؤوليات البرلمانات ومسؤوليات دول الأجهزة التنفيذية في الدول التي تقدم مشاريع قوانين إلى البرلمانات المختلفة، وهذا طبعا مجهود يعني كبير ويحتاج إلى أيضا نوع من النشاط بالنسبة للمنظمات المجتمع المدني المهتمة بهذا الموضوع، وحنعرج على هذا المسألة. نأتي لموضوع القضاء. القضاء هنا أهمية خاصة باعتبار أنه إذا كانت هنالك جريمة أو يعني خلينا نقول هي قد لا يعني في حد ذاتها ممكن يكون مجرد حديث، لكن إذا كان هذا الحديث قابل يؤدي إلى التحريض على العنف وبالتالي إلى ارتكاب جرائم ممكن يكون يعتبر جريمة وليس فقط مخالفة قانونية. وبالتالي دور القضاء هنا دور كبير ومفصلي في هذا المجال. هنالك يعني حينما تم نقاش هذا الموضوع وانه هي يعني كيفيه انه الشخص يلجا الى القضاء يقول انه انا تعرضت كعضو في مجموعه معينه او كفرد تعرضت لحمله يعني ليس فقط تمس بسمعتي او كده، ولكن انما تؤجج من مشاعر العداوه والكراهيه ضدي او ضد المجموعه التي امثلها. فبالتالي هذه المساله يمكن فعلا ان تشكل يعني نوع من الارضيه يتم التغاضي عليها على ضوئها. لكن كيف تحكم المحاكم في هذا المجال؟ هنا يعني تم اقتراح بعض يعني الحيثيات التي تمكن القضاء من النظر في قضايا من هذا النوع. المسألة الأولى تتعلق بالسياق. ما هو السياق الذي وردت فيه الحملة أو الخطاب الذي يعتبر مؤججا للكراهية؟ إذا كانت يعني السياق إذا كان فعلا يحتمل أن يخرج هذا ويؤدي إلى نوع من أحداث عنف أو كده، فلا بد أن نأخذ بعين الاعتبار. النقطة الثانية، من هو المتكلم؟ إذا كان شخص يعني له وزنه في المجتمع واعتبار، يعني مثلا زعيم ديني فلنقل، أو رجل إعلامي مرموق يعني لديه عمود يعني راتب مثلا في الصحف وغير ذلك، أكيد بيكون هنالك تأثير لما يقوله. النقطة الثالثة النية، يعني لا بد أن يعني تتوافر. طبعا الحكم على النيات صعب يعني بالنسبة للقاضي، لكن إذا كانت فعلا يعني حتى المادة 20 من العهد الدولي بتفترض أنه يكون هنالك نية. إذا كانت المسألة جات عن طريق إهمال أو كارلسنس فما فيش يعني مشكلة. المحتوى أو الشكل بالنسبة للخطاب أيضا له يعني اعتباره. مدى الخطاب يعني تضمن تأثير الخطاب وطبيعته العامة، كبر الجمهور، مدى يعني سعة أو ضيق الجمهور. النقطة الأخيرة في هذا في الاعتبارات التي يجب أن تأخذ بها المحاكم هي موضوع الرجحان بما في ذلك الوشوك. يعني إنه نفترض إنه مجرد ما حدا اعتلى منبر، سواء كان منبر مجتمعي أو منبر ديني أو غير ذلك إعلامي، يعني في احتمال إنه فعلا الخطاب يؤدي إلى يعني إلى أعمال بتاعت عنف. أنا أستسمحك شوية يعني أقل. هنالك طبعا يعني هذا يتعلق بقضاء. هنالك أشياء تصل بالسياسات العامة التي تقوم بها الدول سواء على النطاق الحكومي، يعني المقاربة غير التشريعية. هذا الموضوع المقاربة غير التشريعية ضرورية للغاية، لأنه هنالك مقاربة ممكن تقول عليها مجتمعية، وهنالك مقاربة إعلامية، وهنالك مقاربة تتعلق بالسياسات المختلفة التي يمكن أن تنتهجها الدول يعني بخطوات معينة في هذا المجال. طبعا خلصت البرنامج أو الخطة لتوصيات بعينها موجهة إلى الدول الحكومات تحديدا، وإلى الأمم المتحدة جهة دولية intergovernmental، وبما في ذلك المفوضية الإسلامية لحقوق الإنسان، وأيضا إلى أصحاب المصلحة الآخرين. وهذه أنا أختم هذه الجزئية. أصحاب المصلحة الآخرين طبعا يشمل قطاعات واسعة من المجتمع، منها منظمات المجتمع المدني، ومنها يعني المؤسسات الوطنية لحقوق الإنسان، فضلا عن الأحزاب السياسية والقيادات الدينية وغير ذلك. هذه طبعا بداية دور القيادات الدينية محوري في هذا المجال، وخاصة في العصر الذي نعيشه هذه الأيام وفي منطقتنا العربية تحديدا. الجانب المتعلق بالإعلام توقف عنده قليلا. طبعا الإعلام نحن يعني طالما من منطلق الحرص على حرية التعبير ما عايزين إنه موضوع حظر خطاب الكراهية يفتح ثغرة للمسألة بتاعت مسألة السنسورشيب على الإعلام بقدر الإمكان. لكن وبالتالي يظل التنظيم الذاتي بالنسبة لوسائل الإعلام هو أفضل الممارسات في هذه المجال. لكن هنالك اعتبارات لا بد أخذها بعين الاعتبار. أولا على الإعلاميين التنبه لأهمية تغطية الحدث في سياقه الصحيح وبموضوعية ودقة مع ضمان إعلام الجمهور بأعمال التمييز حيثما وقعت. ثانيا التنبه لخطر انزلاق وسائل الإعلام، لأن وسائل الإعلام طبعا ممكن تصبح جزء من المشكلة كما تعرف جميعا. عدم انزلاق وسائل الإعلام التمييز أو القولة والنمطية السلبية ضد الأشخاص أو الجماعات. يفترض أنه في إعلامي يعني يقدم تقرير عن يعني شخص لاجئ، يعني نقول في بلد ما، يعني قام بارتكب عمل إرهابي، وقام بعمل الريبورت من أمام معسكر للاجئين في هذا البلد. يعني كيف تتصور بعد ذاك ردة فعل الجمهور على هذا؟ يعني ممكن طوال مباشرة ينصرف يعني يعملوا صلة بين الناس الموجودين في المعسكر اللي هم ما يكون عندهم علاقة بالموضوع والعمل اللي تم ارتكابه في هذا. لا بد انه ايضا من ايضا الاعلاميين ما ينزلقوا مع المزاج العام في هذا المجال، بالعكس هم يفترض انهم يوجهوا الرأي العام طبعا كما هو متوقع. تجنب الإشارة غير الضرورية إلى العرق والدين أو الجنس إلى غير ذلك. لو قال مثلا في الولايات المتحدة الأمريكية لما يقول إنه شخص أسود ارتكب جريمة ما، مباشرة هذه المسألة ممكن تؤدي لعنف من قبل الشرطة ومن غير الشرطة ضد قطاع معين في البلاد. زيادة التوعية بشأن الأضرار الناجمة إلى غير ذلك. تغطية الأخبار المتعلقة بالمجموعات إعطاء أفرادها فرصة الحديث وإسماع أصواتهم بطريقة تساهم فهم قضاياهم وتعكس في الوقت ذاته وجهة نظرهم. أنا بس أختم أقول إنه مرة في صديق كتب قال إنه we want to be the news and the reporters at the same time. يعني إنه الأقليات مش إنها فقط تكون هي موضوع للإعلام، وإنما إنه خاصة في عهد يعني بقى القارئ والمشاهد هو بيصنع الخبر بالإضافة لأنه يكون متلقي الخبر. يعني بختم بأنه في نهاية الأمر تحقيق التوازن بين حرية التعبير وحد الخطاب على الكراهية هي مسألة دقيقة، لكن في نفس الوقت في ضرورة متزايدة وحاجة ماسة لتطبيق حظر على الكراهية بوسائل قانونية وتشريعية وغير ذلك وسياسات عامة وغير ذلك من الوسائل، حتى أنه نقدر نساهم في منع الجرائم وخطر الجرائم قبل وقوعها. وشكرا جزيلا.
Okay, our next interlocutor is Mr. Gilbert Doumit, who is the director of Beyond Reform and Development, and he is a lecturer at St. Joseph University.
Hello. I think it was very interesting. I'm going to tap a lot on what has been said. I think, unfortunately, it's a timely conversation for the region. Unfortunately, while we're speaking now and trying to figure out how to prevent human atrocities, something is happening now in Aleppo, in Mosul, in Yemen, in Libya. So while we're trying to prevent a lot of human atrocities are happening now, what can we do to prevent? And we're talking about prevention means the action prior to a human atrocity happens. What can we do? And my piece is around civil society, media, and public opinion. I will definitely not tap into any legal framework because I won't dare to discuss these issues. There are a lot of experts in the room, so I won't go there. I won't tap into theory. I'm going to tap into my own practice in the Arab world, what we've been trying to do to preempt, to prevent human atrocities. So I'll use human atrocities not to fall into the what is genocide, what is war crime, what is crime against humanity. I won't dare going there. So I will try to tap out of our experience, what we've been trying to do, and what can we learn from this, and why sometimes we're succeeding and sometimes we're not. Just to build on what Professor Ambus was saying, you know, it's a national issue. Why you cannot enforce the law on a national issue? We're not talking human atrocities in the world, we're talking in the MENA region. And I'll say things and we can discuss them later. We have no trust in any international legal or non-legal framework or mechanism to protect us in this part of the world, because it is a very political issue, and the international actors who sit within these mechanisms, in most cases, regional and international, have a direct stake, by proxy or directly, in the human atrocities. We cannot rely on them. And then we say, oh, let's rely on our national mechanisms. There are 3 types of countries in the Arab world. There are countries that are in wars, there are countries that are weak states in transition, and we have autocracies. So any reliance on local, national legal frameworks is also another discussion that could be interesting conceptually, but effectively, if I am at risk now, there is no place I can go, neither on international level nor on a local level, on a national level. So then what do we do in this case? I'm the product of war. I was living in the civil war in Lebanon, and as an individual, so these environments that are we're calling high risk are very volatile, are very unpredictable. So I used to wake up in the morning, go to school, so I was a good student, and then in the afternoon do some community service and the humanitarian relief, help the community, and at night I was helping the militias logistically to build their spaces, their bunkers. I was the same person. So also the framework, the lens we look at societies that are at risk, sometimes with the same framework where we look like at countries that are in good shape. So when we go and say, oh, we're going to go deal with the state. So when we say, for example, the Lebanese state, who's the Lebanese state? If someone can identify like who exactly we should talk to protect a community that's at risk, can we? So within all this, what can we do? So I'll try to build on a couple case studies. Want to say something as well as an intro. Okay, so I'll go from there. So why it's an unformula? So my presentation is called an unformula to prevent human atrocities. In my practice, has been very difficult to identify one way where we can intervene in a human system to prevent any possible escalation to human atrocities. So my presentation will be around the following. So probably just trying to frame the issue. When do we say we're at high risk? Is Lebanon at high risk today related to Syrian refugees? When can we say or we can't? What are the risk factors that we need to look at? People like me who are practitioners who live in these communities. So I work in 12 countries in the Arab world, and all countries are at risk. So when do we say we need to intervene? Most of the time, my interaction with international organizations, mechanisms, UN, we tend to come and say, you know, we've done it in Rwanda. Let's come and do it in Libya. Doesn't work. And I'll try to say why there is no one way to intervene. And this is why I think there is no formula. We should. It's an invitation to think of an unformula to deal with and the more systemic approach. I'll draw into a case, something we did in Lebanon, something we did in Libya, and try to get some lessons out of this. So if you're expecting any legal or theoretical discussion, probably I'm not up for it. I'm not equipped to do it. So is there a formula? Can we say this is the role of civil society media communities? How can we cope with unpredictability and volatility? The ones who used to be pro-peace in Syria are pro-war today. The ones who were in opposition are pro-government. The ones who were not involved are involved or less involved. What can we do? I didn't have a beard a year ago. Now I have a long beard. So how can we deal with unpredictability and volatility? What can we learn from Libya, Lebanon, and the Armenian genocide? So my premise, my original premise, we need to think of an unformulated atrocities. In our practice, we tried to identify, we did a comparative study between 4 countries, Libya, Tunisia, Yemen, and Lebanon, and tried to identify what are critical elements, critical factors in a context if we want to intervene in a moment prior to moving into serious human atrocities. So I'll elaborate on this in a bit. And we'll talk about what could be done. So looking at the literatures, did an analysis framework by OHCHR, and they identified 8 categories if a country is at risk, or a community or a human system is at risk. So if we look at these, we might say Lebanon is at risk. Forget about Syria, we are already there. Forget about Iraq, forget about Yemen, forget about Libya, we're there already. But for example, just because Lebanon, can we prevent, taking it as a case? So are there intergroup relations, some discrimination, human rights violations? Are there circumstances that affect the capacity to prevent genocide? So are there institutions? Are there mechanisms, judiciary, state? Is there a way? If there isn't, means we're at risk. Are there illegal arms? Are there armed groups? Is there any motivation of legal actors to encourage divisions? See, in Lebanese, Sunni, Shia, Christian, Muslim. We're talking about Lebanese context, we can talk about other countries as well. So is there a motivation? Are there circumstances that facilitate the preparation of genocide? Are there some factors, elections, we're going to elections? Are there other factors? We're talking about oil and gas. Are there some genocide acts? Are there some violent acts that are happening between certain communities? Is there evidence of intent to stop? Is there anyone saying, no, we need to finish with this community or with this group of people based on ethnicity, religion, color? Are there any mitigating factors? So if you look at these elements, they're good elements, they're good framework to say, oh, is Tunisia at risk? Is Sudan at risk? Is Egypt at risk? Is Lebanon at risk? So if I look at these, I would say Lebanon is at risk of human atrocities. In our practice, and it's a very complex model, so we compared four countries and tried to identify what are factors that makes each context very particular, that we need to study really well before trying to prevent any, before we do any intervention. So we're looking at the temporal element, history, violent or non-violent. The critical juncture, and we're talking about the uprising as one moment. Was it violent or non-violent? The post-uprising, was it violent, non-violent? Libya is different than Tunisia. Yemen is different than Lebanon. So each of these elements, so temporally, was it violent, non-violent? So is there a history of violence? And then we're going to look at multiple dimensions. So we're looking at 18 parameters. So we're going to look at the social fabric. Diversity, media. There was no media in Libya. So when we talk about media should be, whose media? There was no media. Media started in February 17 when the revolution started. Before that, there was just instruments for propaganda. And these media were all young people coming together. I met all of them. I worked a lot in Libya for 2 years in the transition. I'll talk more about it. There was no media. So these are critical factors. Lebanon has media. But also our media might be aligned with some political elite. So it's different. So civil society. Comparing Libya to Lebanon, there was no civil society in Libya. So how can we talk about civil society role in preventing human atrocities in Libya? It doesn't exist. There is a political level. Is there a constitution? Is there a political system? How does it work? Is there political competition? What type of political competition? Institutional frameworks. Is there a judiciary? There isn't, partially. Does it have capacity? What loyalties within? Security. Because like one small comparison, if we talk about Libya, Syria versus Egypt, Tunisia, it happened that Libya, Syria security apparatus were more trained on the eastern side, while Tunisia and Egypt have a security apparatus that is more western trained. So these two fell apart, the other two didn't fall apart. So we cannot treat as well security systems within these countries as the same if we want to intervene too. So the structure, the borders, so the geopolitics around it, the international stakes. Libya has oil and gas, Lebanon didn't have. Now we're talking about it. It's another factor that might contribute to higher risk factor. So international interest, is there international competition? Is there alliance? Is there congruence in agendas? History of relations? Already? I didn't start yet. Okay, I'll go faster. So we won't go into our analysis in both countries, in both cases. Just to give two cases where we try to do something, we cannot claim success, we can claim that we learned, at least. So for example, one of the exercises we recently did, we went into 25 municipalities on the borders of Syria, we've been assessing some risk factors that might trigger human atrocities. This was a project with UNDP. It was called Mechanisms for Social Stability. We went and we mapped the conflict. What are triggers that might generate higher tensions? So we identified 3 core triggers, which is different in another context. Cultural. So some Syrians are coming from rural, very rural areas. Even if they're coming to rural areas in Lebanon, they're not the same rurality. One places are more tribal than others. There are some relation with power, women, gender issues. So these were core. A lot of triggers of conflict were because of these issues. Another issue is economic, lack of resources, employment, competition. And the third one was security. How the security is dealing with Syrian refugees in formal settlements has been triggering a lot of animosity within these places. And then we went into, we want to know who's who in these communities, Lebanese and Syrian side. Who influences, who's affected, who needs protection, who can contribute, who can be part of. So we tried to go really in details, in really understanding human dynamics. And based on this, we designed with the different stakeholders a mechanism that we call the Mechanism for Social Stability that was based on 3 parameters. So we're going to create social cohesion, we're going to create economic inclusion, and we're going to create human security. While knowing no international legal framework will help, no state institutions can help. The only one that we can rely on is the municipality for the time being. So it was within municipalities. We created these 3 committees. On the cultural side, we helped establish an early warning, early response. So help a committee of Syrian Lebanese network on the local level and try to assess where are their triggers of tension. And once they have an indication that this is increasing, they need to intervene prior to something happening. So we try to establish in these, and this is all within the municipality umbrella. Municipalities do not have capacity, so this is why we try to create these committees within the umbrella of the municipality, but not from municipal. Sometimes members were involved. So another mechanism is economic. So how can we create economic mechanisms so that we diffuse some tension coming from, so we try to create this social innovation. So what our problems are in your community? Go call people for innovation. The municipality will host you within the municipality to come up with economic opportunities. So an education project to generate income or revenue or whatever. And that was create a lot of positive interaction between both communities. And the security level, we try to do the same, creating some information management, but it's based on proximity. One of the reasons in our assessment that's keeping petty crime low is that we know each other. We're small communities. Everyone knows everyone. So making use of this, use this proximity to create local networks where information is fed prior with an assessment tool. When do we say there is a risk of violence? And some interventions would be soft, go back to cultural, or some interventions would go direct to security forces and create this better information management between the local and the security. And the last thing we did, we tried to push the media in covering only positive stories. So, and you notice probably the last year or two, a lot of good news are coming from these interactions. There are still some news about problems, but at least we're balancing now. If you watch the news, at least in every 10 stories, negative stories, there are 5 that are good stories. We've been pushing a lot media to accompany it. On the Libya level, I think I don't have time anymore. I can elaborate. We did something similar, but it was a new social contract for Libya. So when we went to Libya, we understood that, and I went on June 2011, before the fall of the Gaddafi regime. So crossed from Marsa Matruh to Benghazi, a 12-hour trip, no state, all militias. It was a beautiful experience. Spent two years there. We mapped every stakeholder, everyone, and we brought 2,000 people on the table. We made them all sign a new, like the principles for a social contract. All this fell apart in September 2015. Because I think one component we missed is, we missed, but also we didn't have the capacity, how we're going to engage the international stakeholders. Everything we did flipped because the international actors who are supposed to prevent human atrocities had competing interests. Though we had constitutional briefs, we sat with the committee of the drafting committee, the committee of 60. We engaged everyone. We identified the core issues. We realized that citizenship is a new issue, is a new concept. Democracy is a new concept. So we massively did a citizenship education program and dialogue skills, and invited everyone to dialogue around these issues. It was beautiful. It flipped in 2 weeks because we couldn't engage the international actors. Closing remarks very quickly. Context. To prevent, we need to understand that contexts are very unpredictable. Means when we want to prevent, we need to be as adaptable as the context we're living in. We cannot look at citizens groups who are going to engage as civil society, private sector, government. They do not fit. It's very volatile. The wise men in Libya were more influencing than any other stakeholder you can imagine. Peace is a result of a process, a contextual approach. Engaging maximum number of people is important, and sometimes it's the most difficult. Social media today is a double-edged sword. It can be used, and we used it massively in Libya and Lebanon in order to create positive momentums. It can be used for manipulation. So also we have to be careful about this. International interest is one area it's very difficult to influence. In the MENA region, I think this is, for me, is what keeps me awake days in, days out. How can we develop new tools? Sustainability of these approaches in very volatile contexts is very difficult. Some questions in the end. What should be the role of international community? How can we engage it? In the MENA region, we lost it so far. What could be the role of social media next phase so that we keep it a positive tool? How can we rethink civil society in general while civil society is transforming into NGOs who are funded by the international community? How can we rethink what civil society is in today? Thank you.
Thank you. Thank you. I think we've had a very well rounded up panel that gives us a good idea of the complementarity and the need for complementary mechanisms and issues and indicators and legislation and different tools, really, not only to address crimes that have taken place, crimes that are taking place, but as we've seen also what has to be set in place to prevent crimes. So we've had Professor Ambos, who was defending, if we want, the international mechanisms, international legal institutions such as the ICC, in terms of us, of course, not having to blame the ICC for crimes that are happening today. But when the ICC was created, I think it was also created with the international community's main message of saying never again. And obviously this message today, with what is happening today, especially in Syria, Syria lies at the crux of all of these questionings that we have today. It is about whether the international community is retracting from that promise, from that commitment of never again. Of course, it's not the international community or these mechanisms' sole responsibility to prevent atrocities from taking place or to find justice to the victims of these atrocities. And there are different tools that we've been listening to this afternoon. We've heard about how do we analyze the context to be able to detect indicators that could lead to atrocities being committed. And in this, it's important to bear in mind the role of media and civil society, not only in terms of prevention, but also in terms of facilitating and setting the stage for legitimizing crimes that can happen. The role of public opinion in setting the stage for these crimes that can happen. In Lebanon, it's something that we are very familiar with, I think, and what is worrying in Lebanon is that these same indicators that happened, that were present in the early 70s, are present today. They were present against the Palestinian refugee community that later allowed for the commission of crimes to happen against Palestinian civilian refugees. Today, we are starting to see some of these same indicators with regards to the Syrian refugees. So it is a very acute problem, even if we don't have at this stage crimes being committed. The plan of action, the Rabat plan of action, is one very good example, very timely example of what kinds of initiatives are also there and at our perusal with the very sensitive and delicate and important tension that can exist between the abuse and misuse of these kinds of legislations that can be used, especially in our region, where these types of laws have been used to crush dissent and have been used to silence activists to their governments. I think we can open the room for discussion, take questions.
It was very clear.
Or comments, if you have. Please.
The issue of self-reliance mentioned. I think it requires, it's a matter of culture in this area, matter of culture in all the MENA areas. It's a culture that prohibits critical thinking. It's a culture that accuses the other of any mishaps. The other could be other countries, or it could be other entities within the same country. And actually, the killings or the genocides or mass killings that happen, they happen because of this kind of accusations. The case of the Armenian genocide is an example of that. This is a culture in the area. And this culture is stemmed partly from some religious beliefs that prohibit critical thinking, that prohibit questioning, and it's deeply rooted in the mind of the people. I think this cultural issue is a main issue that have been just maybe peripherally touched in this. I was expecting that this issue be more thoroughly addressed. And this culture leads to the lack of the citizenship concept. In all these countries, in the MENA countries, we don't have the citizenship concept. We don't have citizens. Citizens that share together same values, same benefits, same outlooks. We don't have citizens. When you don't have citizens in the country, but you have different groups, and you have this mentality of accusing others of all the mishaps that happen, naturally you will have always very, very deadly conflicts. I think the issue of citizenship is a major issue that should be addressed in this kind of panels. When you have the understanding of citizenships in a country, of the sharing of common values, there will be always conflict, but these conflicts will be mitigated and all through dialogue. But if you don't have that, then you can go to any kind of extremism. And this is, I think, the major drawback of all the countries of the MENA. Thank you.
Thank you. And I think this was raised also by Gilbert, who was saying that one of the main problems is this lack of trust, not only in international mechanisms, but in our own national representation. Referring back to Lebanon, the Lebanese state's responsibility, for example, with regards to the 2006 war, the Lebanese state took no initiative that it had the power to do to find justice within the international system for the crimes that happened in Lebanon, and yet the parliament had the power to take this kind of action. So the lack of these kinds of responses by our representatives are very detrimental to the relationship of trust between the citizenship and that sense of building a citizenry identity and its relationship with the state.
It's a very critical issue, the issue of religion and Islam and the role of Islam in the violence. I think it's a very, very critical issue. My take on this, I think we cannot see what's happening now irrespective of at least modern history. I don't want to go into a political discussion, but if we look at our governance systems, our political systems, since the 50s, 60s, 70s, we've been living under dictatorships since then. These dictatorships would have fallen apart a long time ago if they weren't sponsored. Hosni Mubarak wouldn't have lived 30 years if he wasn't sponsored. The Assad family, same thing. Jordan, Iraq. We lived in there was a nice article by Condoleezza Rice in May 2009 in Foreign Affairs, when she says one of the mistakes we did in foreign policy, we compromised democracy for stability. So we've been living in dictatorships. I cannot be accountable for the dictatorships we lived in because I didn't have the choice. When we went to the uprising, we lost any form of state, and then there is no justice in order to control crime. So the same criminals that we're seeing now in other countries, they're criminals. In our countries are institutionalized, whatever groups that we call ISIS, Nusra, and so on. If we look at the numbers, how many ISIS members from the Arab world? 100,000 out of 330 million population. I think in terms of number of criminals, it's low. It has ideology. All crimes in the world have ideology. I know that this is a very touchy subject, and I wouldn't claim that what I'm saying, but I think my take on it, I could have been an extremist as well. And I was, during the Civil War, I was one of the extremists, and I was organizing with what we call today radicals. I'm not anymore. There was a moment that helped me feel less fear and probably be exposed. So I'm afraid of accusing a religion and the culture because as if we're perpetuating. We want to fight in this. What we want to fight now is genocide, is putting people in a box because of religion, and then perpetuating the same mindset because of the fear we have. That's my take. No, it's a touch subject. Sorry.
Questions, comments? Yes, please. We'll just wait for the. Okay, so.
I have a comment and a question. If you look back history in Europe, every time we have crimes and genocides, it's because of multiculturalism and multi-ethnicity in empires or in countries, and they are caused by intolerance. And the solution was whether we divide the empires or we create like the European Union to avoid another genocide or mass crimes. Do you think that in the MENA region, where the question of minorities and the fact that the minorities are stagnant parameter, meaning we can't have states without this religion and pluricultural issue. So do you think that we should divide again the Middle East according to the confessions and to the minorities, so we could have peace and so it could be a way to prevent atrocities, or is it possible to create like an Arab great system or union where we should impose to Islam and to radical ideologies the fact that they have to respect some rules, otherwise they will really be punished by international law or international institutions? What could be the situation? Because if we can't have public governance to avoid conflicts, so what could be the solution? Because a solution should be found, because now the conflicts are more and more increasing against minorities.
Okay, thank you. I think we'll take a few questions and then we'll have a round of comments.
Thomas Schellen, Executive Magazine. I have a question to the two gentlemen to your right regarding the incitement of violence and social media and media. And as an observer of the Lebanese situation from half outside and half inside, I think there is evidence, ample evidence of incitement to violence and hatred in Lebanon that happens both in media and in social media, in online discussions and so forth. I wonder if it is possible to limit this kind of incitement with legal means, with procedural, prosecutional means, or if it would be counterproductive to limit the debate and drive it into some kind of underground where incitement still goes on, honestly, in Lebanon all the time, but is not actually brought out in the open. Thank you.
The lady with the red scarf. No? Oh, okay. Any questions? Yep.
Hello, good afternoon. I just wanted to ask whether historically or even now present to Dr. Ambos, do you still think that ICC is some sort of a utopia that we have to aspire and look for, or this is something that can happen, given even the historical history of the ICC? We never saw actual justice being prevailing after it. Just your thoughts on this, please. Thank you.
Okay, we can. Please.
Thank you to the commentators and speakers. I have just a couple of comments. Actually, the first, the gentleman actually who spoke before this round about Middle Eastern culture, and I agree with my colleague Gilbert here in the panel, that I don't think we would like to risk also stereotyping in any, no matter the justification, because at the end of the day, really it is very hard to identify a coherent, what you can call a Middle Eastern culture. There are commonalities, but there are also internal differences. I mean, if you take the region from the Arabian Gulf to the Atlantic, you will find plenty of differences, but also there are common things in terms of language and religion, and I guess it It's always useful to look at culture as a dynamic entity and a dynamic process, and not a kind of a static entity. Despite the fact that, yes, it is true, there may be some kind of hegemonic or traditions that are not helpful for tolerance and coexistence. That is true, which is happening here, and it is happening in other regions of the world. I mean, every culture had its dark side, had its bright side at the end of the day. Every religion has an enlightenment aspect to it and had a conservative aspect to it. And every tradition also has something to look for for inspiration and something that you would like to forget. I think we should be we should try to be more open in this. I mean, we should try to look at it in a kind of, if you like, a comprehensive approach. Because if we want to promote international human rights as an international value, regardless of cultures, etc., then everybody in the world is the same, had the same rights, had the same, and should have the same responsibilities to defend others. And we should strive to find a way that diversity should be an enrichment and not a problem. And that also touches on the issue of minorities. And the lady at the back, I don't believe the solution is whatever, if that is something that is United Nations or the Security Council, whatever I would like can do or cannot do, redividing the region is the solution. Personally, I don't think it is a solution. And as a human rights person, I believe the solution is that there is a shared space in each and every country, in each and every village, in each and every town that should accommodate everybody, no matter how big the population, no matter how diverse the population. That is the solution, in my opinion. It is idealist, yes, because we have to be idealists. We have to have some ideals. Otherwise, then we have no difference. We cannot really claim to be human beings if we don't have ideal that we should strive, even if the reality is awful, as it is now, actually. But we can only step back and try to look back beyond this reality. It's not a question of light at the end of the tunnel, no. But there is big problems need big hopes, definitely. Now the question of incitement to hatred and violence, definitely it is prevalent in Lebanon. It is prevalent in other countries in the region. It is prevalent in social media, wherever you find it, and social media has no geography, definitely. What to do with it? It is a challenge. Legal measures and criminalization doesn't necessarily solve the issue in a way that, because also it opens a loophole and it opens a way for censorship in the sense that there are countries in the region here have something that they call الجرائم الإلكترونية, electronic crimes or internet crimes or digital crimes, if you like. And this is something that most of the time they go after human rights defenders, for example, after digital anybody who is active on social media in order to say something and to make their voice heard. But in the same way that there are people using the social media for good, there are people who are using it for evil purposes, deliberately also. And so one of the solutions, definitely, states can look into some measures to do. These measures can be either legal or policy or executive issues. Some of the countries have established agencies or authorities that look into audiovisual monitoring. In terms of you monitor, you have an agency that could be a government agency, or it could be an autonomous independent agency that is funded by the government but not a government body. But the responsibility of that agency is to monitor what is being in the social media, and and then work with those who maintain the various websites and this kind of thing, of what to do with it, and And that is something that can technically also can be done somehow. And of course, for various groups in the social media, various institutions, I mean, like those who own and manage WhatsApps and Facebook and this kind of thing, also they have a responsibility, definitely. They have a legal responsibility, and they have a responsibility to elaborate guidelines in terms of usage. And definitely governments and also international agencies can also reach out to this institution that they should elaborate guidelines that should not in any way and form encourage or tolerate incitement to hatred and violence.
Thank you.
Maybe 3 comments. First of all, thank you very much for all your comments. I think this is very complex area. As to this question of the Rabat document, I think that there are 2 levels to distinguish. First is this normative level. Can you ever have a succinct and unambiguous definition what is criminal and what is not criminal? Yeah. And if you look at the document at page 4, I just looked it up in the web here. They have a 3-fold distinction, so very sophisticated, between expression that constitutes a criminal offense, first level, expression that is not criminally punishable, but may justify a civil suit or administrative sanction, the third level, expression that does not give rise to criminal, civil, or administrative sanctions, but still raises a concern in terms of tolerance, civility, and respect. And then there's actually a 4th level, expression which raises no problem. So actually it's 4 levels. And imagine you must make a criminal law on the basis of this, because this must be implemented. If you have a national legislator, a parliament, and I haven't seen these criminal laws. I would like to see them if states have implemented this, if this is really something you could, from a rights perspective, accept. And especially as we know that criminal law is very dangerous. Criminal law is an instrument of oppression. I mean, we have to be realistic. As a criminal law academic, we are always very restrictive with criminal law. We normally, German law professors would always say, don't use criminal law, only if there is no other means, because we know that criminal law is an instrument to oppress. And so at the normative level, you would really have to see how states in the region, if they implement this, have made criminal laws on the basis of this. And then one would have to analyze these criminal laws against human rights, right of liberty, expression, and constitutional parameters in the countries. And the second level is the application of this kind of laws in systems which are not totally democratic, or where you have no separation of powers, where the question of recruitment of judges is highly difficult. I work a lot in Latin America, and the big issue is not the law, but is a person who applies the law. So if we have a judge who is actually a kind of prolonged arm of the executive, because you have no clear recruitment system of judges which is not politicized. I mean, you have not really an independent judiciary, then you have a big problem in the system. And so separation of powers, real separation of powers, judicial control of the politicians, actually, is very important in the system. And therefore, it's tricky. It's tricky. I mean, I understand this. I understand the concern that you should not have hate crime and hate expressions and using Facebook and so on for hate. But the question is, can you ever capture this with criminal law? That's the question. I'm very skeptical about it, and especially in regimes which are not transparent, which are not democratic, where you have perhaps no independence. So I have certain problems with this approach. The second issue, the role of the international community, I think Gilbert's point is very important, and that's why I'm very, very reserved about this whole international intervention stuff. And I can totally agree with you that a lot of these interventions, especially military interventions, are totally counterproductive. I mean, we can see it in this region especially, and against this background, there are people who say, let's go for the legal intervention, in inverted commas, and compare, for example, the cost of an international criminal court with the cost of one-day German soldiers in Afghanistan. I mean, we have to ship all the food for them to Afghanistan and not other things. So it's more costly to have our soldiers in Afghanistan. And what's the effect? Practically none, or it's even counterproductive. So this would be, and then I would say I have looked at your organization, for example. I also used it. You know, I did my research now. When you talk, you have supported and get support by UK Aid, US Aid, GITS, and so on. And I would say yes, if we do this stuff, then support this kind of organizations. So local civil society organizations who make important projects, and then give money to them instead of putting money into interventions which are basically pursuing interests of major powers. I mean, that's it. If it comes down to it, it's a little bit superficial, but if we are looking critically in these things, all these interventions are personal revenge, like the Iraq invasion, invasion of Bush. I mean, it's in the end, it doesn't help us. And then what would be the alternative? That brings me to this ICC question. I mean, it's a very interesting phenomenon that the Palestinian Autonomy Agency and the Fatah movement has used the ICC and has changed the practice in the last 3, 4, 5 years, and has tried to use legal avenues to get whatever. I mean, you know, state would be maybe too much, but anyway, something, you know. And so they have actually within United Nations, outside United Nations, invited experts, and they have used especially the ICJ on the one hand, you know, the Wall decision, which is not enforced, by the way, by Israel, again, enforcement problem, and the ICC. Palestine has made a declaration to accept the jurisdiction of the ICC for certain situations, and has even ratified. So imagine this, Lebanon has not ratified. Palestine, having now a status of a state after the General Assembly resolution, non-observer state, at least this kind of legal status, has ratified the ICC statute. I mean, there is a problem, as you better know than myself, in Palestine, and who said it? I think that the Palestinians don't know what they want, and anyway, they have, at least this part of the Palestinians has done, we go for the legal avenues, and not only in this area, and that shows this hope which creates the ICC. So I think the ICC, of course, is for many, many people in the world. Palestine in this region is important, but also in Colombia and other areas where I work, where the ICC has not even opened a formal investigation, where they are only in kind of preliminary examination, they are observing, they have jurisdiction. Colombian peace process with the FARC now. ICC was on the table all the time. ICC was in the room, the elephant in the room. There is jurisdiction, but there is not a case against any Colombian, you know. But the fact that the ICC could open a case and the situation was very important. And in Colombia, when they made this deal, we talked about this amnesty during lunch here. This is impossible. In Colombia, they didn't do it. The Colombian peace agreement, 300 pages, clearly says international crimes cannot be amnesty. So the FARC have accepted. I mean, the oldest guerrilla group in Latin America, that they will be submitted to a system, just judicial system. They may get 20 years punishment. This is something. Compare this to this region in terms of armed conflict, where you have a kind of process where someone would be happy if you had any decision against certain human rights violators in this region without prison. I mean, just have recognition, you know, just have a decision where some judges say, okay, you violated human rights, please accept. Okay, I accept, we don't send you to prison. And in Colombia, you have 20 years as a consequence in the normal procedure. And that was ICC. I mean, both parts in the Colombian peace process have always said we cannot violate the ICC standard. And this is something which people do not realize because they only look at production of judgments. People reduce justice or criminal justice to the production of judgments. But if you go to the website, on the website of the ICC, you will see the ICC has different levels of intervention and has a series of decisions which are pre-judgment. So most decisions on complementarity with Libya right now are pre-judicial decisions. So there is a lot of production of law and there is a lot of discussion. Each day we have news from the ICC. We will have in March a meeting with South Africa regarding non-cooperation, the rest of al-Bashir and so on. So in effect, this is a momentum. This is a very important institution with very many limitations, of course. It will not resolve the Palestinian-Israel conflict, far away from it. But it may perhaps resolve the criminal issue of the flotilla incident. You know, I mean, you know what happened. So this is a case before the ICC, which was even by the pre-trial chamber already considered. This is maybe a drop in the sea, Yes, but it's something. I mean, we can always say it's easy to criticize all this. You can say ICC doesn't operate efficiently because he does not go after Assad. But come on, I mean, he cannot go after Assad. It's ridiculous, this criticism. So please understand the institution and then say, for example, internally they could be quicker, stuff like that. That's okay. But the institution as such does what it can, and it's efficient with the limitations, the inbuilt limitations, intrinsic limitations of an institution of international law. But it's something, and it's one thing. And another building block is civil society. Absolutely. What you do here in Lebanon, absolutely. What you do, your organization. This is of course, much more important. From the bottom. So we have to work together. That's why I'm talking of this system. It's not just the international criminal justice, it's an international system. Why do we have the most important coalition of NGOs is ICC, and then climate change, Paris Convention. That's another one. So the most important civil society movement in the world has been the ICC. We had a situation where Open Society, for example, financed the participation of African delegates because the countries did not have the budget to finance the participation in New York because it's very expensive. And so we had, from the first moment in New York in the 90s, there was full support by foundations, you know, to help states to participate, and NGOs participated from the first moment. And this is a success story within our history of mankind. I mean, it's still a baby. It's just 10 years old, through 30 years in practice. But we are better off with the ICC. I mean, we should be clear with this. It doesn't solve everything, but it's a contribution.
Can I ask a question? Yes. But because usually when we look at ICC, it's related to states, so it should be ratified.
Yes, by a state ratified.
So now we're seeing war crimes, genocides that are done by non-state groups and that we know nothing about. So if the ICC want to intervene now in Syria, it's ratified, we decide. So who are we going to hold accountable when ISIS and Nusra are doing it? Who are the individuals? We don't even know them, and it might be on a very local level, and they killed a couple of thousand, but we don't know them because they used to be here. So who are we going to hold accountable? How ICC can?
It's natural persons, and natural persons either organized in a non-state actor or in part of a state. That's not a problem. I mean, effectively, the first cases have been paramilitary groups in Congo. So you know, Lubanga. So that's not so much the issue. The issue is you have jurisdiction. If Syria would ratify, I mean, let's dream. If Syria,
can I ask
or you could and yet you had territorial jurisdiction. The point is, let's make things easier. I mean, if it's territorial jurisdiction, if Lebanon ratifies, everything what happens in Lebanon after 2 months after ratification, entry into force, would be jurisdiction. Any international crime by any actor. It's not limited.
So just on the responsibility of states and domestic jurisdiction versus international jurisdiction, the case of Lebanon is quite illustrative because when the momentum came for the creation of the Special Tribunal for Lebanon, from a Lebanon perspective, the demand for this tribunal was not necessarily to prosecute the crime of this particular assassination. It was really a more global call for identifying who was responsible for the long series of crimes that had taken place and the long legacy of the Syrian occupation in Lebanon, a 30-year occupation. So this was the tip of the iceberg that created that momentum for the creation of the STL, and it was mainly grounded in a call for the truth, so knowing the truth, which is one of the aspects that we do tend to look at in courts, whether they are domestic and international. But one of the detrimental unintended effects of the creation of the Special Tribunal was that it gives us, as citizens, the impression that the Lebanese judiciary felt that it had no more responsibility because the STL is doing the work on the investigations. And instead of having this kind of complementarity, with also what we were expecting to see in terms of judicial reforms with regard to the abolition of the death penalty, with regards to the pre-detention trial periods, etc., we get a sense today that the Lebanese judiciary has its hands off, or is just cooperating when it's being called upon by the STL, but not itself initiating the investigations that are needed. Another question I wanted to raise with you with regard to the IC is that, yes, you said something that is really at the heart of this discussion, is that today there is a system that is failing. One of the representations of the system was the creation of the ICC, which was supposed to prosecute crimes when national states couldn't do that, but also it's supposed to have a deterrent effect, which today we are, I think, in good posture to have a very strong question mark about this deterrent effect. In Syria, we know what's going on. There is no issue of revealing the truth. The Syrian civil society has been incredibly active in this regard in not allowing us to say at any point we did not know or we do not know what's happening. But what is interesting in the dynamic today is that it is exposing the failure of the international system in the sense that we know everything that's going on, and what can we do? It is the fact that the ICC is still linked to a political will means it's the biggest challenge today that we face with. And my question here is, what can civil society in a trans-global civil society do to address this problem? Because obviously it will remain a systemic problem. And what is the role of the states of the General Assembly in addressing this issue? So there have been calls for veto restraint. What is your opinion about this? How realistic is it? There have been some initiatives within the General Assembly, but they aren't gathering momentum. What is the role that civil society in different countries can play in building momentum anyway for this kind of systemic reform?
So, as to the Lebanon tribunal, independent of the statute of the jurisdiction of the tribunal, of course, Lebanon is responsible for the crimes. That doesn't change with the tribunal. You can have 10 tribunals, it wouldn't change. This is a primary obligation of the territorial state. And in the ICTY system, we had a very close cooperation between Bosnia-Herzegovina, former Yugoslavia, and ICTY. You had even deferral of cases, i.e. you did not only take cases, that was when it started with the Tadic case, but then you deferred cases back and you created a parallel system on the local level with the help of the international community in this case. But it's no excuse for a national judiciary to say, well, we have an international tribunal, and therefore we are no longer able or competent to do something. They are still, they should still do something, and it's also always a limited jurisdiction. I mean, it's temporally limited, and it's limited in terms of ratione materiae, because you will only cover international crimes. In this case, we have the relationship to the Lebanese penal code. You have a special relationship, but still you have a much broader jurisdiction, because the whole Lebanese law is applicable under the Lebanese system, and therefore it is broader than under the STL. So this is no excuse. As to the international level, again, I think the first thing to do is to I mean, it's maybe utopian to ask you to get the ICC treaty ratified in this country, but that would be my first thing. What I would do if I were Lebanese, I would work for this, and then we can speak about how can jurisdiction be triggered, you know, and that would be either by proprio motu, but you don't depend on the Security Council. The Security Council is a mess. If you depend, and that's in Gilbert's thing. I mean, that's a mess of the messes. I mean, the Security Council is just a frustrating thing for everybody who works in this area. So don't rely on the Security Council. You know that the reform has been proposed years ago, and it was blocked. I mean, the Security Council is historical as to the permanent members. There should be India in this, Brazil, South Africa, and not France and UK. I mean, this is just a ridiculous historical legacy of the Second World War, when these countries still were important, but France, UK are not important major powers as the other three. But you don't get the reform without the five. That's a problem. And therefore, you will not have a reform. And the General Assembly, legally speaking, can only make soft law, and they can have resolutions. And in the case, for example, of Palestine is not full member because the United States said we will veto this. It went to the Security Council. Palestine went to the Security Council. Germany, by the way, I mean, I'm German, but Germany abstained on this. You know, we have this problem with, I suffer from this also in Germany. I could tell you things so difficult to criticize Israel in Germany, but our government in this area is not consistent either, because there will be never ever a decision against Israel with the support of Germany, and the decision against Israel is a decision to accept a statehood of Palestine in the Security Council. And this was blocked. It was not even put to vote because the United States says we will block it anyway. So then they went to the General Assembly, and the General Assembly only can give you this non-observer status. It's a lesser legal weight, and in other situations, the General Assembly can only make a resolution which is at best soft law. And so we are all the hostages of the Security Council. That's the truth of the matter. No, that's the sad truth of the matter. Of a historical, I mean, a German responsibility again. If we did not start the Second World War, this whole situation would not have developed like this. And imagine these arguments always that the General Assembly decided in 46. Who was member of this General Assembly? 46 states, come on. That's ridiculous. Even by international law standards, some people say, well, we had in 46 this General Assembly Declaration, Nuremberg Principles, or Genocide Convention. This was not at all representative. Today, at least, we have all the states in the United Nations system. That's okay, but at this time, this was still a kind of colonial colonial system. I mean, so what is the legitimacy of such a institution? The Security Council is still like that.
Yeah, we can take one more question and then we'll wrap up.
Well, I will be quick. You know, we're assuming that they are states and they are authorities. If we take this Near East today, unfortunately, we're in a position, let's take Lebanon, we're almost not a nation anymore, and we are not a state anymore, because the same thing in Syria, except for Jordan, most of the countries of the region, there is no more the will of the people to live together. Practically, they are being forced to live together, but deep down, when you go back home, you think that people do not want to live together, and the states usually are dysfunctional for various reasons, corruption, political influence, power, and so when we say acting, who is going to act? We are almost now in a virtual state. It's not real. I was raised in this country. I lived in this,
an illusion of a state.
I remember in the late 60s, early 70s, whether my friend, my schoolmate was Sunni, Shiite, Derzi, Armenian, Maronite, it didn't make any difference. And maybe the influence of the colonial power was still in the second generation, which was ours, that we continue the traditions bringing from France. Even your jurisprudence, you could have gone to court and quote the precedents of the Court of Paris to be applied here. But today, Syria is the same thing. It's not only the question of Daesh and the power. Even, let's say, now Putin and the Russians move forward and clean up Daesh. What is next Syria? It's not the same Syria. We all know that we have a minority ruling a majority. The majority will not tolerate that anymore. So there are real problems on the ground which go beyond the issue of the ICC and other. A second observation, I would like your comment. You mentioned Latin America. For the last 40 years, I have been traveling to Latin America. And we know that they went through various stages. In the early 80s, it was worse than anywhere else. They were worse than the dictators of the Arab world. What happened that after Pinochet, then in Argentina, Uruguay, all these countries had very harsh dictatorships, horrible human rights issues, which are not yet solved. Still, those who lost their children or their husbands, they are seeking for. No, I'm saying that.
There was the end of the Cold War as well.
They have a monolithic society. They are all in general Catholic, not even Christian, Catholic, practically. And so they don't have these religious differences, but yet they made an evolution from the 80s to the 90s or 2000, except a little bit maybe the corruption of capitalism. They were able to build nations, democratic systems, democratically elected, So what is, and we know that the Latins are not like the Germans, they are not very disciplined, but it happened that they made this curve while our Arab Spring was a disaster. But from the first day when I heard the word Arab Spring, I said, my God, winter is here already.
No, maybe should I, on this point, should I say something?
We'd like to respond. And okay.
Shall we? I'll just make a couple of very quick comments. So starting from the last one, I was thinking of Latin America. That was the end of the Cold War as well, and part of the problem in the Latin America was the Cold War between the communist regimes and the. But I agree that we have the talents and the capacity, but I think we're more divided. No, they were part of the problem was by proxy between the Soviet Union and the US during then. It was part of the Cold War, and most of the revolutions were supported by either or until when the Cold War ended, and then we saw more stability for the region. Probably the difference, though we have to take responsibility, and we take responsibility, at the same time, there is more stake in the region until today, and Syria is an excellent example for this, of how the regional and international actors are making wars by proxy. So probably as if we're in a Cold War again in a time that the region cannot afford it. So just to say that we shouldn't exclude the external factor, I absolutely agree with what you said, Mr. Bej. I think without excluding the international actors' stake in the region, related to oil, related to Israel, related to, we cannot exclude it. It's also when we say people don't want to live with each other. So Lebanon is religious-based. Let's talk about Libya, Amazigh and Tabu. There are other small minorities, but they're the same religions. We're 99% Sunnis. So if we go into whatever, Egypt or Tunisia, so is there any community that doesn't have a minority or multi-minorities? We're not, I don't feel this part of the world, we're different than any human creatures on the planet. We all think the same, we all have the same brains, but I think what we need to fight for, and probably this is an answer for you as well, probably what we need to fight for, instead of thinking what would be best political system, whatever, if it's federal or unitary, can we create political systems that are based on rule of law, on justice, on freedom? It's irrespective, because if we go into the game of every minority self-govern, I'll talk about the Armenian because we're talking about here now. So probably the Bush Hamoud would be 3. No? Like the Christians have fought more than the Christians and the Muslims, if I talk about Lebanon. So just to say, if we'll go into the mindset, but if we create a nation state that is based on justice and rule of law and freedom, we don't need, and Lebanon is a good case, relatively good case, in the sense that we fought, and now we are together. Imagine if we have a better justice, and we have a senior judge would love to hear your voice, your opinion about it. If we have a rule of law, no, I can't shoot you because you're a different ethnicity or religion, and then I'll be in jail, whatever is my religion. But unfortunately, we don't have it. Exactly.
Because when you have that
exactly.
nation and the state, then you're at all. Because the state they gave security and equal rights until
absolutely.
The war. That's why it helped building the state or the nation.
Absolutely. So it's the problem is not us. The problem is how we're making our states weaker because of multiple internal and external factors. A last point, so I don't think division would change anything, because if we go with this mindset, I think literally Bush Hamoud would be 3 states in this case. Exactly, it's quasi-independent now. One problem with Lebanon, I think, that we should learn from is this amnesty law. I think probably if I want to think of one mistake that contributed to what's happening now, is that we gave amnesty for warlords. And probably if we want to learn something from Lebanon, if we want to build nation states post-uprising, there should be amnesty laws, and there should be an international coverage for such laws post-war, irrespective of the actual legal frameworks. Just want to say thank you, AGBU, thank you, Anita, for the invitation. I know we didn't close, but probably I won't speak anymore.
No, I want to. Can we have Professor Ambos react? Okay. Is everyone okay with skipping coffee and continuing the conversation? It's your fault.
I second.
Lean, just to do that, we'll turn to actually, we'll turn the microphone to, because I believe Dr. Ambas would like to have a comment, and then we'll close this session and move immediately to the next one.
Thank you very much. No, just on this Latin American point, I think it's a very important comparison. We say in Latin American research, there are many Latin Americas, so we have to be careful. It's not just one Latin America, so each country has its own history. But what is true is that why do we have this kind of redemocratization and human rights compliance on the continent from the US up to Argentina, down to Argentina? And that has to do with one reason is that the second best human rights system in the world is the Inter-American system. We have an Inter-American Court in San Jose in Costa Rica. We have the Inter-American Commission in Washington. And that is a human rights court, like the European Court of Human Rights. And people go to this court, and this court has heavily influenced the whole process. There's a lot of jurisprudence. Velasquez Rodriguez was the first case, duty to prosecute, no amnesty, Peru case, and so on. And so this, again, there is this international framework is necessary, and that is lacking in the Northern Africa and Southern Africa. You have this African court, but this African court is not so efficient as the Inter-American Court and as a human rights court. And you know that now in the African Union there is also the Malulu Protocol as to the criminal branch, and this must be observed very carefully. What will happen to this? But I think this kind of regional systems of protection of human rights are very efficient if you have really a court which issues binding decisions on the states, and that has influenced very much the situation in Latin America. And also, of course, that you have not this religious diversity, but you have evangelical movements. I mean, it's not just Catholic. You have a very strong, that is Trump, you know. I mean, the support of the base of the Tea Party movement is very strong in Latin America. So we have this other kind of, for us Christians, bad kind of evangelical populist movements which support right-wing politicians. That is a kind of counter-example, but of course it's not comparable with the religious conflicts in this region. But I think really we have to have this mixture of kind of international or regional, better regional frameworks which can help if states subject themselves. I mean, there is an issue of state sovereignty also, I mean, in the region, here in this region, because, you know, for a state to accept that a higher court will judge you, either as a state, a human rights court, say you violated the convention, Germany violated the convention, and then you implement this decision. I mean, Russia and Turkey are part of the Council of Europe system, imagine. And Turkey, for example, did not ever execute persons being part. I mean, they do not apply the death penalty. It's part of, that's a consequence of the European system. And Russia is abiding more or less. I mean, they are not making big structural reforms in the human rights system, yeah, European Court of Human Rights. So that's a very successful system, and also the Inter-American system. And maybe that's another option. I mean, to have a kind of human rights system for the region where you have a regional human rights court which states accept.
There is one in the Arab world, but it's not good enough.
Yeah, exactly.
Well, this session is officially closed, but we're bridging it directly. And I would suggest, first of all, let me thank again Professor Ambas, Dr. Abdussalam, Gilbert Doumit as well, and Lean. Thank you so much for moderating. But I would strongly suggest that if we're going to bridge, if you'd like to stay, please do stay with us so that we can directly move to the next session, the closure. Professor Ambas. Yes, I was suggesting that, to have a round table for the last session, now that we're moving to the next one. Well, I have to say, it was specifically when we were choosing all the parties and civil society activists to join this event. Well, nearly we chose everyone here that spoke throughout the day for a specific reason. And somehow I think now we know why each one was here, covering a different angle. as
Who would you like?
Lean. You know how much I went after you to get you here. So how you at stay on the chair? Of course you may. It's a long haul flight thing. Because unfortunately we can't move this table. I would have wanted to have it rather in a more roundtable discussion. And I would strongly urge to have Dr. Abu Jawde with us, like also. And Nidal, please do intervene. Because as Dr. Ambas was suggesting yesterday, and Dr. Rolf also, was like, you Lebanese know more what you need to do. And as we are doing yesterday, we started this, but this has to be the jumping board of what's next. So I would suggest in the coming 40 minutes, if we can think about, AGBU initiated this, but what's next for us? If we can have it. Mr. Wa'el Khair, as well, we need you to moderate as well on this session, since you are a leading figure in these social civil activities as well, society. Yesterday we had another interesting remark from Professor Ambas and Dr. Hosfold. He was saying, we're Germans, but you're the Lebanese, and you should know more. But I said, definitely we can benchmark some of the successful stories that they have had from their experiences. So please, we would like to have your intrusions as well. Dr. Abu Jawde.
Are we taking a 2-minute break?
Do you want to have a 2-minute break? 2 minutes. Let's have it 2 minutes and then.
Better not.
Maybe more than 2 minutes. Always. Better not. No.
We're just here? Okay. Go ahead, Rabia. Dr. Abu Jawde, Ambas. I mean, let's finish quickly. 40 minutes and we'll wrap it. Yes. Dr. Abu Jawde, let's go. Ralph Hospital. في حدا ما في
ايه
ما في مطرح كأنه
مطرح ما بعرف أنا رأيي everybody moves here بضل في طاولة هوني
I think we need one.
Beautiful. I mean, gender sensitive, so I can't care. You want my bag? هاي لين ولا لإلي؟
هاي لإلي، إذا بدك
I thought it's mine.
ما بعطيك إياها.
ولا طلعت أنا هون هي؟ هيدا أنا بنقول؟
مالي بنعرف عن حالنا إذا
خلص فوق بعض حط.
إيه مالي.
ما ضروا الأسامي هالحياة. إذا بدك ريحي حالك شيليها. خلاص بدي يعني. Fine. That's good.
بعد إنه بدنا نروح جلبال؟ لا يا حبيبي. يلا قوم ما تتخبى.
بعد في جلبال.
It's yours؟ لا دي جلبال لا.
It's my notes يعني خلص.
بدي نكتب أنا وياك.
بس
على تواصل مع حبيب.
وين يمو؟ صار بأوتريشت وانترك نيويورك. صار مع جمعية impunity
أنا بعرفها لا
مع impunity watch.
كنت روح أقضي الويك إند بيترخت.
عن جد؟
بيترخت عندهم مركز كتير محترم اسمه السام.
إيه.
كان عندهم بروفيسور very good in European law كان يحكي هو ليو زفاج.
شو هو؟
ليو زفاج.
No.
He was a member عندهم وبيضلوا يعني he knows the system كان يعلم European human rights system.
إيه هو ما صار له سنة بس ما قدرنا ولا مرة هلين هلا. إيه مبسوط.
أخذ الجنسية.
أخذ الجنسية خلص ما هي
هلأنا فيها.
مع إنه هو متعنق كثير بنيويورك. بس الصبح ما إجا الشغل ما كان.
New York is a place you love it or you hate it.
لا أنا I love it.
ما اجينا مجال نحكي ترانشنال جاستس.
ترانشنال جاستس
لا كثير قليل.
ريكونسيليشن.
بس وقت بنحكي عن
حتى هون بالبريفنشن ما قدرنا نحكي كمان. يعني احكي لنا شوي بلا لانه شيلبير شوي بلا شيلبير لانه it was about prevention. It was about analyzing the context of how to have the impact.
It's the boss. Truth and reconciliation.
من بعد الهيدا بس that plays the role of breaking the cycles يعني.
Is it your first time in Beirut? Yeah. How long have you been here?
No, only on yesterday I arrived.
You're staying for a few days? Yeah, I'm Chinese tomorrow.
بدي ابعث له صوره لبيروت. معلش
Did you enjoy it? Is it nice, Judge? Yeah, talk to him.
Dr. Ralph. Nidal, we were struggling when we were thinking if it's going to be a round table. It's nearly a round table. I leave the table, I leave the place for you. Lead us. Take the best out of the brainstorming session as a jumping platform. Where do we go from here?
Yeah, I'm honored to moderate the last session. And in a sense, it should be the most crucial session of all what we pass through. It's what's next. Now, so the theme is what's next? And I open the floor to my colleagues. Who would like to start?
Are we talking about what's next in the Lebanese context?
In general.
For the MENA context?
No, the MENA,
the conference.
MENA region.
In the MENA.
If we follow the schedule, it should be what's next for the MENA region.
What can we do? I mean, we're all here and we all see that in all nations, in all countries. It's true, some part of a judicial, some part of legal, but there's a lot on the shoulder of the civil societies to instigate things, to create movements. Like probably now we should be as well, it's a moment to salute the ladies movement, the CAFA. Over the past 2 days, they like abolished the law about like the old law.
We audience, for instance, would like to have like a vision. Hope today you are professionals and you are practical public. Tell the people what message to convey. And if we want to say, we as AGBU, at the end of this conference, we organized this conference after analyzing how much we can analyze in one day. I think, as a matter of fact, it was excellent. First of all, I want to congratulate you all. I never realized that in one day we can cover so many topics. But at the end, what is the conclusion and what we should say if we had to say this was the conclusion of this gathering?
Well, if I may propose the following. Now we live in part of the world that's riddled with conflicts. And in fact, there's no place on earth where genocide is abundant as it is the Middle East. In any definition of genocide, you find that the Middle East suffers from certain minorities being exterminated. In the full definition of the genocide, whatever agreement or declaration or convention. So this is my first point. Now, should this have happened, say, 100 years ago, it will not be as now. Because now we have a very, relatively speaking, an efficient instrument to confront and challenge and hopefully to deflate this tendency. which is human rights in all its forms. The Universal Declaration of Human Rights and also the humanitarian law and the ICC, etc., etc., etc. So there is a problem and there is a solution. This is my second point. My third point, we should be careful not to be carried into excessive optimism. Now, although we have the remedy, but the remedy is very slow and the remedy is very limited. But it's not an illusion, it's not a fallacy, it's a reality. My fourth point, how to reactivate this minute reality. This will be the practical part. Now, if we are going to see it in terms of the MENA region, Middle East, North Africa, then this will make the work far more complicated, difficult, and even impossible. Imagine what would you have in common between the Saudi society and the Lebanese society, not to mention certain fragments of the Lebanese society. So the more we widen the thing, the more difficult it will be. I'm afraid ultimately we have to settle down on particular countries, at least as a starting point, if we want to be practical. So these are my 5 points that I propose to be the framework for our discussion, but of course, add to them, subtract from them. I'm not infallible. Thank you.
Just a few quick comments. We often give Lebanon as an example of what not to do after a major conflict that has dragged on 15 years, basically starting with the amnesty law, not prosecuting persons who are responsible, not seeking the truth, especially with regards to the fate of the thousands of people who still remain disappeared today, even though we have all of the technical expertise and knowledge and tools, even with the draft law that sits in Parliament today, to resolve and to lessen the suffering of the families. We haven't done any of that, and today, 40 years later, we can see the consequences of not addressing the conflict in Lebanon. And it's not just about finding justice for the victims or the families of the victims. It's a whole system, it's a whole society that's created out of not addressing the reality that led to the war, that led to the conflict and what happened during the war. Today in Syria, what's going on, when you talk about Daesh, Daesh today is a foreign, most of the fighters come from Europe, but the next generation will be a Syrian Daesh because of the way that the atrocities that are taking place today are being addressed or not addressed. It is a very real issue. I think when we're thinking about prevention of genocide, again, in a very loose definition of genocide, of course, we're just talking about institutional state or not state, but at a very large scale of civilians killed. The fact that there is no justice by the international system, because the national system is, of course, party to these, to the perpetration of these crimes, will affect the future of these cycles of violence. I mean, there are so many ways. Latin America, we mentioned it today. It's about a political context that changes. It's about the judiciary that takes its own responsibilities, that takes a decision. For example, in Argentina, 30 years after, it is the judiciary that took the decision that the amnesty was against the constitution and that allowed for the prosecution. So there are certain, and it does boil down sometimes to the pressure that civil society puts. It does boil down to certain very bold individuals who can take these kinds of decisions at their own risk. And it comes with a whole process. I mean, in Latin America, they've worked a lot on all these memorials so that future generations would not forget what happened and what led to the commission of these acts. This is something that, as a state in Lebanon, we have failed to do, but as civil society, it is still a matter that keeps being raised despite the passing of such a long time. And I think the role of civil society in all of these different contexts in the MENA is to continue doing what we do, which is basically documenting these crimes as they happen, documenting these indicators that we've talked about, these kinds of messages and incitement to hatred and incitement to crime that can legitimize the commission of crimes. It is our role to be questioning and to be continuing to build pressure, to continue to send the message that it is the role and the responsibility of the state, it is the responsibility of the judiciary to be addressing these crimes, to be legislating, to be creating laws that can prevent these crimes from happening, from holding these the persons who commit them accountable. So it's, I think, yeah, a civil society is really about building pressure, it's about exposing the events as they happen, it's about doing the documentation, and it's about giving the voice, of course, and being a platform for the people who can't actually reach these kinds of platforms where these discussions are taking place. And by that I mean the people, the victims of these crimes, the persons who are suffering from these crimes, their families. Our role as civil society is to be a loudspeaker to their suffering and to their perspective, to make sure that, as much as we can, to make sure that it's part of the political process of the political decision makers. We have to raise the costs, we have to make it more difficult for politicians to ignore the suffering and the perspectives and the rights and the needs of these people.
Excuse me, I want to mention something as long as we are approaching, even entering the practical things. In our foundation, we embarked on something that turned out to be very positive. We thought if we are going to wait for the legislators to change the laws in Lebanon, this is almost an impossible task because of so many reasons. I'm not going to enter into them, we all know them. Now, what will be the way out? We thought if we could encourage some justices, jurists, to base their rulings not on positive law, but on the natural law, on the principle of justice. And this worked wonders. There was a kind of, excuse me to use this term in an Armenian milieu, there were some young Turks among these judges who were very thrilled by the idea. And they passed very courageous court rulings, not based on the positive law, but on the principle of justice, on the natural law. In the morning, the professors from Germany mentioned this. Now, this is a shortcut to reform. I would suggest that we bear this in mind and we apply it.
Going by turn.
Turn? I can.
I don't know.
Okay, that's fine. That's fine.
Otherwise, I would have waited.
Okay. The challenge for us, the challenge is not only to celebrate the genocide, commemorate the genocides that happened, and celebrate the day for the dignity of the victims of genocide. In fact, on a personal level, I think sometimes this could be damaging. Because when we celebrate things too much and we don't do anything, we become numb and we take it as a celebratory event. It's like New Year's Eve. So something I have my reservations on. I think what needs to be done is as simple as it gets, how to improve protection. What struck me is that the convention entered into force around 1951, so 65 years. Number of countries in the region that ratified it is not small. Yet I couldn't find one piece of law that criminalizes genocide. Sometimes it is lack of will, and at the same time, I agree with Professor Wael on some things in the terms of natural law. But natural law, I don't want to be a party pooper. But for a criminalization, for criminalization, a conduct, it will not fly. We need to amend the penal codes. It can work for other human rights issues, definitely, but just for criminalization at such a level, especially that such a crime requires also amending procedural laws in a number of aspects. I think not to always throw the ball in the state's court. I think sometimes there is no political will, but sometimes there is no pressure. First of all, the Genocide Convention is one of the forgotten conventions, in my opinion, after I worked in the region now more than 12 years. So I'm not that young, I look, I don't know. But I rarely, even the human rights community focused a lot on its incorporation. Sometimes it's the ICRC always, and I thank the ICRC for their work on the genocide, on the Geneva Conventions. And usually it's partly the ICRC helping. Office of High Commissioner, among other, working on the human rights instruments. It is something that is falling in between, and I feel that's not taking the proper care from all of us. Although it is an element of protection that exceeds its importance than any other human right or IHL instrument, in my opinion. So I think it needs a strategy, at least, to work on a number of places to provide laws. Sometimes you think it is mission impossible, sometimes you don't. Criminalization of torture for Lebanon, I thought personally it will never fly to allow to criminalize torture and to try officers before civil court. Now there is a draft of law that passed 2 committees. I don't know if it will pass more. We worked on it as Office of High Commissioner along with the Human Rights Parliamentary Committee. I don't know the political will because it's very sensitive, very sensitive. We know for a fact it's very sensitive. And at the same time, it's moving. So sometimes, let's see, not only Lebanon, don't forget other places can be suitable. Iraq is a place to put pressure. The Iraqis will be probably happy now to follow. Because it will be a pity if ISIS will not be prosecuted for genocide. It will be a missed opportunity. You know, the Allies, when they were negotiating the idea of holding accountable the Nazi perpetrators, one of the debates was no need for a court. Let's kill them and finish it up. After all, they are a bunch of criminals. I was thinking that if this would happen, we would have lost a lot in terms of rule of law. Nuremberg can be criticized for selective justice, victorious justice. But at the same time, thanks to Nuremberg, that we had the basic pillars of this law, that with all its problems, we cannot afford losing it. So on the legislative level, I think there is a lot of work to be done. Okay, and this includes us as a UN, civil society, duty bearers, all together. Again, I think there is more work can be done. On the judicial system level, more sensitization there be there. I know that many judges, their heart is in the right place, but trust me, and I don't want to be arrogant, many people don't know what exactly genocide crime is in terms of its element. I was surprised years ago, I'm not anymore. And this includes the domestic element and the international element. Now, Kay talked about the ICC. Why? ICC is definitely important, and we all supported the coalition in the region. But at the same time, it needs more effort to explain the role of the ICC. The ICC is misunderstood in this part of the world, and sometimes the prosecutorial policy of the ICC did not help the ICC. But it doesn't mean that the ICC is not very important, and the ICC is a court that respects rule of law and is in need. I recall, if you all remember, Yemen. Yemen it's Jordan that is a state party, it's Tunisia that is a state party, it's the Comoros Island state party, and there is one, I think, Mauritania. Anyway, there's 4 Arab countries who are in the ICC. The latest was Tunisia, which is a great step. And Yemen was one country that was very close to ratification. They ratified at the first chamber. It was in the second chamber of the parliament where they realized that it could be a Trojan horse, in their opinion, which is something over-exaggerated completely because of the principle of complementarity. ICC will do nothing if you do your job. Yeah? What is so satirical about the issue of Yemen is Saleh and who practically blocked at the end the ratification. Now, after the allies and some accusation of the allies in Yemen, it's a number of NGOs, including close to Saleh, are calling the ICC to try to do something about the crimes that are taking place. So there is a need for rule of law, but not selective. When it helps us politically, we need it. When it doesn't help us, we don't need it. So I think this is worth more explanation, more sensitization, and not only talking to the converted. This is my personal opinion. We always talk to the same people we talk to, but they are already on the same line. Let's talk to the difficult people, people who are skeptical about everything. Okay? Sometimes there are valid skepticism, but sometimes it's merely misunderstandings. Used sometimes, unfortunately. The third point we would focus on, I think, prevention. Prevention is as important as punishment and deterrence, because prevention will save the lives of thousands. So, in that regard, I would highlight also, again, genocide is a crime that usually, implicitly and explicitly, starts with hate crimes. It is a crime that starts with a stigma, with stereotype, with generalization against a group. It starts with hate. It does not happen without hate. It needs, correct me if I'm wrong, but it does not happen without hate. And this is why the drafters included incitement, direct and public incitement to genocide as a standalone crime. So I would think that focusing on incitement to genocide and incitement to hatred and the Rabat plan of action is not only a rhetoric and just another UN instrument to keep on carrying it and moving around. I think, and we think it's very important, because the region now and the level of incitement to hatred is a truly an element of worry and element of concern at the highest level. Also, the element of PVE, preventing violent extremism, is another issue. The root causes of why there is radicalization and there is this stigma vis-a-vis other religious groups and other, I think this can be put in a plan. I think the civil society is playing an important role, needs more. I think media is a new and important, not always, it's an old, but really need to be approached, need to be targeted in a different manner. Even among us, we talk UN and others, we talk generic aspects, but we don't talk in reality about specific challenges. I think among that and rule of law for everybody is an element through this process that can help to put a roadmap on how to move forward and to make this day meaningful, not just a celebration and that's it. Thank you.
I don't know what to add to this, but I can say not only genocide, I would like really to include other human rights violations, gross violations, and not in any strategy or vision to include also other, mass displacement, massacres, killing, disappearances, and so on. I would also say that we need to think about a strategy in terms of a multidisciplinary approach, not only but have different disciplines and also a multi-level also strategy where we target civil society, general public, the media, through also education, culture. These are very important, means to be able to really reach the general public. You were saying that this is important. We had an experience, Lynn was involved in experience in creating a consortium to work on a policy recommendations about transitional justice in Lebanon, addressing truth, memory, criminal justice, reparation, institutional reform. And we have suggested in these policies we asked the Lebanese authorities, mainly the parliament, to ratify the Rome Institute, the statute, sorry. And then also include in the constitutions an article about not granting amnesties, general amnesties or special amnesties for gross human rights violations, crimes against humanity, genocide, and so on. So we have proposed a set of recommendations, practical, concrete. I think it would be good to be able to build on that and continue the work as a platform. I think it's important to be able to work on multiple levels, mainly, and also think about alternatives. I mean, in terms of there is the ICC, but what can be done? We talked about. I mean, Mr. Khair talked about also other issues. So, capacity building also can be important. Awareness, education, culture. So, I think this is important to be able to include in any strategy.
Sorry, I don't want to confiscate the discussion, but just to correct or to add one thing, the fifth country joined the Rome Statute from the Arab region is Palestine.
Yeah.
I think now that chocolate hit the fan in the region.
Oh, chocolate, I like it.
I think it's probably conceptually, I think it's about time to rethink our existence. I'm within a whole new social contract in the region, rethinking the concept of state, our relation with the state, whose relation with the state. I don't think we can go back to before 2011 and 2010. So I think now that we're in that situation, and I'll push my thing a little bit further because we're in academia, so I'm detached from reality. In my daily life, it's about dealing with reality. So I'm allowing myself. The whole world order is in trouble. There is a lot of literature today about the postmodern state. The states we know are falling apart, starting in the UK to the US, and in France, everywhere on the planet. We're rethinking if governments work. This world order that we're looking at, that includes the ICC and the UN and the World Bank, I think we live in a world, they might all be at question. And if we look at how much trust, so in my work, I was in Kenya and Nepal, and I teach in the US, I know no one who trusts the world order. Except people who are benefiting. So maybe. Because you're responsible of the world order. So maybe we're not going to be able to change the world order, but probably because we're in a region where chocolate hit the fan, why not taking the time with all intellectuals, all stakeholders to rethink our existence as a region, as countries, as cultures, as citizens, our relation with the state? I think there is room for innovation in the way we want to recreate ourselves. That's conceptually. If I'll go practically, I think in war countries, I think before anything we do, so that we don't lose resources, because probably I've tried it and it was tough. I think before doing anything, we need to make sure that geopolitically we have a deal. In Syria and Yemen, I think any investment we do now, other than humanitarian, if there isn't a geopolitical deal, and probably what we need to do, and I think there is enough stakeholders in the room who might have influence, is to strike a geopolitical deal before doing anything. And then we know what we should do. We know that we need to go for a truth and reconciliation process, a transitional justice process, a national dialogue between all stakeholders. We know that this should be done so that we build nations again. For countries like ours that are weak states or pseudo-autocracies, we want to build a nation. But every time we want to build a nation, we know that justice is core, and joining the ICC might help us preempt. But the first time I gave a lecture at UB, I think it was 2001, 2. I was thin, I was young, I had black hair. At 20 years after, I'm still saying the same. I'm tired. Sometimes I'm bored of myself. Just answering. I think we've been saying, and every time, every conference, I was moderating a panel in the morning about public health. It always ends with, there is no political will. And then we all go home and say, we know what should happen. There is no political will. I think for countries like ours, I think it's about time for civil society to produce a political society so that political will be ensured. Whoever is sitting on the table who can sign should be equipped to sign. I think for Lebanon, I think my generation has done enough. I think I've been in conversation related to Lebanon ratifying the ICC since 2001, 2002. Probably I met Carmen during then. No, it wasn't through this. Okay. So you see, I even lost my memory since then. I think my generation had enough. We did all studies, we did all strategies. I have 60 laws in my laptop.
from access to information law to the new standards for education. I've been involved in advisory and consulting and advocating. We've done enough. It's about time we organize and become a serious political competition and say, yes, if I am in power, I will ratify the ICC. If I am in power, I'm going to make sure to reform the judiciary, not alone, not as an individual, as an organized new elite for the country. It can happen in Tunisia, it can happen in Jordan, it can happen in everywhere. Thank you. No, because I tried everything. Exactly, I know. Thank you.
Well, I think it's very difficult for a foreigner to give recommendations. I mean, I can only hope that this kind of pressure, which Nida referred to, will be built. I mean, of course, here everything depends on pressure to implement 5 points I would like to have implemented. I would say the same in Colombia, so it's not a Lebanon thing. It's a thing where I think that justice would be improved in this state. And the first is, of course, ratify ICC statute. Second, strengthen civil society even more. Build a coalition of civil society groups. I'm not sure how far there. There's always this problem with NGOs and civil society that there is a lot of competition and some want to be more protagonist than others. But in a situation where it is difficult to have political gains or political results, you must have a coalition. That's why you had an NGO coalition for the ICC with very, very diverse NGOs. So strengthen civil society means also for the civil society organization to have an internal mechanism, round table. I'm not sure if this exists between the civil society groups, yeah, where all groups can participate and then really work as one block, at kind of coalition, you know. Do justice at a local level. I think one experience, for example, in countries which are in Asian countries, China, Japan, Korea. China, I would even name here because it's one party, but it's quite efficient on the level of no corruption, for example. Police corruption does not exist, basically. They have really this under control. People are very, in the West, sometimes very much criticize China for the human rights record, but that's a very intellectual criticism because, for me, I think because the people, normal people live in the street, for example. If you can trust police, and no police corruption is a big deal. I mean, no police corruption is a big advantage. We have no police corruption. And, this justice at the local level, in this sense that you have a civil servant which you can trust and which actually does what he should do, help you. I mean, he's there to help you, not to molest you and not to get money from you. A truth commission, if you have all this, what I learned here, that you talk about this amnesty, you have this amnesty, but there is not any information, there is not even a truth commission. I mean, not even a kind of mechanisms where you have established the truth, and we would normally say nowadays in transitional justice or these processes that the minimum is truth. So if people are not ready to take responsibility, criminal responsibility, and you have no system to prosecute people, at least have a kind of minor thing, which is a truth commission, where you can establish what happened and assign responsibilities. Independent truth commission personalities and so on. And the last thing is judicial training, and that brings me to this idea of what can, judges are a very important actor in each system, you like it or not, and that's even a problem in systems where judges are bad judges and are political judges. But they are important, judges are very important, and therefore one has to incorporate judges. So one has to get into contact with them and try to win them over. And judicial training can have different forms. I mean, one is this, what you do a lot in transitional justice, international criminal law, you tell them what is genocide, for example, or what is crime against humanity, how can you apply this, and that you please, could you please look at the ICC or in international case law and take this into account. If your constitutional system allows it, like in Colombia you have it, in some systems you have kind of very open constitutional system, you can apply directly ICC statute, or you can directly interpret norms, national norms with international law. That's a question of national system, what allows us in the Lebanese system. But in any case, to have judges which are
which are aware of these human rights obligations and these international obligations, and that they may apply this law. Not so much in natural law. I mean, I didn't say this. Maybe I didn't express myself clearly. I mean, I'm very much in this sense of strict criminal law. I think it's also protection, because today these judges which apply your natural law tomorrow apply it against you. The Nazis applied natural law, don't forget it. Gesundes Volksempfinden, that's natural. More than, it's like, it's a concept which is not defined, and Freisler and the Volksgerichtshof killed people by saying that was what you did. Yeah, but it's very one of the consequences of one of the consequences of the anti-natural law movement in Germany was exactly the Nazi application of general principles which have not been written down in the you see. So positivism. So this idea of positivism, which is actually a French idea from La Bouche de la Loi, this very positivist law has also protective function, yeah, because if judges can only apply what is in the law, the democratically legitimate legislator defines this, judges cannot be arbitrary, yes, and arbitrariness of judges is a big risk, especially in authoritarian states. We can see it in Turkey right now, and using criminal law as an arm. So then, therefore, in my experience, and generally, I think we would say we have to have strict criminal law provisions, which may be interpreted because it's normative. You have normative terms, and you can interpret it, and you should not be too positivist, and you could certainly invoke human rights, and you can invoke international criminal law, but you cannot just take it from somewhere outside your code, at least not in a codified system like the Lebanese system, which is very much influenced by French law, I understand. So it's not like a customary law system. This could backfire, you know, that's dangerous. But I think one should integrate judges in the sense of judicial training. What we did a lot, also GITS, for example, in Latin America, is this ICL training. So you train judges what are international crimes, the obligations. If you tell a judge that you are obliged, you are a state representative. I mean, that's the state of Lebanon, but you are a judge of the state of Lebanon. You are not acting as a private in your private capacity. You are acting as a judge. And as a judge or as a prosecutor, more important, or juge d'instruction, you must prosecute these crimes. That's your obligation. And if you don't do it, you violate, as a representative of the state, this obligation. So one can take them at this honor, you know. I mean, you take them at the honor of a judge or of a prosecutor to say that's an obligation, and you have to do it. So in this sense, I think one should, prosecutors and judges, and more integrate in this whole justice area. But these are 5 points. They all depend on the strength of civil society, I think. And for example, I think this seminar as such was very important. I mean, it's you know, you can say without conclusions, it's interesting and important to have an exchange, and this is part of this didactic exercise education. But for an organization like AGBU, perhaps it would be good to have a declaration or some paper. I mean, something must have been written. You must publish declaration and publish some of the recommendations, and then that could then be a trigger for future events, which in themselves have their legitimacy, I think, because you bring people together and you then have perhaps a triggering effect. It's all. Or just a declaration. I mean, what we do a lot, I have also an organization in Göttingen, an academic organization with Latin America, and we do declarations because you can use Facebook and stuff, and would not do a book. I mean, it's much. I think a declaration, for example, what we discuss now, you want that we give you recommendations. So someone must be rapporteur and must write this down and summarize, and then you have a declaration, the points you made, and then you have 10 points maybe. And this is a declaration of the seminar, of all the institutions. Perhaps the United Nations must think about it, but at least the NGO, the civil society can have it as a declaration, and this declaration is then easily can be divulgated via Facebook and so on. So just one page. People don't read, you know, don't underestimate this. One should be very short, but then a clear message, and then a kind of future think that is the first event, and we will continue if this is your purpose. Yes, then I think that would be very useful, and then we can have a follow-up and maybe look if there is an advance and invite specifically. I do not know who is here, for example. That's important. Who did you actually target? Who is the audience? Who are you getting at? I mean, are judges here? I talked to one judge, which I know from The Hague, but how many judges are in this room, for example, or have been? That's important. But that is all your work. I mean, and then you can broaden your kind of audience, and I think that's a very, very hard work. It's slowly, but I think it's a good approach. Okay, thank you. Thank you very much. For me, it was a great experience anyway, so if this helps.
Thanks.
Yes, okay. Thank you, Kai. So, well, I am not a lawyer, probably the only one on the audience who is not engaged in that profession. So, and this is, of course, also a very wide field, and I feel not competent to give any recommendations in a region and in concerning problems which I have not studied enough. So let me just maybe make some remarks or some impressions. I think we should not forget that I mean all the things we've been talking about, and I've learned a lot in this very tense day. We should not forget that all this depends, of course, of a process we have not so much influence on, which is happening around us, which touches us in Europe and touches you much more here, and which I would call the violent birth of a new world order. So it's I mean I don't have to explain this to you. You know what I mean. But there are powers involved which are much stronger than any NGO or any small country like Lebanon. I don't. Maybe you are lucky and have the chance, like small countries like Switzerland or Sweden during the Second World War had the chance to find your way, so to say, to be more or less untouched by this. You will never be in a situation that you're not touched by this, but maybe you can have the chance to develop yourself in your own environment and discuss all these important questions we have been discussing today concerning your own country. But what happens across the border, probably you don't know. I mean, you cannot make any assumptions about this and how will the division of power between Iran, Saudi Arabia, and Russia, and what's the role of the United States in the future and also of Europe and so on. We cannot say very much about at the moment. So maybe, and you must excuse me if I'm as a foreigner who has not really a deep knowledge about your country, say something wrong, but maybe you have the chance to give an example also for the future of your surrounding countries. If you manage to develop something like a dialogue in your own country. And that, in my opinion, does not only concern questions of whether you join the ICC or not. I mean, it's of course important questions, but also if you succeed in getting into a dialogue where you come to discuss your different narratives about your own history and your contemporary situation and so on. And I mean, things like this can happen. For example, we are part of a workshop which is called Workshops on Armenian and Turkish Scholarship, which exists since about 15 years, and which is Armenian and Turkish historians and historians which are neither Armenian nor Turkish, but come from other countries, and debating about the Armenian genocide on an academic level. We have done this last year very successfully in Istanbul, for example, which gets a bit more complicated at the moment. And we do this next year, continue to do this in Potsdam, where we have our institute. And I think all these small steps, of course, are very important, but I think we must be aware of of what you depend on, factors which you don't have so much influence on. And I will stop here before I get into things which are necessarily more speculative than I can. Okay.
I'm really thankful to all of you today, and I think we're nearly towards the end of our last session, and probably, if I may say, the most important part. And just answering Professor Ambus, yes, the lady over there, she's been here just to precisely do what you had suggested. She's the note taker, and we will be coming up with declarations, and to those who like to read, we will have a publication. And as nearing to the end, and answering as well to whom did we invite, and I'm very thankful to our collaborators who, I like the Arabic saying, إيد وحدة ما بتزقف, and we really were many hands. وزقفنا, I think. Everybody worked very hard from all our collaborators, and everybody gave us a very important input so that we have today. As I said, as Afra mentioned, like we tried to cover it from different angles. And now we have food for thought. I think we have food for work coming afterwards. And we made a point, and I would thank our collaborators' advice. We wanted to, not to preach to the choir, we wanted to have these open discussions. At least we start, instigating it, as our president initiated this, and we're thankful to that. But moving forward, to whom are we want to talk? We want to talk to the legal departments, to the justice. We had judges, we had lawyers, academicians, politicians, diplomats, and these were mainly our targets today, and of course, to the audience at large. Moving forward, probably we'll need to do more of this, and again, we will be needing each one of you moving forward to touch about maybe do some important changes in the fabric of our society. And now I would like to invite our president, Mr. Berse Trakian, for the closing remarks. Not trusting.
Well, as the French say, toutes les bonnes choses ont une fin. All good things have an end. But frankly, I feel such a rewarding experience. My wife and I came specially for this event. Tomorrow morning we'll be flying back to New York because it is a first step for our organization, because we thought that as the largest Armenian organization in the world, after the centennial, just to recapitulate where we started, there is no doubt that we will pursue our rights for justice to the Armenian cause. But after 100 years, thank God, imagine that we're an organization. 50 years ago, we wouldn't have thought or hoped that we'll be sitting here in the hall of the American University of Beirut, having with us such partners and sponsors, and we would hold such a magnificent tour of events. Now that the Armenian community worldwide, after 100 years, is coming out of the genocide with a victory of survival, of a victory that we are here, and with the goodwill, it's our turn to really, as part of the international community, to bring our part of the solution, especially that about 30% of our population live in Armenia, and 70% live all around the world. It's on one hand, it's a little bit of a tragedy, but at the same time, it's a big wealth. And what we are trying now on the occasion of the 110th anniversary of the Armenian Benevolent Union, we adopted the slogan that we are now going to have global Armenians, one nation with its diaspora, with the country, and with the church, because the church is an inseparable asset of our nation. Because we believe that if every community continues working in its own limited geographical area, within 5, 10, or 15 years, we will not find Armenians anymore in the diaspora. So we need to think as one global nation, and as one global nation, we can bring our contribution to the international community. And this experience, we think that this organization with about its branches in 31 or 32 countries, in 90 or 100 cities, we are engaged in this process. It's our policy that for after 100 years, 101 years, we want to be part and bring our contribution because of our global presence. So we are committed to it. We thank you, and you think your generation has done already. Imagine my generation. In 1970, in your university, I was president of student council, and I believed, and we were in the streets, we believed that we were making a new Lebanon, and frankly, before 75, we were building a new Lebanon. But I don't lose hope, because nothing is permanent in life. Who would have thought that the Soviet Union would collapse? How many people can dare saying that they thought that they would? So there is nothing permanent. After World War II, we had the new world order with the United Nations in San Francisco. Unfortunately, after the collapse of the Soviet Union, we had a monolithic world order, which was a big mistake, most probably. Hopefully, with the new era, we are going to have a new world order, I promise you, after January 20. I don't know whether it will be good or bad. God help us, but still, we have to hope. And together, I hope we'll see you again. You have been so instrumental and so inspiring, each one of you. And I would like to all those who helped us organize this event, especially within the AGBU. And I would like to really mention two individuals, Mireille Khanamiria, and a big round of applause. And Anita Libyar for her talents of organizing talents, and I discovered that she has more every day. Every time that we have an event, we discover more talents. So let's see what surprises she reserved for our next event. So hopefully we'll see you next year, and we have to remain in touch. And one thing, you have to do something. You have to raise your voice much more, and definitely, even in Armenia, we're doing it. Civil society is, in my opinion, the main answer. Because the power of the people, nobody can stop the power of the people, but the people, because I was telling our friend that all the problems that we heard about for the last years is caused by few people out of billions of population. Because we always say the silent majority, we have to motivate the silent majority to raise its voice, and I'm confident that we'll raise and we'll succeed, hopefully before that. But
we're going to bring you back.
Of course, we can't thank you enough, but just a small token of appreciation. We would like to start with the organizations and institutions who collaborated with us for this wonderful day. I would start with the director of OHCHR, Dr. Abdussalam. Our next collaborator with us, Issam Fares Institute, and I think Sareen will be receiving it on behalf of Dr. Mitri. Foundation of Human and Humanitarian Rights, Mr. Wa'el Khair. Wa'el, you've been instrumental in networking us. Thank you very much. And we didn't know that almost everybody knew you. Thank you.
Kept hearing your name almost day in, day out. Thank you very much.
Our next institute, Lepsius House, Potsdam from Germany. Thank you, Dr. Ralph. And Mrs. Mireille Khanamirian. It's not an institute of... Mrs. Mireille Khanamirian, thank you very much again for networking. Dr. Abdessalam, as an individual, for your personal participation. Dr. Nidal Jordi, thank you very much. I have to say you were the most difficult to be reached, but like in the past days, you've been quite reached for different reasons. Thank you. Mr. Wa'el Khair, we're troubling you again. Wa'el, this is for your personal contribution. That was for the institute. Dr. Ralph Hosfeld, this is for your personal contribution. We'll bring it to you. Professor Ambas, thank you very much for flying in all the way for today, and for Mr. Jordi for introducing him. Thank you. I'm now proceeding in not in particular order. Mr. Gilbert Doumet, thank you. Dr. Abu Jawdi, thank you very much for your valuable contribution.
That's why she's so close to the...
Mrs. Lee Malouf. After all the calls and stalkings, thank you for making it today. Much appreciated.